like I said, my dad, my grandfather were from Germany. They did not speak or read write English. They did never read a book in their lifetime. These men can hold themselves to court. That's how this country was established, because people were coming over from Portugal, Siberia. They would come from Russia. They were coming over. They were coming from all over the planet. So we did not have a homogeneous society like England did, where it was an English common law. We had to learn to adapt to many different customs and people who had their own beliefs, and we couldn't say your beliefs are no longer good. Or when this country was established in, we would say 1783, when the Constitution was, whatever, we already existed, say 1800. We already existed. This country, this nation, what we call the United States, existed for 300 years prior to the Constitution. So people forget that we had people living here in 1500, 1600, 1700. So when the Constitution came around in 1800, that did not negate the fact that there was customs of the people who already inhabited this land that still stood true. The Constitution didn't wipe out all those people's customs, beliefs, or practices and said, no, you will only have one set of beliefs. Like what's happened over in England. You will only have one church. It will only be the Church of England. And if anybody dares to do anything other than what the Church of England says, off with your head. No, in this country they said, whatever you people believed in, God bless you, just keep going at it. There's 516 different religions in this country, 10,000, 1,200 different customs and beliefs. God bless you. Do whatever the hell makes you happy. Just remember the golden rule, don't hurt anybody else while you're doing it. Don't cross into one society and hurt another society. That's all. If you people want to hurt each other within your own society, go for it. It's like the legal society. If they're going to do whatever they want to do, that's fine. Don't cross into the common law society, our common law, and think you're going to bring your legal society into our society and cause us harm. You're not going to do it. We're not subscribing to your beliefs. We're not held under your codes. We're not going to appear in court as a pro se or a temporary attorney. We're not going to appear with an attorney so you could enforce your legal societal beliefs onto us. We're not going to do it. We have the right not to believe what you people believe. We have the right to have our own separate beliefs. Even with the only ones on the planet who believe this, we have the right to do this. And it drives them totally insane when you realize what nation, what form of nation that we have over here.
What I found here a couple of weeks ago, I was in a used bookstore, and I found a 1949 Centennial legislative history booklet. And in this legislative history booklet of California, it was talking about the common law. And it stated specifically in there that this nation and the founding fathers specifically adopted the common law because it tends to protect the rights of the individual people, and that the Roman civil law tends to protect the rights of the prince, or in this case, the state. And so, looking into this, the California Civil Code wasn't adopted until 1872. In 1967, the state adopted the Uniform Commercial Code. In 2007, they married the Uniform Commercial Code into the Civil Code. So in reality, the Civil Code goes back to Rome, goes back to the Code of Hammurabi. In reality, the Civil Code was always the Uniform Commercial Code, and they've just sort of made it official. What I find funny, go ahead.
Okay, sorry about that. Well, I was going to say, let me explain this real quick to you folks. What this man is saying with it, like you folks have heard of like the Gambino crime family or the Cosa Nostra crime, whatever crime families. Okay, Rome, the word citizen just means a member of a family. It's civis, C-I-V-I-S, just means member of a family. So it was a great honor way back when, during the Roman Empire, say, I'm a Roman citizen. So you had a certain status, but then you also had a hierarchy. There was an emperor, so there was a senate, and then you were down somewhere on a food chain. So what's going on with being a citizen is that if you're saying that you're a citizen of the Lentz family, and my name is Karl Lentz, well, then I'm the dad, but I have certain duties and obligations to my children. So becoming a citizen, even though I'm the dad, I don't have rights. I have duties, obligations, and responsibilities to other citizens within my family, or the Gambino crime family that you always see them movies, the mob bosses at the top, and then there's henchmen and all these whatever guys at the bottom. It's the same belief about a Roman, hierarchy or citizen status. That's what's going on. So when this man, Mr. Hailstone's talking about, well, Mr. Hailstone, what's your first name? Do you mind if we?
Oh, my name's Ben. Okay,
this is Ben. So I know you're a good kid, and I really like. I don't know if you're young, but you sound like a real good kid. And you talk good, and that's basically what the codes are. And the common law is basically just like I say to folks, the easiest way for me to describe it is like Gilligan's Island. They could hold a trial on Gilligan's Island, and they did. They had a funny episode, where the monkey was like the judge, whatever. And everybody was trying to convince Gilligan because he was the seventh person out of seven survivors or whatever. And the common law is basically what is ever common to those folks, where they've established their rules. Like, it doesn't matter that Mr. Howell is a rich millionaire, and he might have been a senator in the United States. Now, when they're in this jurisdiction, under this territory, in this jurisdiction, he's still going to wash the dishes. He's not going to be able to use status because now it's the common law of the people. If you want to eat, you're all going to pitch in and help. So he can't say he's the king anymore, or he's the prince, or he's some special status. So that's what I'm just trying to explain to the people, what you were going off on the codes like that. And some people might not understand to me, but I make it as simple as I can about the codes. And I know you're doing the California codes and how everything merged, like equity merged with a common law. But a lot of people have a misconstrued belief of why equity merged with common law. Now, Ben, what do you believe that you were told why equity merged with a common law?
Well, seriously, I believe the attorneys did that specifically so they could get their foot in the door, so they could overlay this equity civil legislative crap and do away with the pure common law, because pure common law action was simply done in a declaration and with all the proper elements.
Okay.
So you didn't need an attorney for that. And I believe that's why in 1872 it was the attorneys that pushed to bring in all the codes in California and New York and start pushing this legislative equity side, and they've buried pure common law actions.
Okay, well, the English adapted it in 1860, 1861. We did like 1930, 1930.
Oh, you broke up there.
Greg, a second. Yeah, it's Greg's phone. He's got like a hands-free headset thing. No, so what I'm saying, if you go back in history, and this is what I did a habeas corpus show, it was to eliminate habeas corpus. It wasn't, I know what you were taught. I know a lot of research you've been doing, and I know you listen to a lot of Patriot shows, but it was to do habeas corpus. What was going on in England, you had Chancery, you had the Queen's Bench, you had the High Court, you had Superior Court, you had the Supreme Court, you had all different kinds of courts. These guys, I guess, make good money operating courts. So what was going on is habeas corpus orders were flying around all around merry old England. So the guy was going, well, let's get it out of the Court of Chancery, let's bring it over to equity. Let's get my client over to the King's Bench, let's get him over to the High Court. So you had this poor guy, well, not a poor guy, sometimes he was venue shopping to see where he could get a better deal. So it's like, hey, this is habeas corpus. You got the body in the wrong court. We're going to bring this court over here. No, the body's going to go to this court. No, we're going to go to this court. So I can imagine the nonsense that was going on. So they just said, no more of this nonsense. If you want to be a judge, you know what? You're going to have to wear many hats. You're going to hear equity, common law, maritime. You're going to hear everything that's before you. No more shuffling these people around. No more venue shopping. No more. And that's what you do with the Erie Doctrine. The Erie Doctrine 1938 says venue shopping. And that's what it is. You're not going to try to cut a better deal someplace else. You're not going to drag this guy and say, well, I got a lawyer, and he's going to drag me to the King's Bench because he's got buddies. Or he's going to take me to the Chancery because he's got friends. And then they got tired of like, okay, what's the prevailing law here? It's like, thank God this country is common law. Over there in England, it's like, okay, well, who gets some exchequer, Chancery? Who gets this body? Who gets to try this guy first? It's just like you hear with criminal cases here in this country, like Jeffrey Dahmer kills somebody in Utah, New Mexico, Florida, and then the feds want him. Who gets first crack at him? So usually all four courts agree. Who's going to hang this guy first? Can we get him through Texas? Beautiful. Texas gets him first. So Texas is going to run him through, and everybody's going to say, you know what, we're not going to prosecute this guy because Texas is going to kill him in 20 minutes. That's how they find him guilty. So to me, if you want to study that a little bit, Ben, maybe you can see if I'm right or maybe if I'm wrong. You know, and if you want to download the other show that I did with this lady, because she was trying to understand habeas corpus, and I was like, stop using their terms. Call it return of property. And then I let Greg come on, and Greg explained to you folks, stop diminishing the capacity of the subject by putting an adjective in front of the noun. You lose. It's like, I always say to people, Greg does it that way, I do a God theory. You see a thunderbolt hitting lightning right in front of you, like, oh my God. It's like, yes, this is God. You're like, oh my God, I'm going to die. This is my last day on earth. Oh, please don't kill me. And you say, well, I am the rainbow pony God. It's like, oh, Jesus, Lord, you scared to death. I thought you were the God. Well, no more rainbow ponies for you if you don't obey my commandments. It's like, oh, geez, you got anything to do with me today, God, the rainbow pony God, or can I go on my way? It's like, well, I'm warning you, keeping my commandments, or else what? No more rainbow ponies for you. Oh, is that it? Huh. Okay, thanks. You know what? I'm really busy. I got to go take a dump. Get back with me next week. You know, I'm kind of busy. Obey my laws. Yeah, okay. So that's what I'm saying. So you just want to go in a court and you say you're a man. You don't. Once you say you're man Ben, that's good. I like the man Ben. But as soon as you say you're the man Ben Johnson, it's like, you just diminish your capacity a little bit, because now you have duties, obligations to the family as a citizen known as the Johnsons. So then if you say you're a California resident, it's like, now you just reduce your status a little bit more. Because now you're saying you have a duty and obligation to all the other residents and citizens of California. So you keep dropping it down your status, the more paperwork. This is what I try to say to you folks. Just say, I'm a man. My name's Ben. How you doing? I got a claim. Because how many times do you see Supreme Court cases where it's anonymous versus anonymous, or they use the word John Doe, or Roe versus Wade? How many times do you see Jane Roe, John Doe? You don't have to use a name, and you don't have to keep diminishing your status. Because every time you keep making these really long, ridiculous sentences, it's just like, boop, 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 boop. How far down the food chain did you go by saying I'm Ben Johnson, and I'm an inmate within, San Francisco, whatever prison they have out there in San Francisco Bay, whatever they call it out there. Then you say, oh, we're talking about a prisoner. Why don't you just say I'm a man? Instead of going, boom, 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 boom. And then they're going to take your lowest status point and say, we're talking to a prisoner in like San Quentin. Just say I'm a man. And this man is doing me wrong. You know, and there you go. But if you reduce your status, keep going down, they're going to ignore you, like this lady was saying. Just like I said, just say you're a woman, your property needs to be returned to its place of origin, and that's it. And then she said, oh, the judge looked at me funny because I call my child a property. I said, well, that's just property is just what you claim is property to your person, exclusive to the jurisdiction to all others within society. That's property, which means your dreams, your hopes, your aspirations, your rights, your heartbeat, your car, your toothbrush, your child, your husband, your wife, your mom. You know, that's it. Only I get to call it my husband. Only I get to call it my wife. You know, only I get to call her son. The place of origin is with me. I created that child. That's my property. Is anybody else going to come and claim that that's their property? So I said, of course, the judge is going to curl up his nose because they want to say, oh, if we could use a legalese word like child or children, we could get her under some sort of 1947 UN Doctrine of Children's Rights. So not only do we still have jurisdiction and control over children because she's agreed to allow us grant or deny her a motion, but the UN could actually come in and dictate to her what to do. They're going to try to use somebody else to keep their foot in that lady's domestic affairs, you know, and to that lady's threshold, and to that lady's house. They're always going to try to keep their foot in the door. And like I said, like what Hillary Clinton did with Syria, she said on CNN, she said, we would love to go in there and take all the women and children out of Syria and protect them in their best interest, because the men in Syria are no good or whatever. They're going to kill them all, put burqas on them, whatever they're going to do. But under the domestic authority doctrine, we don't have the right to enter into another state, into the domestic affairs of another state. We don't have that capacity. We don't have that power. We don't have the right to do that. Even though we could eat Syria up for lunch and run from one end of this country to the other end of the country by dinner time, we don't have the law which permits us to do that. So that's what I'm trying to explain to this Canadian lady. They are trying to keep one foot in the door to allow them to have the capacity still to run through your home. They're going to try to cut a deal with you because they're going to deny her motion on Thursday. She's going to be heartbroken. They might pull the heartstring card, bring the babies into the courtroom, have everybody screaming, mommy, 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 Next thing you know, the state's going to say, hey, cut a deal with us. Yes, you'll get your kids back, but just let us come in once a year and let us just see how the kids are doing, and we'll let everybody go home and say, Mommy, please sign it. Mommy, please sign it. It's like, you know what? You're going to crack and you're going to sign it. I can't imagine if you don't crack and not sign it, because any woman would sign it.
The cannabis cultivation laws, the marijuana laws that were created in 1935 and 1937, when you look those up, of course, they're in health and safety, and their applications is to doctors, dentists, pharmacists, and veterinarians, those who receive licenses from the state to distribute drugs for medicinal purposes. And so, they're charging people, private people on private property, for growing that plant. Right. And there's a fellow in Arkansas who just got 20 years, 2 10-year sentences that they ran consecutive instead of concurrent. And I've been thinking about trying to prepare a...
Yep. Where'd it go? Where'd you go? Mr. Hailstone. Uh-oh. You were trying to prepare what, Mr. Hailstone? Sorry about that. You trying to prepare what?
Well, I've been thinking about trying to prepare a writ of habeas corpus for him. He actually sends me letters, 2-3 letters a week. He's got a really strange case because
okay, that's good.
There is no complainant, obviously.
Now, what you said so far, to you, in your mind, what jurisdiction would you want him to be returned to?
In what jurisdiction? His own.
And what would that be?
In his own private capacity.
Okay, and like I said to me, that's good. No, there's nothing wrong with that. That's pretty good. Now, if he'd want to have it in his own private jurisdiction, what I said, what usually I think is kind of funny, what I work with sometimes, is does he have a wife?
No, he does not.
Too bad. Or does he have anybody who depends on him?
Yes, he does. He has a minor child.
Okay, well, oh boy. See, how I tried to work the angle, somebody asked me the same thing, a drug thing. Same thing was pretty funny. So she never got back to me. I wish the lady, if she's listening or whatever, she got back with me. But it was basically a habeas corpus. But what I was saying is, you want to have the return of your property, compare that with habeas corpus of California, Arkansas, Exhibit A. And what I said to the lady is like, you believe, this is what I say when I said to my wife years ago. I said to her, and when the child was born and we wouldn't sign any paperwork with the state, I said to people, I said, are you going to touch my property? And you have no authority to do so. So, well, we don't call newborns property. I said, well, I call that woman sitting at the end of the table my property. And they're like, oh, Mr. Lentz, that's a horrible name. I said, she calls me her property. And she said, oh, no, it was Lincoln abolished the slaves. And I said to my wife, I said, am I your property? She said, you're damn right. Nobody better touch you but me. I said, well, there you go. We got an agreement. I'm exclusive. She has exclusive rights to enjoy me. Exclusive to all others within society. She is my property. I provide for her. I provide service for her. I provide financial support for her, and then she provides for me, whatever duties and obligations that we confer to each other. So that's what I'm trying to say. If you could show, like in a habeas corpus thing, like in a right to transfer of property, bring the property back to its source of origin, I said to the woman, I said, look, say your husband is your source of income, and by them holding that body, that mule, or that donkey, jackass in their prison, it's interfering with your source of income. And that you rely upon that mule or that donkey. I'm sorry that mule or donkey smoked marijuana, or that mule or donkey had 5 pounds of pot on it. But you know what? Are you going to release that donkey and that mule back to me anytime soon? You have some sort of purpose in keeping it there? Because I believe I have a superior claim to get the full benefits out of my property. You claim that's your property. Did that property cause you damage? Did that mule actually cause you damage? Oh, it causes the taxpayer of Arkansas great damage. Good. You let a taxpayer come forth and actually show you an itemized statement of an actual bill of particulars in which that donkey, for some reason, caused $517 worth of damage to that man, and we'll compensate that man on a private side. We'll work with him through the administrative process. But until some man comes forward, that's my property, and I want that property returned to my jurisdiction, because I depend on that. If you want to call a human being a U.S. citizen property, well, I'm claiming him as property. The United States and all you Patriot Movement people all say, well, the United States thinks we're property. Oh, good. They should move my claim through the court really quick. You people, every federal district court, oh, you claim that we're property. Well, we are. Well, okay, fine, we're property. Give me back my property. And there you go. So I'm just saying that's a spin on it a little bit. If that kind of helps a little bit, sure, I get your brain working on that one. You see what I'm saying? I'm trying to get it back to somebody who can make a claim that it's property, and without that property being returned, they're going to have accrue financial loss.
So, I can go in and amend it. How do I make the amendments? Would I basically rewrite what I've written and kind of resubmit it into that case, or just write a simple letter that I want to keep the word property?
Well, like I said, try to get everything done by Monday, because they gave you till Thursday. Even if you don't think you can get it done by Thursday, you can just say, when I need to stay on the return of property order that I submitted to the court. Honestly, at this time, I'm living in a trailer. So I'm living in my grandma's closet, and whatever you make an excuse to stay. You could stay the hearing or stay the trial, because you're the one moving the claim. So you can just say, at this time, I'm going to have to stay the hearing or stay the trial for another week until I get my paperwork properly submitted. Whatever you want to use, any excuse. It's in your court now. It's in your hands, because it's the Arness court moving through the Queen's Bench. So if he says, well, the court's not going to like us saying it's like, well, you know what? It's the Arness court. It's well, that's the lady's name, Jessica Arness. It's the Arness court moving through this court. It's the Arness court moving through this venue. I'm holding court. So the Queen will let you know when she's ready to move, when she's ready to proceed.
Right.
So the Queen Arness will move her court when she's staying good and ready. Maybe the Queen's got a sniffles. It doesn't matter. You'll wake up at 3 o'clock and say, I want to hold court. Like, you seen how fast they did it. Once they realized you were holding a court of record, you were heard immediately that day. They realized the Queen was in the building. President Obama popped in. Oh, everybody get troops all lined up. Let's help the Queen out. Right. But once you're the Queen, you aren't afraid of any man in the judge suit, because you're the Queen of England, or you're the Queen of Canada, or whatever, and you're holding court. And it's like, thank you, but the court is not amused. Well, it means we're not confused. The court is not amused. And we will stick with the term property, but we'll take that into proper consideration. Thank you, Your Honorable Fine Sir.
Hey, Tom, Greg.
Hey, Greg.
I jump in real quick. You've been doing great. I didn't want to say anything, but you and I were talking about this yesterday. And one of the things that we mentioned kind of like off the cuff as a joke, but when we realized that it was really important, when the court recognized that the Queen had showed up, all of a sudden they brought in their top dog, their biggest dog, okay? Because the Queen would not want to talk to anybody except the top dog. However, at the same time, what all the lawyers were saying and judges were saying to each other was, holy shit, how did the Queen get out of the Tower of London? Who
right.
the damn pulpit?
We had a right.
So while she's here, well, of course, now she's here, so we have to be nice to her. But we need to find a way to have her kind of like accidentally back into the door of the Tower of London and walk back up the stairs and try to do this as nicely as possible, because we don't know who the heck the guy was on guard. We're going to find that son of a gun and let her out.
That's great.
It would be really nice and to get her back in there.
Yeah, because what's Greg's saying was he missed a little step there, but he did damn good. But what he missed was, me and Greg was saying, when the judge was challenging you, if you were truly the Queen and you knew your authority, you would have said what I said. Thank you. We'll take that into royal advisement, but the Queen is not amused that you're trying to deceive her with this bamboozle nonsense, child property nonsense, because the Queen owns every damn thing. Every damn thing she claims is hers. So the judge would have understood, oh my God, this really is the Queen. So if he was able to change her brain a little bit, he's like, oh, she just watched a YouTube video. Oh, she just read a Patriot thing. Oh, she's got some crazy clown on talk show from Virginia who's telling her what to do. She really doesn't know her as good as she thinks she does.
Right.
This is what they're trying to do. And like I say, these
folks... we did kind of get into a debate with them as well, at first, and then we just kind of succumb to the glinting smile and the kind eyes, you know, being like, okay, well, if he's going to submit our paperwork just but with this, changing this word to this word, we'll do it to get our foot in the door, and we'll figure out how to backtrack and nullify that kind of change after the fact. So that's basically where we're standing now, to try to...
It's like me and Greg was saying, when you...
And cover their butts. Hold on. And to cover their butts, just in case you really are the queen and you just have a sad case of amnesia, they don't want to disrespect you. So they're going to be very polite and helpful to get you back into your cell in the Tower of London.
Right. And what me and Greg was saying, why this is so dangerous for folks like you guys to play this game, is because if they could get you back where they want you, they're going to make your life hell. It's like you're dancing with the devil.
Yeah.
And he just wants you closer. It's like, oh, come here, man, come here. Let me tell you what you should do. This is what you should do. And it get closer and closer, and he's going to burn you more and more. He's just trying to figure out a way to burn you. And like I said, and that's what they're going to try to do. They're going to try and intimidate you. They're going to say, look, there's your babies over there. If you want to see them again, this is what you better do. You better stop playing with us, and you better start working with us. Believe me, I went through that nonsense with them for 7 years. They're saying, look, you owe hundreds of thousands of dollars in next child support. Put me in jail. Do it. I don't care. I'm going to move my claim from finally get a copy of my case file, because I have no idea, neither does my wife have any clue how you'd put my child into your custody. We don't know if we charge you with a crime. We had 17 lawyers, literally 17 lawyers we paid hundreds of thousands of dollars for, and we can't crack that cover. None of our attorneys can crack that cover. But nobody knows how you're holding our child in possession of the state. It took us 7 years to find out that it was based upon a contract that they said we signed the day the child was born. And like I said, and then when they finally showed us the contract, we laughed. This had to do with a girl who was 4 years old, living with her uncle and her grandma in an apartment. So like I said, they'll try every dirty trick in the book, even if they know they're flat out wrong. They're going to try to do it and see if they can get away with it. So far,
the contract was signed 3 days before your kid was born.
Yeah, it's even funnier. But like I said, they're going to try every dirty trick in the book they can. But it's hopefully Canada might be a little bit more gentle than Alabama. And maybe they'll actually just say, get these people out of here. But I think they're going to try, me and Greg were saying, they might try to save face by trying to say, look, man, just let us come to your house once every 100 years. We'll come into your house in 99 years, just sign some sort of consent decree, and we'll agree to end all this. Right. And that's what they're going to try to do. Because when you do a consent decree, that means nobody's admitting guilt of any wrongdoing. So they're going to try like the old consent decree now. Because that's what they told me to do. They said, look, Mr. Lentz, we don't want anything from you or your wife. Honestly, you know what? If you just go to and get a psychological evaluation, we don't care if it's your mom who's a licensed physician, or you got an uncle or a cousin, or you got a best friend who's a physician. As long as he says, I'm a physician, Bob, and Karl and his wife are A-OK in my book, we'll give you back your kid. I said, nope, we're not dancing with the devil. We're making no deals. It's like, oh, come on. You get your kid back in 2 minutes. You know, we'll even pay for it. Nope. Oh, you can pick any doctor you want. In your state, our state, we don't care. Nope. Like, oh, come on. This will all be over. And I was like, nope, I ain't dancing with you people, because you always got to figure out a way how you're going to stab me in the back. There's some sort of loophole in this consent decree somewhere where you're going to be able to still come back in a year from now, 2 years from now, take my kid right back and put him right back, and then you're really going to bury me. Then you're going to have a real criminal charge against me, and I'm going to be sitting in jail, and I'll never see my kid. Because now you got a hard on for me, and now you want to slam me. Because I decided to fight back. I said, no deal. That's what you were saying about you and your husband. They said, well, they got found 10 pounds of crystal meth in the trunk of your car. You guys are going to sit in prison for 50 freaking years, and the kids are going to look at you through a plexiglass. So I said, do these people want to move out of Canada? Do they want to move to another province? Or do they say, you know what, maybe if we press our case hard enough, quick enough, they'll just give us back our kids and leave us alone? It's all a gamble. You folks have to, you know, I don't know what New Brunswick is like. I don't know the mentality of these people up here. But like I said, the state attorney general for Alabama, not the FBI, ABI, Alabama Bureau of Investigation, told me never come back to the state. They said, you'll never leave. You ever come back, you'll never leave. I took their word on it. I mean, they don't play. They're like, you come down here, you'll never leave. that's pretty.
So how the hell do you fight a case in their court, or at least in their district court?
Yeah, we'll talk about my things. Right, we'll talk about my things some other day about provost marshals and how to use them. But to get into a state and get out of a state. So you got to understand, these people have no problem keeping your kids away from you for the rest of their lives. So, but you don't look at them like, I hate you, I hate you. You just say, this got to be stopped, and I'm not going to knuckle down and just be intimidated by you folks.
Exactly.
This is my course. These are my rules. I have this right according to, natural law. You don't have to use God or the supreme being. You have a natural right. You have rights to control your property. And the church teaches you any nonsense about property. I'll try to find the John Locke quote, because it's like, he's saying, well, Lincoln freed the slaves. It's like, yeah, but what did John Locke say about property? Property is what a man claims that is property, his person, exclusive to all others within the society, for him to enjoy exclusively of all others. Is that not property? Like my heartbeat and my dreams, my hopes and my desires, is that too not my property? And let him baffle that little ditty. And he'll say, well, okay, well, then I guess John Locke kind of does trump Abraham Lincoln. It's like, yeah, because that's where Abraham Lincoln got his knowledge from. So don't. You want me to trump you? I'll keep trumping you all day. You just look before you leap, and then I'll say, well, he who hesitates is lost. You want to play your little ditty games with me? I'll play your little ditty games all day. The bottom line is, does anybody have a claim to that property other than me? Yes and no. And it'll be that simple. And thank God in a common law country, no. In France, if that child is part of society, you have no inherent right to that child if you agree to abide by the customs and traditions of that society. That child is part of the community. That's what they're trying to do here. In this country, they're trying to make the child a part of a community.
Yeah.
And that's fine. There's a lovely concept. It's kumbaya and hugaboo and stuff like that. That's lovely. Maybe one day they'll figure out the DNA of a human being and get rid of all the anger, lust, greed, gluttony, avarice, fear, hate. They'll eradicate that gene, and we'll all be lovely, happy creatures. But until that day, I don't want nobody touching my kid, because I don't trust nobody.
That's right.
With my kid, that's my kid. Don't tell me you have good, will for my kid. I will only do what I will do for my kid, and nobody else will do what I will do. And you don't have to explain it to anybody. It's universally accepted that everybody understands this concept about a child and a mother.
Yeah.
So you don't have to go about that. But what I would do if I was you, establish the rules of court, give them in the form of a notice, explain that the honest court is going to be holding a preliminary hearing for the return of the property, and if there's any claims that come forward, the trial by jury date will be set 1 week from now. There you go. And if nobody comes forth with a claim for the possession of this child, this man in the black robe before us, who's ever going to sit before us for a representative of this venue, a representative of this, whoever the clerk assigns to sit before us, he's going to take he's going to be witness to what occurs today, the event, that nobody came forth with a claim, and that my order for the property 1, 2, and 3, 4, also known as children, are to be returned to its original place of origin by 1 a.m. And then once you get that order, then you go to, well, I don't know if you folks have sheriffs in the Mounties, then you could bring that order down to the sheriffs in the Mounties and say, help me regain my property.
Right, here it would be the sheriff.
Right, because like I said, if they say you want to do something similar to what you folks call a writ of attachment or writ of sequestration, that's fine. But a writ of sequestration is more like saying, if you really thought that MOSD folks, whatever the people out there, the social service people are hurting your children, you could move for a writ of sequestration and say, I want those children, my property, removed from those people because I think they're in great danger and harm. And if you could, can you relocate them? If you don't want to put them in my custody and care, can you please bring them over to a Catholic orphanage? Because I trust those people more. You see what I'm saying? That's a writ of sequestration. I'm not saying you're doing this for you. I'm just making this available for ideas of other people to use in the future. Not this isn't for you alone. I'm just saying throwing it out there for the people who might listen to this stuff.
That's right.
Like,
What the different options are that are out there that are available.
Right. It's real fear that the social service people who are holding your children at certain providences and states are actually placing with a maniac family, or do you say, well, you know what, we gave services a hard time, so they're going to pick the worst foster care family to put my children in, so my children get beat up because we won't just knuckle under and sign damn contracts. You make a motion to the court we'll explain motions and orders some other time. You order the court that you want your child moved from that place and placed someplace else. And we'll do that some other time. Somebody wants to talk about a writ of attachments or writ of sequestrations. We'll do that some other time. But your big thing was when you walk into court, how you act, set up the rules, say why I'm sitting on the left, because it's custom to you people so you don't freak out. The guy's taking over the right-hand table with me will sit at the left-hand table. But at no time do you think that I'm not prosecuting a claim, that property is mine. And regardless of where I'm seated, the fact remains, if a claim doesn't come forth before this court by 10 a.m., the clerk, the magistrate is to recognize and witness to the court clerk that she is to stamp our orders and to deliver upon us. And then you can do whatever you want with that order. You can go down to the sheriff's department and say, well, I got an order. If the sheriff says, well, you know what, we like writ of attachments. So why don't you go get us a writ of attachment, or, like a warrant in debt, go get a warrant for us and we'll go get it. And then I'll explain to you a little bit about bonds and stuff like that.
Yeah.
Right now, you don't really need to know all that stuff. So this was just basically how to act when you walk into the court and how to just kind of try to get away from all that crazy, should we stand up, should we rise, should we speak, should we not speak? And like I said, the best thing to do is you give them the rules. As long as you give them the rules prior to being there, everybody knows what's going on. And it's like, sir, did you not read rule number 2? What? If anybody's making a claim, they could bring the claim forward to me. Or they could hand their claim to the bailiff, and the bailiff could hand you a copy, and the bailiff could hand me a copy. Why am I not getting a copy of the claim? I'm going to be the one who's going to judge whether or not we're going to share this property. And if I choose not to share this property, or the proposal that they're throwing across the table at me, I'm going to say, you know what, we've reached an impasse, and now we have a matter of controversy that is going to be standing for all times again between us. So we are going to have to move this before trial by jury. And does everybody have a problem with us being here next week, same time, getting the jury convened and let the show get on the road? Anybody have an objection to that? Because, like I said, court's open 24 hours, 7 days a week. You could hold trial by jury at 3 o'clock in the morning. There's really nothing they could do about it. I did that to a jury. Tommy said, oh, Carl, please, let's be reasonable about this. He says, can we convene in 14 days? I said, well, let me tell you what. How about we do it in 30 days? He said, 30 days? He said, court is open 24/7, 365. I said to the judge, I call you up at 1 o'clock in the morning. What happens? He says, I'm supposed to call the state. The state's supposed to convene. We're supposed to come down here and hold a trial. I said, that's right. He said, Carl, please, can we be reasonable about this? I said, what do you propose? I said to the judge, the hearing officer, what do you propose? He said, how about 14 days? Give me 14 days because I live pretty far away from this county. He was coming up from Montgomery, a big county down there by Montgomery. He said, can you give me a little heads up? How about 14 days? I got things to do in my courthouse. I said, okay. So I said, how about I give you 30 days? He said, wow, that's great, 30. He said, that's very reasonable. I said, buddy, I got to come from Virginia. I got to lock up a farm. I can't be here at 1 o'clock just because I wake up and say, oh, the King's convening court, it's 1 a.m., everybody chop, chop. I said, I still got to drive 600 miles to get here. I said, so believe me, 30 days is fine by me. He's like, oh, well, God bless you. At least you're reasonable about this. See, when you really know the rules of the court and that who's running the court and that you're the prosecutor and you're the king or queen, you're the one who's calling the rules. And they have a certain established set of rules. The court is open 24 hours. Well, here in America, here in the United States, it's 24/7, 365. So I don't know what it is in Canada, but the rules that are well established, and you can find in every single constitution or every single code book in all these states. It always says the same thing. Courts are never closed. So they might just make a simple word like that, courts are never closed. That doesn't, so when you say, well, the door closes at 5 o'clock a lot, you could always go to the sheriff's department. They'll ring up a magistrate. The magistrate will come down, and you can conduct court in front of the magistrate. He's a witness that you brought the claim at 2 o'clock in the morning. or that you're filing a criminal complaint that somebody broken into your husband, busted your nose, the magistrate will wake up and come down and take your claim. The sheriff will go arrest your husband at 2:05, and there you go.
Yeah.
Then when the clerk of the court opens up for business 9 o'clock, the magistrate will just handle the paperwork. Say, this is what happened last night while you were sleeping. File it, put it, give it a case number, routing number, whatever you want to switch to, court clerk, and I'm going back to bed. So is there any other questions you really had about Wednesday?
No, I think that really helps kind of clarify the process. So what would we title our notice that we're sending to outline the rules that we're
Notice. Notice.
Just a notice, okay.
All lowercase. Notice. And underneath this, say notice of, and then say our notice, and then underneath it, you could do I like to do it, rules of court. You could make rules with an uppercase R and court with an uppercase C, because what you're saying is, by doing one uppercase like that, you're saying you believe court has duties, responsibilities, and obligations. You're saying the court has no rights, but what you're saying is the court has duties, obligations, and responsibilities. So when you say rules, you're saying that we have no rights, but what we have is duties, obligations, and responsibilities to abide by our own rules. Like if we operate outside of these rules, you make the king and queen aware that we're operating outside of our own parameter and rules that we establish for this court, and you could hold me in contempt of court. You see what I'm saying?
That's right.
You could be held in contempt of your own court. So that's why, like I said, make notice in lowercase, but I'd make the rules of court, rule uppercase R, and C uppercase C.
Mm-hmm.
And, when you do the on this court, like I said, you could do it in all lowercase like that if you want again, because you believe you have exclusive rights to everything within that on this court. The on this court could be all lowercase. That's fine.
Okay. Can you spell the on this court?
Yeah. Mm-hmm. Oh, yeah. And then every time you want to refer back to the on this court, just say said court, SAID court. That way you don't have to keep saying on this court, on this court. You keep saying said court.
And how do you spell the Arness court?
What's your last name?
Oh, you were using our last names. Okay, yeah, so the Arsenal court.
Okay, well, you wanted everybody to know Arsenal.
Okay.
That's what I was saying on this, kind of figuring that you kind of figured you knew what I went for. So, like, okay, if anybody's listening to this call, you use your last name. Because if you look at any Supreme Court rulings, like Hale versus Hinkle, it'll say, in the Hinkle court, the lower court decided this. And then it moved up to the Circuit Court, the Court of Appeals in New York, and in the Hinkle Court, at the Court of the New York Superior Court and the New York Supreme Court, the New York Supreme Court in Hale versus Hinkle ruled that the accountant for the banana fruit company, Mr. Hinkle, was denied. So Mr. Hinkle now has brought it before the Supreme Court. So the Hinkle Court has now moved into the Supreme Court of the United States. So what it is the Arsenal Court now is now moving into this venue. It is the Arsenal Court. So what you folks will call the Arsenal Court, and then you can put the word at, and then say what court are you actually comparing, like the New Brunswick District Court?
Court of Queen's Bench.
Okay, is that all it's called? Is it called the New Brunswick Court of Queen's Bench?
We actually called it the Jacinthe and Jonathan Court.
Okay. What I'm saying is, what do they like to title or stylize on their letterhead? How do they like to address themselves?
They refer to it as the Court of Queen's Bench of New Brunswick.
There you go. Beautiful. So you say it's the Arsenal Court at the Court of the Queen's Bench of New Brunswick. Exactly the way they stylize it, uppercase, lowercase, however they like to do it that way. Because it's just a cause at this place. Because you basically, everybody's knows where this building is. So instead of being cute, you're saying, does everybody know the name of this? And they say, yes, okay, fine. Then the Arsenal Court at Queen's Bench, blah, 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 blah. We'll have a hearing, blah, blah, blah. There you go.
And, yeah, so I think, basically we're outlining our rules of court, we're the prosecutors. We need the minister to come forward to press her claim on the record, if he has one.
You leave it vague. You don't say you don't You say we are accepting any and all claims. You don't really use prosecutor because prosecutor means you're just a hunter. You know you're a hunter. So it's like the hunt for deer or something like that. I don't have to say Karl the hunter. You see what I'm saying?
Mm-hmm.
You don't have to defining yourself as a prosecutor. So all you have to do is say the on-nest court is accepting all claims to property 1, 2, 3, and 4, see exhibit, whatever. And then you can even put their lovely birth certificates and anything else you want to do. That's fine.
Okay.
But to say the property known as 1, 2, 3, 4, see exhibit 1, 2, 3, 4, that's fine. And say we're accepting all claims, and may all claims, and we accept all claims from 9 o'clock to 10 o'clock. And it's just simple like that. Don't direct them personally, because what you're trying to establish is people on the right-hand side don't even exist. They're a phantasmal, agorical, whatever aberration that somehow believe they have an opinion or a voice that should even be heard. You see what I'm saying?
Yeah.
You're trying to make it like they don't even exist. I don't even know where these people get their authority of power, jurisdiction. I don't understand why these people are in this building at this time. I have no idea what makes them think they can do what they're doing. So you see what I'm saying?
That's right.
You're trying to basically, talk to the hand. I don't even know what you are. I know you're just some rule book that sprang out of the ground 2 years ago. My kids are alive a lot more. There's agencies on this planet.
That's right.
See, so that's try to be vague about who's making the claim. You see what I'm saying?
Okay. So we're basically, our rules of court, when we lay them out in the notice, we're accepting all claims from, say 9 till 10. And, if nobody brings forth any claims by 10 o'clock, then we want the judge to basically record that the other party didn't show up, nobody pressed a claim against for their kids.
Instead of saying the judge, say the representative of the court clerk's office. He's going to be a representative of the court clerk. Who's ever been assigned to our court's office is to witness that no claims have come forth. Okay. And that he or she is to bear witness and take my order and present it to the court clerk and have the court clerk file it and return it to me as a witness that no claim has come forth.
Perfect.
There you go. You want to get away from looking at him as a judge. Like, this isn't a beauty test. This isn't American Idol. He's not your judge.
That's right.
And if the magistrate, the guy in a black robe, says, "No, ma'am, I'm sorry, but the MSO Social Services did bring forth a claim, so we can't bring this to the court, and we can't have your order stamped and filed at this time." So good. Then you read the rule. If you believe, if the assigned person, the court clerk's office, at this time believes that there is before this court a counterclaim to our claim, then we want a trial by jury set up as soon as it's available in this venue to see the jury. And then we can say we'll come midnight. We don't.
I don't care what time it is.
Right. They'll understand. Well, you can put that. Court is never closed, and I'm sure you can. It says that.
My question to you is: you're doing a claim, and then you're not into 21 days. My question to you is: you're asking them for a bill of particulars. I heard that on one of the calls, and then there's one thing I was having you do. I don't remember, but anyhow, you have these other things going on. Are you doing the claim first, and then the bill of particulars, and then your cease and desist and what's going on? Or are you doing a bill of particulars first, and then come cease and desist, and then do the claim? I mean, could you give me that in sort of an order how you're doing this?
Well, first I give them a notice, then I give cease and desist, then I give them the order, and then if they request a bill of particulars, I don't give them a bill of particulars or an invoice or a statement of the facts unless they ask me for one, and unless they request one from me, I'm just handing them the bill. I'm just handing them the order.
Okay.
All right.
My next question is to you is, So you got this process going on, because I definitely know how to do processes. And you've got this thing going on 21 days. But what happens if you're going into court and like 10 days later or 12 days later, you haven't really cured your process at that moment? Or are you saying to the judge, hey, let's bring this all to common law court? Or, okay, but you already, and if he says no, but you already have this process going down the pipe. You see what I'm saying?
You just have to establish that your court's not ready. Like your name is Tim, or what's your name from Ohio?
My name is Chuck.
Chuck. All right. Hang on a second. Hang on, Chuck. We got great. All right. You there, Chuck? So,
yes, sir, I'm still here.
Greg's going to call up in 2 seconds. I'm going to let him jump and talk too. But what I'm saying is, what you have to do, you have to establish court has just made aware that there is a claim being presented to the Chuck court. You see what I'm saying? So that's how you basically realizing it, that the Chuck court has just been made aware that somebody is filing a claim against a person known as Chuck, whatever your last name is.
Yeah, Chuck, yes.
Whatever your last name is. That there's a claim to your person, and now you need time to answer it. And not only do you need time to answer it, you also have filed a claim of your own against a person of a cease and desist or a false claim, that there's another case in district court in which I'm moving this person who is harassing me or who will not settle the matter with me on a private side, and he's forcing me into a public forum in which is dishonorable. So since he will not cease and desist and work a solution with me on a private side, I'm moving the claim against him in district court. If you notice, the district court clerk gives you a case number, say, look at case number 1234, you will see that I have established him as a defendant in my case. So we want to merge the claims at a time in which would be convenient for all parties to attend.
Okay, one of the most important things to think of anytime you're doing anything in law, as a matter of fact, if you're writing a letter to your kid, the most important words are the tiniest words. They're the words of position, if you will. In, at, on, of, for, above, on, things about position. All right? Things that, okay, and all those little words are very, very important. For example, if I'm standing on your foot, I'm trespassing. If I'm standing in your foot, I've committed a miracle, and I've been able to actually move my foot inside your body. If I'm standing at your foot, I am beside it. Okay? If I am standing over your foot, I might be considered a threat. If I'm standing under your foot, you have some control over me, and you might be hurting me. The words, the very small words, are very, very important to keep in mind. And so, stop using the word in when it comes to anything in law. All right? At, on, around, near are all great. Okay? You can be filing this in your court, and you can use the word there and then, if you name your court. Right? You can name your court in your filing. I'm filing this in the court of, Granny at, the district county courthouse, and so that they know that you're not in their court system. Okay, now the only other thing that you can be in besides a cup or a container is the word agreement. You and I can be in agreement. Okay, that means we can be in a state of something. All right, we can be in disagreement. We can be in heaven. We can be in, some form of state of being. Okay, and believe it or not, they will use all these tiny little words to help you move yourself out of your jurisdiction and place yourself squarely into their jurisdiction. So you have to be extremely careful. All right. So I don't know if that helps. I'll stop there because I think you get the general idea of what I'm talking about. Make sure you understand the words you're using.
Hey, Greg. Hey, Greg. Greg, just answer that. Just answer that question, because a lot of people ask that too. What's the difference between in-law, at-law?
In-law is in the state of law. Okay? At-law is juxtaposed to it.
You want to explain it to John? John from Colorado is asking that question. He says, "What? So I want to be at-law or I want to be in-law when I write my paper?"
In-law.
Because he's asking, he said, "What about filing at-law? Is filing at-law good or bad?"
Filing at-law is what attorneys have to do, because they're operating in their fictional capacity as a steward.
Okay, well, I'd like to add in there, say I'm operating in law, because who creates the law? I do.
So, right.
Creator of all my laws. I'm not waiting for a man to put a piece of paper in front of me and say, "Now, there's your laws, Carl. Obey them and live the rest of your life according to these laws that I wrote for you." What? I'm not. This is my turn in the sunshine. I don't care what somebody in 1776 told me I'm supposed to do. F them. This is my turn to do what I want. I'm going to create my laws. I'm going to create what I think is necessary and proper for my constant survival, what I think is beneficial or not beneficial, and I'll accept benefits and I won't accept certain benefits. They're gifts from my forefathers to me, whether I accept them or not. There's no concern to anybody else who's the trustee. Don't you worry about it. You just hand out the assets that the trustor or the forefathers created for me. So any damn concern that you're holding me obligated to a gift. You can't hold me obligated to a gift. Just because I'm a beneficiary of Social Security or whatever other acts of whatever, doesn't mean I'm obligated to compensate for the gift. Well, why would he establish this gift for me? If it was an obligation, then it's not a gift.
Well, I think Spooner puts it extremely well, because he even uses that to describe the original founders of the United States. He says there's nothing in law that allows for a parent or a predecessor to bind their children or anybody else. In other words, if you are a dad and you build a house and you give it to your kid and say, "I built this house for our family and you have to use it for the rest of our family's life," for on and on for eternity. Well, your son can accept that gift and say, "Well, thanks, Dad." He can also say, "Sell it. I don't like that house. I don't need it." And there's nothing that you can do to make your kid keep that house, take that house, live in that house.
Right. But like I said, I think John was typing too slow, because it says, so at-law and in-law means no difference then. No, we just explained to you what it means. So you can re-listen to this tape again, but it's really simple. Attorneys are at-law. We are in-law. We are the law.
Right, but there's also a reason that hundreds and hundreds of years ago, they came up with the term to describe your wife's mother as your mother-in-law, not your mother-at-law. Okay? Because you and your wife created law by contract, right? By your marriage. And so your mother is her mother becomes your mother-in-law, which means in the law of the marriage contract. That's what it means. It's within. It's embraced.
You can understand that. It's when man creates his own law, man creates law, you're in law, and compared to at law, the attorneys could only approach the law. They're not actually in the law. That's why they don't testify. They have no first-hand knowledge. It kind of makes sense. They're not witness to the law because they weren't there. Okay, hopefully that helps. I don't remember. Was Granny asking anything else? Because Granny's still on the phone.
Well, I just don't know where to do the matter of jurisdiction.
Yeah, I remember the question now. Yeah, like I said, we're going to do like a family court thing. We'll do that. Like I said to the other lady, where you file the appeal and not file appeal, where you file the original, you find out where the judgment was, and obviously you want to make a void judgment. You could make a void judgment to that court, but like I said, they're going to basically ignore you. So you can take it to the district court, and you move your court into the district court, and you're making that judgment a void judgment. And Greg, you explain to me, he feels like it, but a void judgment is an actual thing. It's not doesn't describe the judgment. A void judgment is a specific phrase, like a specific thing. It doesn't say the judgment is void. It's a void judgment. A void judgment never existed.
Right, exactly.
Okay. Greg, you want to do that real quick?
What about what a void judgment is?
Yes, but the adjectives and diminishing the capacity of the noun like that, the subject and front, why, you want to be careful when you say the judgment is void or it's a void judgment.
Right. In English structure, the antecedent word is the predominant word, okay? And I'll try to put that in high school words. Whatever word comes last is the word that's being modified. The word that comes before it is the word that's doing the modification. One thing that a lot of us that are on this cookie trail are familiar with is hearing somebody saying, oh, I've got the right to a jury trial, okay, with regards to your rights, as opposed to a trial by jury. Now, trial by is one phrase, okay? Jury is the subject of the modification. So what you're entitled to is a jury, all right? You're entitled to a jury. And you can just say, I'm entitled to a jury. You could even skip the trial by, all right? Trial by is simply modifying that so everybody knows we're talking about having a trial by jury, not a hearing by jury, not a coffee meeting by jury, not going and shooting full of the jury, but a trial by jury, all right? And if you go the other way around and say a jury trial, you're saying I want a trial. And I want a jury to be there, okay? It doesn't say what their role is. It doesn't say what their responsibilities are. It doesn't say that they can override a judge. It doesn't say that they're going to be making the determination of law and establishing the facts. It doesn't say that. It doesn't say it's court of record. So when you move the words around, they mean completely different things because it's the last thing in the group of words that is the critical thing, and you can get rid of all the other modifiers and still make sense. Okay? I'm going to drive my car. Okay? I'm going to drive my beat-up old 1997 Ford car. All right? I can get rid of all those modifiers and just say, I'm going to drive my car. All right? And so the more words I put in there, the more diminished my car got. All right? Even if I put positive words, like my brand new Subaru hatchback with shiny chrome wheel covers, all right, I'm still limiting my car. Every time you describe the car, you limit it. All right? When you make a list, for example, if you're going to tell a court or a judge that your claims include apples, oranges, pears, and bananas, okay, well, let me do a better job. Let's say oranges, limes, and grapefruits, okay, and others, all right? So what you just did is you named 3 citrus fruits and others. So that means that everything in your list that includes only includes citrus fruits. Even though you said oranges, limes, grapefruits, and others, you might have thought that you were talking about apples and pomegranates and bananas, but you're not, because you created a list and you did it, and the word includes is a limiting word, not an inclusive word. All right? So there's a lot of things that we have to be careful of when we use words in combination with each other and when we're structuring those kinds of things, because in our effort to try to be more clear to the reader, we usually end up diminishing what it is we're going to say. So be extremely careful to not add additional adjectives and additional adverbs whenever it's possible to just speak like a very simple sentence, like C spot run, I love you, God is good, Cubs suck at baseball,
Well, Greg, I think that you did real good, but let me, you brought up a good point there. When people want to avoid a judgment, see, this is why I try to say to you folks, make very many separate independent orders, because like some lady was saying about a divorce and kids and settlement and all this other nonsense. So she goes back, and this fall back in 2004, and basically the only judgment that she's going to show me is something about divorce and all this stuff. It's going to be pretty hard for her to avoid the judgment because you no longer want to be divorced to this man, and you want all the thing to be the judgment to like it never existed, not ab initio like from the beginning, but avoid judgment means it never existed. So you only want to avoid that judgment, or if you want to avoid the judgment, you're going to have to start from dead scratch. And that's why I try to say, can you make separate orders? And you guys just say, look, place this order so that way somewhere in the future, or if you're not granted or something's denied or you want to modify a certain thing, you don't have to go back and rearrange the whole thing from the beginning. You just say, look, let's do this a la carte. Let me make an order, separate checks, separate claims, separate bills, just in case, you know what, you make this great big huge order for this waitress, and the waitress says, I can't grant you that order. So you say, I want pineapples, fruit, a shrimp cocktail, flounder, moose oxtail soup, can we have kippers? It's breakfast. And the lady said, I can't grant that order. And she said, why not? It's like, look, I ain't got time to explain it. I can't grant that order. I'm out of here. So if he says, can I have kippers for breakfast? Yes. Okay. Can I have oxtail? Yes. Can I have shrimp? Yes. Can I have shrimp scampi? Yes. Can I have a fruit cocktail? No. Why? Because we don't have it. We don't have the capacity to deliver that to you. But everything else we can give you. But that we can't do. So instead of the judges are going to explain to you exactly why you can't have every damn thing on that you just ordered. He's busy. He ain't got time. Maybe he couldn't care less. And honestly, it's not his job. So that's why I say to you folks, like I said, when you find these judgments, when you avoid the judgment, if you put so many times, if you make this judgment so freaking long, you're going to have to go all the way back to the beginning, start all over again, and just go back to the divorce, because that's what happened with my sister and her ex-husband. The judge said, you know what, the original order to consent decree is a disaster. You know what, he didn't disclose that he was hiding assets. So we're going to have to start this whole divorce all over from the beginning. And my sister said, oh, no way, I'm not going through this again. So see what I'm trying to say to you folks? When you say, okay, when you have the judge write up the order, well, you propose the order to the judge if you want to, if you're going through a divorce. If you really trust the person in a black robe, you have attorneys, you propose the orders, and then the attorney sends the proposals to both sides, and the judge, and everybody kumbayas and, comes up with a decision. When you're a man in common law, you create the orders. You're not waiting for the judge. He just was sitting there waiting for you. He's like, okay, when are you going to place your order with me? It's like going into McDonald's to the drive-thru. It's like, oh, and the lady in the window, you tell me what I want. Go ahead, you make the order for me. Like, what are you kidding? Tell me, buddy, what do you want? Oh, I want a Happy Meal and some fries. Okay, that's what I had to say. Give me number 2. Okay, here's your order. Fine. That's what a judge wants to do. Just give me your order, and I'll give it to the court clerk, and the court clerk will stamp it that I witnessed that nobody answered. Nobody objected to your order. I delivered your order. Now go out and do whatever you want with it. Throw it on your windshield, eat it, do whatever you want. It's your order. Go bring it down to the sheriff's department, hang it on your wall. We don't care. You got your judgment? Great.
Oh, I also like, in common law, Carl, I also like to really start not calling these guys judges, but calling them magistrate, and then putting the word judge in 4-corner brackets. Because they like to call, because that's what they know, but I'm not asking them to operate in the capacity of a judge. I'm asking them to operate as a public magistrate. Okay? Right. That's what I'm asking them to do.
Right, as somebody who's just been assigned from the court clerk's office to witness the procedure. That's all. Stay in the background, stay out of the loop. We don't need you. We got the tribunal here. We got the jury. We got the other sides. We're good to go. Just say that you witnessed this event, and then just take the rendering from the jury, take the verdict, bring it to the district court clerk, take it to the court clerk's office, let us stamp it, and say that, you witnessed this went down, and this is the true verdict from the jury. This is the true bill they handed down, and this is what all parties are supposed to get, and forever hold your peace. No appeals, nothing. We're done. You have to understand, a court of record is also what you would say is what the common term is, like a court of record. You're basically saying it could be a traffic court, it could be a mortgage court, it could be admiralty. They're going to record the event that happened. So unless you say in this court of record at common law, or you say law, common, law, common, what type of law are we at? Are we in traffic law? Is this admiralty law? Is this natural law? Is this absolute law? What law is this? And law is just the customs and the practices of the people in society who agree to a certain terms and conditions to abide by. So when you go to traffic court, it's their law, it's their customs, it's their beliefs, it's their practices that you're standing in. This is where you're residing. So you're at that law at that particular moment in time.
Yeah.
But it's on the law. So just because you say it's a court of record, being recorded, but you have to expressly state that this is a court of record, and my belief, and is also backed up with Black's Law, 8th edition, 2004, operates only under the common law. There you go. You can say court of record, see Exhibit A, and then the judge flips Exhibit A. Well, according also not only my belief that it operates under the common law, which I have the right to have a trial by jury, and the magistrate is independent of the tribunal. It also established, well-established fact on Black's 8th, 2004, page 522, court of record.
Well, I can continue. When they put me on, when my ex-wife put me on the witness stand to examine me, she goes, well, I hear you're one of those sovereign citizens. Do you want to expand upon that? I said, well, there's no such thing as a sovereign citizen. You're either a sovereign or a citizen. I consider myself a sovereign. And the judge smiled at me. Right when I said that, he smiled. And I knew I owned that court right there at that moment. That was my court.
Well, what you did was not truly a court of record common law. What you did was you were doing a dance, the Dancing with the Stars and the judges and Simon Cowell, and Simon Cowell was giving you a thumbs up or thumbs down. In common law, that guy in a black robe has nothing to do with anything. You established a law. You're bringing the claim. All he's doing is witnessing that nobody brought a claim forward from the other side. And if somebody did bring the claim forward from the other side, then you're going to hold a trial.
Well, she didn't really bring anything. I had my affidavit. She had nothing else.
Well, then there was nothing for you to say until she puts it in writing and brings it and answers the claim. How did you even get to the point of a trial if she didn't answer?
Well, it was basically a summary judgment, and I just said, look, this. If I don't get what I want, and I said on the witness stand under oath, if I don't get what I want, we're going to jury. So that's all there is to it. And the judge smiled at me and winked, and he said, and basically right there, he said, "You're getting it."
Oh yeah, because that's fine. I was just trying to figure that out.
And you know what? If she would have demanded a trial by jury, she could have had it, because I declared it a court record. We're two combatants.
Well, whether you
not using swords, but we're combating in court, and a jury will decide. And she did not demand a jury. I got what I wanted.
Well, like I said, I wasn't there at the time, but like I said, obviously, did you file divorce? Or she filed for divorce? How did it go down?
Well, this was after the divorce. We'd already had custody settled at 50-50, and then she wanted more time.
Okay.
She wanted to take away time that we've already settled in court, signed by a magistrate, and she didn't. She disputed that later.
Okay, wait. Stop. You got to stop, because this is convoluted what you're saying here. You already had an agreement established, a 50-50 Bruce, between you and your wife, correct?
In the divorce, yes.
Yes. Okay, stop. What happened then is she wanted to
modify again.
She wanted to modify the order, you're saying?
Yes.
Okay, and she wanted 70% of the time, you're saying?
More like 90.
She wanted more 90. So where did she file that amended to request or a grant or whatever? Where did she move to court? What court did she move to amend the order?
The same district court that we had the magistrate.
When she wanted 90, okay, that's it. That's stop. It's fine. It's simple answers. When she wanted 90%, did she send you a proposal, or did she verbally say to you, "I'd like 90%"?
Well, she didn't say to me. She said to the court.
Okay, so no knowledge until you were summoned to appear in court that she would have liked more time with that child.
Well, she had verbally told me she wanted more time, and I said, no, I disagree.
Okay, that's fine. That's fine. I just need simple answers here. So when she made a proposal to you of 90%, you said that's unacceptable. I still want to stand by the original 50-50. Then she, I guess.
Okay. We signed on the divorce agreement.
Okay, it was 50-50. Right. Okay. So now, she wanted to modify that contract, right, or that agreement, right, or that order, right?
Yeah, and take it to, I get every other weekend or something like that. Like every other weekend.
Now stop right there. See, this is what I'm trying to help you, because what you did was way overkill. You did not have to do a damn thing. The answer would have been as simple. There is an order standing. It could be a foreign judgment order. It could be wherever she filed it. It could be she could have lived in another state. There is an outstanding order. At this time, I do not wish any third party intervene to modify, alter, or change the original order that was established in whatever year you got divorced, in 2002. I don't care what year it was. All you have to say is at this time, I do not see any benefit. It would not be beneficial for my person to alter or change, modify, to accommodate that person's wishes or demands. The order is to stand as it was written. It was written, let it be done. Period. There is nothing else to say. You don't have to go up on a court. You don't have to do court of record. You don't have to do none of this stuff. Nobody's allowed to.
Because she's filed again. She wants to take away some time again. And I'm thinking I'm just going to...
So now you go back to the original order, and you just show to whoever it believes they have the capacity to see and judge this and modify it. You just go back and say there is an outstanding order. I am not wasting, because if you open your mouth and you start saying sovereign citizen, say what? Third party impartial intervener.
Well, she started saying that when she had me on the witness stand, and I said, wait a second. A sovereign and a citizen is an oxymoron. Which do you claim that I am, a sovereign or a citizen?
What you do is you hold that order from 2002, the divorce decree, and you hold it in front of the judge's face, you hold it in front of her face. What does that say? 50%? What does that say? 50%. Do I want to renegotiate this order? No. Did you sign this order? Yes. Did you consent to this decree? Yes. I do not wish to amend, modify, or alter this document in one shape or form, and nobody on this planet can force me into a negotiation, and I'm not going to do it. And you keep saying it.
The original court was in error. And they can't be. They can't call themselves error.
She is the one who signed it. Her name is on it. She's bound by it. There's nothing you can do. You gave your word. That's nothing.
Her attorney and her signed it. I just signed it myself.
There you go. The deal is done. Let it be written. Let it be done. No more appeals. No rehearings. No redos. Go read the 7th Amendment. Go look at what Marcia Clark is kicking herself in the butt. If she found 10 witnesses now who saw OJ do it, she can't retry him. There's no rehearing. It's done. You had your day. Your trial is done. Now get the hell out of this building and leave me alone and get the victim all the time.
Get the hell out of the building. I like that.
It's simple. It's done.
So the original order, that's it?
There's nothing wrong with the original one.
That's it.
Right. Nobody can intervene in nobody can intervene in a contract. Nobody can intervene unless you...
It's a contract signed by her and her attorney and myself.
That's right.
And sealed by a magistrate in a court of record.
And we're done. It doesn't have to be fancy. It could be in a court of McDonald's. It could be in a court of the Happy Meal Park Plus. Again, it doesn't matter where the court was held. It's called a foreign jurisdiction. And me and Greg one night are going to talk about courts of foreign jurisdiction that are recognized every single place, no matter where you go in an English common law world.
In establishing the common law court of record, do you also have to establish your capacity as a man? I've got somebody attempting to trespass on my property, and they are also attempting to diminish my capacity as a man by alleging that I am either a natural person or a corporation.
That's wonderful. Who cares what he believes? You got to convince the jury. You don't got to convince anybody. You got to convince God and the jury. That's it. I don't give a rat's behind what anybody believes. If I believe in the Tooth Fairy and Santa Claus, if I believe I have to pay taxes, that's my belief. I just got to hope there's a crazy 12 people on that jury that have the same crazy beliefs I do.
Well, we're working on converting them all, right?
That's why it's kind of dangerous sometimes, because you don't know those 12 random people out in society believe your crazy beliefs. So sometimes it's great to go for the man in a black and white robe, because your word has just as much standing as the other person's word in that courtroom. And the man in a black robe or woman understands that, and the scales of justice have not been tipped one iota yet at this point. So until somebody can come forth with a contract, it's a draw. There's really nothing the man in the black robe can do. But with a jury, the jury's fun. They could take 50-50 and they could turn it 99-1. They could do all kinds of magic with your claim or his claim, and you could say, holy cow, how did they come up with such a crazy, that's what they believe. And that society was, I didn't realize I packed the jury with 12 Muslims. I forgot that they're doing Sharia law. Oh my God, I just got slaughtered. It's like, right, did you know what these people believed in before you let them judge you? So sometimes it's good to let the man or the woman in a black robe decide the matter, because it has to be expressly written into the contract. If your name is not expressly within that code or within that act, how could they hold you accountable to perform unless somehow the other side could prove that you are bound by those rules? Good luck.
Or you consented.
Right, because they said I consented. Well, look at this. Did you do? You seen me sign that? You know for a fact that's my signature. Were you witnessing to that? No. Good. You know what? I'm going to get you to file a false claim, Jim. Not Mr. U.S. Attorney. I'm going to get you, Jim. I'm not going after the Department of Justice, Jim. I'm going after you, Jim.
And I also wanted to thank you, Karl, for putting that Richard Cornforth info out there. It's I listened to the episodes that he had on there, and it was like a light bulb went off.
Right.
You know,
I said it was funny.
It's great videos.
Like I said, that Dallas Debt guy, him and his buddy, his sidekick on that show, was bashing me during the summertime about that silly nonsense. Now, almost every other word out of his mouth comes Trinzi versus Pagliaro. They said, holy crap, Karl was right.
Well, the 4 legs under the table makes perfect sense now.
There you go. It's a beautiful thing, man. I'm glad somebody else. I'm not an original thinker. I'm just grabbing it like some Richard Cornsforth, Clayton Cherry. I grab it from Winston Shroud. I grab it from Erwin Schiff and Leroy Schweitzer, and I grab it from everybody. Adam Smith. Locke. Kant. I grab it from everybody who's lived before us, and I just try to smash it into a little 1-sentence thing. Like,
well, I appreciate you getting out there on your own call and giving us all the time that we've asked for, and thanks for all the effort you put out there, Karl. I appreciate it. And
Greg is a good guy too, man. He helps me a lot on these calls because, like I said, usually my head is pounding this time of night.
Well, and Greg, I really enjoyed listening to him talk about definitions again, because I've learned a lot about the words that we use, and if you assume that they apply to you, well, then they apply to you. But
you're going to find out. What's your name?
This is Highball. This is Dallas from Texas.
Oh, hey, Dallas. If you really want to understand the mastery of the words, this is what I did, because I was getting clobbered in court. So I wrote a dictionary, and that's my thing. So when I'm not going to correct you from saying assumption to presumption, it's a huge difference in assumption. But it is all mastery of the language. If you know when you're going into a common law jury, you want to speak. They speak. You want to speak. If you realize a bunch of Spanish people or Mexicans or black people or white people or rich people or poor people, you want to speak their language. And they will not bicker with you the difference between an assumption and a presumption. One is going to cost you money, and one is just an error. There's a difference between looking something up and being held liable. That's assumption. And presumption means, well, I just made a boo-boo. Not going to cost me nothing now. So like I said, judges are listening for these magic words. So if you say something wrong, you better, if you don't think you got a mastery of the language to go before a black-robed one, you better go for a jury if you feel more comfortable with them, because they'll allow a lot of mistakes. A lot of mistakes in your pleading, your writings, all kinds of stuff. They'll accept a lot of errors. But a black-robed one, if he wants to get you, he's just waiting for you to say one little thing wrong. It's like when you said assumptions. Good. He's denied. You're like, what? Oh, don't worry about it. Thank God I'm out of this one. The judge, black-robed one, will say, oh, thank God he said assumption instead of presumption. Wow, I'm done. Thank the Lord, sweet Jesus. This guy almost had me. That's why I try to tell you folks, if you want to go in front of a Black Robe one and you think that he's going to look and ambush you, figure out a way to get it down to him in one sentence. And stay with that one sentence and don't wiggle, don't move, don't blink. Because he's trying to get you to say a word where you say, wow, I was able to protect all my buddies at the Bar Association. I was able to protect the state. Oh, my God, this guy really had me scared there for a minute because this one sentence claim I couldn't do anything with. There was no way out. He said assumption. It's like, oh, you made an assumption. Yes. Oh, thank God he made an assumption. We're out of here. Because he said, case, dismissed, D9, have a nice day. Like, what? What did I do? What did I say? He's not going to tell you. He said, next time you need competent counsel, go hire one. And you just missed it by one word. So like I said, that's why I say to you folks, be really careful and make your claims extremely short. 1-2 sentences, make your compensation maybe 1 sentence, 2 sentences long, and get out of there. And keep your mouth shut and just let the paperwork ride. Don't explain your paperwork to the Black Robe one. Explain it to the jury. They'll forgive you. The guy in the Black Robe's not going to forgive you. If he doesn't want to. If he doesn't want to. But then you opened your mouth. And you allowed him to make the judgment call. Say, oh boy, he's going to jump all over you. If he chooses to. Maybe he likes you. Maybe he doesn't. You know what I'm saying? I don't want to trust, some guy in the Black Robe. But it's between me and the state. I honestly, I'd rather take my, chances just with my words that I write down on paper and just let the paper ride. So just look, I placed my bet. I'm just going to let it ride. You want to explain your bet? Nope. You want to describe what kind of card you have in your hand? Nope. I'm all in. Just let it ride. And
well,
there you go.
Karl, if you're going in as a prosecutor, you're not the one that's going to be asking for a jury, right?
Oh, of course. If you're the prosecutor, you're going to be asking for a jury when the other side answers. If the other side doesn't answer, you're just going to get the marshal or the sheriff's department. You're going to drag that guy in. You're going to have him read the charges or read the bill in open court. There's going to be somebody from the court clerk's office, and they're going to witness that you presented your claim to this man in open court, and he shut his mouth, didn't say nothing. He refused to answer through the mail. He refused to answer in open court. It's done for all time. He can't come back and void that judgment because it didn't come by way of oath of affirmation in open court. It is recorded, it's pressed upon the record, and it's etched in stone. He can't come back and modify, alter it, or ask for a retrial because he had his day in court and he kept his mouth shut. It's done. But if he doesn't appear in court, if you just get a default or summary judgment against him, he can come back, his children can come back, his great-great-great-grandchildren can come back and reclaim his what he lost based upon a default judgment. So default that's something that I learned from Richard Cornforth was the boy's judgment. If there's no verified complaint or any witnesses or anything, then you can actually turn that judgment back. Right. There's tons of case law now. Right. Well, you don't need a lot of case law. He didn't say this, but I did a lot of research myself, and it's the Judiciary Act of 1791, Clause 31, which simply says it doesn't matter if the man dies in the middle of a hearing or a trial or a claim, his great-great-grandchildren can pick it up when they find the claim laying somewhere. And they could come and move a court, and they could prosecute the claim on behalf of the great-great-great-great-grandfather. So you don't have to use a lot of precedent. This is well established in law. You don't have to never use precedent. Never. You can use precedent as an exhibit, attach it to your claim, but never, ever put it in your claim. Oh, okay. That's all right. Cool. Yeah, it's not your words. It's somebody's opinion from 1776. It's not you didn't write the damn thing. You have no idea what he wrote. Like, I'm tired of these people say, well, let's reinterpret the Constitution and the Second Amendment. You see that comma there, a semicolon, a colon? See, this is what Thomas Jefferson meant. No, look, you know what? I don't give a rat's ass what he meant. You know what? Somebody's going to make a claim that by me carrying a gun is causing them harm? Well, no. Well, yes, it is. It's hurting my feelings. Okay. Show me the bill. Well, you had to go to a psychiatrist and you had to pay for a psychiatric therapy because of my carrying a handgun. Well, I don't have that. Well, then you don't have a claim. Leave me alone. And if you don't bring that claim, that's what I'm going to sue you. And I'm going to say you made a false claim, and now I'm coming after you for saying that by me carrying a gun caused you harm. And you can't prove that claim? Now I'm going to make a claim that you're filing a false claim and besmirching my good name and interfering with my rights. Not rights established by the Constitution, or rights because you believe that you could carry a bazooka on top of your head while singing Yankee Doodle Dandy on one foot. You could do whatever the hell you want. Not because some document says you could do it, because you say you could do it. Go ahead, Greg.
One of the reasons that lawyers always use precedent cases and citations is they are incapable of filing a claim when they're operating in the capacity of an attorney. They can only petition the court to request permission for them to give an order that they would otherwise be unable to get done. If they were showing up as a man, they could just make a claim. But because they can't actually claim the facts and law of a particular situation, they then go, well, here we have this circumstance in this little case here. And now if we go back to 1492, we see Columbus, and the boys ate their cabin boy. And then we come forward to, 1924, and we see that, the Rothschilds decided to crash the stock market and ate their cabin boy. And then we came over to, 1965, and we found that LBJ went out on his yacht and they ate their cabin boy. So we can find all these legal precedents to show that it's totally righteous and okay for you to eat your cabin boy. All right? And so now they're going to say, in light of the fact that all these other cases have been ruled that it was okay to eat a cabin boy, we petitioned the court, we begged the court, we moved the court to judge in our favor based on all that. In other words, they can't prove that it was all right for you to eat your cabin boy. So what do instead? They go and they find all the other people that ate the cabin boy so that they can say, okay, please give us permission to do this because we can't prove it. All right? And so all you're doing when you're trying to be a good lawyer and copy their strategy is you are copying their deficiency. All right? And you're falling into, they actually are operating from a position of deficiency, which is why they have to work so hard, and they have to come up with so much stuff, and they have to come up with so much research, and they have to do all this stuff, and have to be able to spin 16 plates on little sticks at the same time while whistling Yankee Doodle. They have to, because they're not there as a man making a claim.
They're in a diminished capacity.
They're in a diminished capacity, so they've got to go and come up with all this proof in order to get granted permission from the magistrate to say, okay, I guess that's so. But it still isn't proof.
I love it.
Right?
Thank you.
But you don't have to do that. But in the meantime, please don't eat your cabin boy.
I'm trying to quit.
Yeah, and that's the story of the Maginette. If you want to read that, that's where common law basically got all its precedent established in 1854, 74.
Great information. So just to throw something out there, if someone wants to take me to court and the attorney is the only one that shows up, he's got no verified claim, he's got no witnesses with first-hand knowledge, the next thing should be motion to dismiss for what?
Nope, you got to make sure in common law. I'm telling you, John.
Okay.
I'm telling you,
before you even go, your first response to a notice before suit is filed from whatever attorney it is, say, show me your evidence.
They don't need any evidence. Evidence is a waste of time.
Okay.
Evidence and facts is a total waste of time. All this, I hear a lot of these guys, like a Mark Stevens, screaming up and down about facts. Facts are irrelevant. Evidence is irrelevant. You want to see that man. You want to see that man that's caused you harm. First, you want to see if there's even a man. Is like I said, Paul going home went bananas on me because I was giving you guys the trick. Is there a claim that's been properly presented to court? Yes or no? As soon as you say that, only man can make a claim. And attorneys can't make a claim. The court can't hear any matter, see any evidence, see any facts, can't hear any witnesses, can't take any statements, don't care about statements of fact, don't care about anything in a file, any pictures, nothing. You got a proper claim filed before this court, yes or no? Now, all that other nonsense that you've been learning from all these other gurus, I just told you in one sentence, man. Everything else is done. That's all you have to say to the other side. I still have not yet to this date seen a proper claim filed before this court or any court. Please present me the claim that's been filed against me, my person, or my property. Thank you. And you're done. You just established everything. That's common law. That's it. There's facts. There's evidence. Do I have a code apply? It's all bull. Where's the claim that's been presented to the court? Has there been a claim properly filed before this court? I do not see yet at this time any proper claim. Please present your claim. Well, cease and desist immediately. If you're going to try to move a false claim against me, be prepared that I'm now preparing a case against you for filing a false claim. It's simple. Like I said, but these gurus ain't going to make a damn freaking dime on me telling you this. The attorneys ain't going to make a damn freaking dime if you guys start to learn this nonsense that I'm saying. It's done. This is simple.
Does that entail verified declarations? Are those claims?
Is there a proper claim filed before this court or any other court within this territory, this jurisdiction, or in this universe? Let it come forth now. And I will answer the claim, and I'll compensate the harm. And whatever meeting my person or property has done to cause the harm, I'll compensate and tender, and I'll render all, I'll settle all debts, settle or discharge all debts at this time. Make the claim known. I'll hang around here for 10 more minutes, and I'm going to hell home. That's it. That's how simple court is. How much money can I make doing that? So go ahead, guys, and keep rattling your brains and studying this stuff and all you want. I don't really care. I'm telling you, it's this simple. If you don't believe me, go ahead and just keep researching, keep filing all kinds of crazy stuff. I don't care. That's why Gordon Hall went bananas on me. He said, hey, you're showing the magic trick. You're showing how the rabbit came out of the hat. Don't do that, Carl. That's our bread and butter. Get this guy off the phone. He's a maniac. Yeah, that's right. It's like his buddy's like, well, Mr. Hall, that's a hell of a question. Why call the proceeding if there's no claim before the court? Get this maniac off my show.
Yeah, I enjoyed listening to that call, Carl, and I used to listen to Gordon a lot, but as soon as he belittled your trade of being a truck driver, I stopped. I couldn't handle it anymore. I didn't think he was. I didn't think he was like that, and it really made me sick. I mean, it just there's no need for that.
What I could tell Gordon is while I was a trailer driver traveling across the country delivering fruits and vegetables and poultry to all the people of the United States and fresh fish from Cape Cod up there in that area, Cape Ann, Cape May. While I was doing that, you were sitting in jail because you ripped off a whole bunch of little old ladies on Ponzi schemes, from real estate closes that you never had. You're a real estate developer, but the FBI said in their Department of Justice report that you were a paper developer, that you never picked up a brick in your life. So while I was out there doing his honest pay for an honest day's work, you were sitting in federal prison, buddy.
Amen, brother. I hear you.
I could have said that to him, but I didn't.
I think you held your composure very well. He lost it.
Oh yeah, well, I don't really want to say bad things about people, but right, that's how I could have done it, but I chose not to. I don't feel there was any, I don't need to explain to him where his failings in life is. That's not for me to judge him. But that's how I felt, but I kept it in me.
Well, the other thing, Karl, is, when you go into court and you say, okay, is there a proper claim filed before this court? And if they go, yes, you go, where's the man, who I've done harm? Where is he? Oh, he's not here. His lawyer's here. Well, that's fine. It's like, if the guy's not there, you tell the lawyer to shut up and sit down. Because you go, I'm here to answer a claim. You say this is a valid claim. I haven't seen it. But, this lawyer over here says there is one. But the guy who's prosecuting it isn't here. So guess what? I want this, I order this case to be discharged immediately without prejudice.
No.
Because it's never done this.
No, Greg, that's dishonorable. What you say is, maybe the man was incapacitated because he's a castaway on Gilligan's Island. He couldn't make it here. Or maybe he's in a coma, or maybe he got into an accident. But at this time, I want this proceeding to stay these proceedings until a man comes forward. And I want the case to be dismissed without prejudice. I'll leave this book open. It's unwritten, and it's not signed yet. It's not sealed. The deed isn't done. I will let any man come forward and make a claim. I will make a claim because I want to settle all debts honorably. So until that man comes forward, the book will not be sealed. And like most people say is 7 years or 10 years, that the court will stay a proceeding until you close the case and say, well, the man hasn't appeared. I guess he's lost at sea. I guess he's died. I guess he's given up. Then you could come back in 7 years or 10 years, whatever acceptable within your district or territory, your land or your county, your province or your country, whatever you want to call you people, whatever you want to call your area in which you squat upon, whatever acceptable, 7 years, 10 years, 2 years, whatever. And then you say, you know what, I don't want this brought up ever again. I want the book sealed. I want the case closed. I want the discharge. I want the claim to come to me, and I want to, you accept whole equity in that claim. So when you go there and then you say, I'm taking the claim. Release the claim to me. And now you take the claim, so it's forever. And then it's like you people see that Archie Bunker show that All in the Family where Archie burns his mortgage. Like, yeah, I finally paid it off. Right, he got rid of the claim. He got rid of any record that anybody could come forth ever and use this mortgage against them to try to obtain another dollar. You take the claim and you burn it. If you want to, you stick it on your mantle on your bookshelf somewhere. If you paid off a debt, you go back and take the claim. No, you don't.
I was trying to say basically that, Carl, okay, so it didn't come out right, that's fine, but the reason I was bringing it up was there are going to be some circumstances where you're going to go in there and do everything properly, and you're going to get a magistrate judge and his cohort lawyer that are going to just ignore you. They're going to say, no, we're just going to do this anyway. That's when you have to be able to be prepared with your or else.
Please explain, Greg, or else.
All right. In other words, if you say, is there a proper claim before this court? And they go, oh, no, well, there's a complaint over here that this guy has filed to this company. I said, is there a claim here before this court? And they say, well, there's this thing. I go, if there is no claim before this court, and there is no man that I've caused harm or injury, I move this proceeding be discharged. Now, if there's no claim, okay, in the previous scenario, Carl said, if there was a claim but the guy wasn't there, all right? Now, if there's no claim and there's just a complaint by, U.S. Bank or whoever, if there's no man to testify to come over there and say that, we did him harm and it's just a complaint, you order this thing to be discharged with prejudice, okay, because there is no man. There is no claim. It's just a bunch of lawyer bullshit. Now, I apologize for cussing. The point is that they will sometimes try to just railroad the thing through, even though they know and you know that they've got nothing to go on. All right? And at that point in time, you need to say, if you, Bob Smith, judge over there, or lawyer over here, try to take this any further, you are going to be personally liable, acting outside the capacity of your office, and I'm going to sue you and hold you directly liable, and it's going to cost you this much, period. All right? That's when you nail it right there. And then if they go, blah, 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 you're threatening the judge or whatever, it's like, who cares? All right? And if they try to go proceeding with the thing anyway, you just say, I order this thing discharged and dismissed. Discharged or dismissed, with prejudice. If you can't, and that's all you can do. And if they go ahead and they make a judgment against you, in spite of the fact that you just protested that and said that there was no case to go against you, you can then use that judgment as the evidence for a wrongdoing against you, and you can sue them in common law for that, in addition to the original thing that they brought that had no claim. Okay?
Gotcha.
Well, that's what we do, Carl, when they just move ahead. And I just gave them terms and conditions for me to appear to them, to fulfill their order to appear. And today they got my bill. And we'll see where it goes.
Did you send me your bill?
Not yet. Well, I did one. I didn't hear from you, and I had 2 or 3 other people review it. So it was in pretty good shape.
All right, yeah, if you want to just send it to me, and I'll tell you what they might or might not do.
Okay, I'll be more than happy to. I identified the terms that off of the stipulation off of the terms and conditions to appear. I appeared when they asked me to appear. Now they have to compensate me. My compensation was $1 per second from the inception of the situation, which went back to January 22nd. Well, it added up to a nice little tidy sum. And then I put another stipulation in that if they didn't answer the terms and conditions, that the ancient maxim of times 4 would kick in. Well, I got to quadruple the amount, and I noted it all in the front. So we'll see.
Okay.
I'll send it to you.
You're doing it a little bit, a lot different than I would have done it. But what I'm saying is They charge you with violations, misdemeanors, or felonies. What did they charge you with?
Misdemeanors.
Okay, misdemeanors they charged you with. Have those charges been settled, dismissed, discharged? You accept the equity?
No. Not yet.
Okay, folks. Like I said, I'll just do a simple one for you guys real quick here. The first thing you do before you demand compensation for the wrong, first you get rid of the wrong. You prove that beyond a shadow of a doubt that what these people did to you was wrong. You get that settled and you get it done. Then what you do is you go after the compensation.
Okay, I did that in declarations, and I did that in the terms and conditions.
Honestly,
in a verified declaration.
Honestly, I really don't know what a declaration is, and I don't know what verification of claims is. I don't really know what any of these words are that you just used. But if you believe in these words, if you believe they have merits, can I write a book about those things you just said? Oh, absolutely. But do I know what they mean? No, absolutely not. Because to me,
you have to know what they mean? No.
It's just way too complicated. It's just way too much. I'm just making a claim. Now, did I cause, is the man who claims that I did wrong, is he going to appear? Yes and no? No. Okay. Well, then all these charges that you got against me, well, now I'm going to take these charges that you burdened me with. You placed those burden of those charges. You put the charges on me, right? You charged me with them, right? You placed the burden on me. Good. Now I'm going to accept all equity. All the value that you wanted, what these charges are worth, now I'm going to establish what the burden was. I'm glad that this burden of putting this charge on you is worth $500 a day. Now I'm going to charge you. You filed a false claim. You burdened me with a false charge. You placed a charge on me, like electrical charge, and I've been carrying around this thing for weeks now, months. Yeah, I accepted the charge. But now you have to prove your charge. I was a good guy to accept that charge. Now you filed a false charge on me. I'm going to turn around, and I'm going to discharge it all over you. So like I said, you just go about it a different way. First, if somebody wants to place a charge on me, I was like, oh, lovely. You're going to hand me an order? Oh, good, lovely. That's how I make money. Oh, good, you're going to charge me? Oh, good.
That's what I did.
Charge it my debit card. Charge it my credit card. Charge it my debit card. I don't care. Charge it my gift card. Go ahead, charge it up. Get charged up. And if you can't prove it, you're going to pay the bill. I'm going to hand the bill to you. You're the one charging up this card. You charge up my credit card. You charge this. Oh, you want to charge up? Go ahead. Now what do you think I did? Oh, wonderful. You got to prove it. You got to prove that this charge is going to be true. Because when I find out, when I can prove that you bear a false witness and you filed false, and all of these charges are false charges, I'm going to place the burden on you, and I'm going to win in 2 seconds. So, like I said, I just make simple claims. If you want to make a claim, and like I said, where's the claim? Is there a proper claim to file before this court? Yes. Is that what you claim is a claim? Is you trying to place that claim up on me? Oh, lovely. I'll accept that claim. I'm going to show that the claim is false. And then when I prove that my claim is false, I'm going to charge you.
My whole issue was that they wanted me to come back in their room and appear again, and I asked them if it was their wish that they wanted me to take their order to come back and appear, and they said yes.
There you go.
And I said, oh, thank you very much. You have in your hand already my terms and conditions to appear.
Well, you could do that, but if they fail to ask, it's like I said, going to a fancy French restaurant, and they don't have no prices on it, and you just
I asked Carl.
I'm just saying to people who are listening to this call, if you go to a fancy French restaurant, and there's no prices on the menu, there's no fee schedule, and you just go in there ordering somebody about, and telling them, give me French Scampi, give me a bottle of Dom Perignon, give me this, and they come back with a bill for you for $20,000, $30,000. You're obligated to pay it.
Right.
So just because a judge orders you about, you say to the judge, is that your wish, Bob? Not judge. Is that your wish? Yeah, okay.
Yeah.
Bob, he's liable now to pay it. Did you have to present a fee schedule? Of course not. Did he ask? No. So guess what, Bob? You ordered me to do this. Guess what, Bob? Lovely. Wait till you see the freak. You don't say to him, you're saying in your mind, but I'm sure for a woman, it's hard for you to put it in paper and writing. It's hard to keep quiet. You say, oh, lovely, lovely. Wait till he sees my bill. He's going to swallow a pickle.
I know. I didn't really say a whole lot other than you wish to take my terms and conditions. You wish me to come back, and they said yes. I said, oh, well, thank you very much. You already have in your hand my terms and conditions to come back.
Right. Well, see, that's what I'm saying. That's what I would not do. If you're playing poker, you keep your cards close to you, and you don't keep saying, look, well, you want me to come back? Look, I already got an ace, a king, a queen, and a jack. You know, maybe, just maybe I have that 10. You know, you might get them a little nervous. I want them to think I'm a complete moron. I don't want to give them any fair warning that what's going to come from me. They're going to say, holy bananas, how the hell did this just happen? Who's the moron that let this guy through? So they get to lay your case for who knows how long. They could just like look at poor Tom Murphy. How long has he been dealing with this stuff now? 3, 4, 5, 6, 7. How many trials he's been to? They're just waiting for him to make one little mistake so they could violate his probation. Everything that he did gets thrown out. He goes back to square one and spends his entire time in jail, and no more probation, no more parole, no fucking nobody. He did not accept bail, whatever. They just keep going on and on forever. So to me, I'd rather say, is that your wish? Is that what you want to do? Good. You just keep doing what you're going to do, and just let them do what they're going to do. And then once you say, you know, like I said, then you spring it on them. When you prove beyond a shadow of a doubt that they had a false claim the whole time, there was nobody harmed here. There was nobody harmed by what I did. I already told you folks this was common law by just saying what? Bob, do you claim this? You know, Judge, what's the judge's name? Joe, do you claim this? You claim I broke the law? Prosecutor, Bob, you claim I did it? Oh, the officer's name is Sam? Sam, you claim I did this? Good. I got them all in common law because only man can make a claim. I said, you broke the law. I broke the law. Good. Now, Judge, you know the rules. You know law. Only man can make a claim. Where's the claim that's probably been submitted before this court? Did Sam, Bob, or Joe make a claim? No. Is there a claim before this court? No. And I'm going to get every single one liable. Every single one of you now are liable. You just committed perjury.
What I did was put most of that in my paper, Carl.
Right.
Rather than explaining it, I just put it all on the paper and said, you default. This is what it will be. Well, they defaulted.
But all I'm trying to say is, instead of telling a man that you're going to charge him for every minute, every second, every day, let him just keep running it up. Why? He's not asking you. He knows the rules. Ignorance of the law is no excuse. If he orders another man to do something, he's bound to pay the bill. So, you know, you can say, I order you to mow my lawn. Okay. You never bothered to tell me how much I was going to charge. You just told me to do it. What makes you think I can't demand compensation now after I did it? What do you think I was going to do it for free? What do you think you had jurisdiction over me? What do you think I could do over me? Is that what you presumed? Is that what you, well, not only you presumed, now you assumed it because now you're going to be liable for damages. So like I said, but if you don't establish the fact that you're a man or you're a woman and that you have rights and that you could not be ordered about by some sort of fictional code or some code that's not applicable to you, and they decide to do it anyway, then you could hand them a bill. But if you don't establish the fact that you're a man or a woman and that I was not operating a motorized vehicle under Washington State Code 1234. You know, I was just a man just traveling from point A to point B, and I didn't hurt nobody when I was doing what I was doing. So unless somebody's going to claim on, you got to back off with your frivolous claim, or I'm going to, or you say you better back off from moving with this frivolous claim against me. You don't have to say, oh, I'm going to demand compensation. You just say, I demand that you back off from this frivolous claim. You don't have to say, or else. Just say, demand it. If they don't, you really don't want them to back off because you want compensation. You say, well, I gave you fair warning. I told you back off. You know the rules. You don't back off. You don't cease and desist. Guess what? Here comes the demand for compensation now. How long have you been doing this to me? 3 years, 5 years, 11 years? God bless you. Because now when I get this before the jury is just going to eat you for lunch. Because I told you 10 years ago to stop, and you didn't stop. And when the jury says, well, why didn't you stop the first time she told you to stop? Well, you know, we just thought, well, I guess you thought wrong. And now you got to pay for all this time for messing with it. See, I just don't like to let too much out of the cat out of the bag. I just give them one sentence at a time. And I let them, hopefully, they just totally ignore me and say, this guy's writing gibberish. This doesn't even, this is like not even a complete sentence. This makes no sense. Okay, fine. You know, that's fine. I don't care what you say. I'm gonna move this before a trial by jury. And I'm going to bring you in, Bob, Sam, and Joe, not prosecutor, and not officer, not judge. You guys all know the rules. You all know the law. You knew what common law is. You're supposed to know it's the premier, the number one law of this land. You all know how this country operates. It says they're right in the U.S. court website. All state courts are common law courts. You all know every place we're standing in this country, if I'm in some court or state, every courts within that state are common law courts. And you can subdivide them from there. It's just like what I say to people, property. Everything I claim is property to my person is my property, which means my rights, my children, my car, my spoon, my clothes, my dreams, my hopes. They're all subdivisions of or subsets of my rights. It's the same thing when you say all state courts are common law courts. They all start at the top of the pyramid as common law. Then they can break down to admiralty, maritime, any other kind of law you guys want to use. That's fine. They could flip their hats on and change courts, change the law at a flip of a hat if they want to. And even though you try to move under common law, you folks try to sneak in some statutes every now and then and get you guys in trouble. So then it just took you down from the top of the pyramid down to a statute, or you used a precedent and it took you down to, or it took an act of Congress, 1802, and it dropped you down into that act. It took you from the top of the pyramid and you're slowly knocking yourselves down further and further and further. Or UCC and stuff, that's really dropping you down near the bottom. So like I said to you folks, man, is just make one simple, plain statement lines, but it's so hard for you guys to control yourselves because it seems like the more you write, you believe people are going to be impressed because, especially you, Maria Janet, you were a school teacher. If I wrote a paper, my paper would have been one sentence long. You would have given me a big fat F with a big old sad face on it. Some kid would have walked in with 10 pages, 500 words or more, like you told him to do, and he would have done it. And you would have given a big A+ and a happy face. But my paper said E = MC squared. My name was Albert Einstein. But you know what? His teacher gave him an F- because he did it in, 5 or 6 letters or less. But she said she demanded 1,000 words or more to get the big happy goals. That's what they trained you people to believe, that more is impressive, that less is a joke.
Yeah. No, in my school, you had to work the apparatus. You had to show me you could do it.
Right, but E = MC squared, I guarantee Albert Einstein's math teacher rolled up the ball, popped it off his head, and gave him an F.
Oh, I'm sure they did.
Yeah, and said you get 10,000 pages or more, or we're going to flunk you out of school. Doesn't cut it for
I was such a different teacher.
Right.
I didn't do any.
What I'm saying, when you go to court, you write E = MC squared and stop. And don't explain what E = MC squared. It's none of their damn business. It's only between you and the jury and the other side. The guys in the black robe and the prosecuting attorney say it has nothing to do with them. It only has to do with the person that you're moving in court or they're moving you. They know what E = MC squared is, because if they didn't know what E = MC squared means, they wouldn't have been communicating with you. So, like I said, incredibly simple, one sentence. The other side know what they did wrong. Say, Bob, pay me back $500 because you did me wrong. Now, if Bob's the prosecuting attorney or the sheriff or the guy in court or the judge, say, Bob, pay me $500. He knows what he did wrong. He moved in a capacity in which he wasn't permitted to do as a judge or as a cop or as a state prosecutor. If you want to say, well, Bob, pay me $500 because you did this, you want to write a freaking book about it, you're wasting your time. Bob knows what he did wrong to you. He knows exactly what he did wrong to you. Now, could Bob make a statement of facts or like a billing statement? Why you believe you should be paid $500 from Bob? A little bit of a story. A little bit. You don't have to. You can say, no, Bob, you know and I know what you did. You know what? I'll see you in front of the jury.
Yeah.
And there you go.
I think that's why they set my hearing outside of the speedy trial, so they could get rid of it.
They set it up as a speedy trial?
They set the next hearing outside of the speedy trial rules.
They could do that. What I would do if I was them, I would just I'd let the statute of limitations run out on the charges against you and just let it drop.
Well, I think that's what they're doing.
That's what they're going to do. They're going to let the 2 years of limit. Like Canada, it's 6 months, and the United States, it's usually 2 years for them to prosecute a wrong. And they're just going to say the judge couldn't make it. The judge had a death in the family, whatever. Because until you make your own case, all this stuff that you're filing in their case is going to be totally ignored.
Mm-hmm.
It's going to be totally ignored. They don't see it. You're just packing it in the sausage. You're just getting lost in the ingredients. They don't see it. You're just stinking up their case. And like, man, this lady's really stinking up a case of sausage. She's making it stink. You know what? Just let it rot.
Still can't make a claim or answer my claim.
But you haven't filed your own case yet. You haven't filed a lawsuit against them yet. You haven't filed a case
Oh,
against them.
no, I need to do that.
Right, so everything that you're doing right now is good practice, which is fine. It's keeping your mind busy, learning a lot. That's fine. You're making a lot of mistakes. Good. Making mistakes in their case. That's fine. You know, because, you know, it's not going to go anywhere. So, but at least you're learning. And you'll get better as time goes on.
Well, this would be the fourth time I will beat this charge that they tried to put on me.
Big deal. You know, the charges ain't nothing. You know, the charges, it's you want to get compensation.
Mm-hmm.
You know, I want compensation.
You're right. That's right.
Right. So what I would do immediately, as soon as I know somebody charges me with something, I'm going to accept the charges and say, oh, lovely, this is how I get it. This is how I get paid. You know, and now you're going to burden me with this. Oh, good. So now I'm going to show that your charges are false charges. So now I'm going to claim compensation due to your false charges. See, Mr. Gordon Hall used to do it a little bit different. Mr. Gordon Hall would tell you to accept the charges and plead guilty and settle it by paying, discharging the debt or setting it off or giving a $2 million side draft. Not me. Oh, you want me to accept those charges? Oh, yeah, I'll accept those charges, all right, but you better be, that better be dead on. Because when I prove that those are false charges, I'm going to say, well, you burdened me with those charges. You know, that wasn't easy and that wasn't a light burden to carry. Guess what? I'm going to demand compensation for you placing a false charge on me. You burdened me with something that was false. I knew from day one it was false, but you know what? I'm not going to make any money by not accepting the charges. So you know what? I'll accept that order, Judge. Is that what you wanted me to do? Good, lovely. And then I'm going to show that he placed a burden on me that I should not have been placed, that burden. He placed the order. He made the order for 10,000 Happy Meals. He's going to pay it. He made the order. He's going to pay for it. And there you go. Like I said to you guys, I said I looked at the federal court site, and all these judges and all the people within the court system, they all are insured, and they're all recommended to carry their own private insurance when they interfere with constitutional, statutory, or civil rights of the people that come before them. Because they will be sued one day in their personal capacity, and they will have to pay out of their own pockets. I got it right off the federal court website. How they should go about if they don't believe they're carrying that the United States covers them under their insurance company, that they should go out if they have millionaire judges or billionaire judges, that they should go out and obtain their own private insurance in case that they don't believe they're going to be compensated or covered, indemnified under the government's policy. So it's simple. They all know what they're doing. They're not stupid people. They all know what's going on.
Yeah, if the government officials won't let you file your claim, then what do you do?
Oh, they cannot let you file a claim. All you do is mail your claim into the court, and you could explain in like a nice little letter saying, as far as I know, this is a public building, and everybody has the right to access this public building, and you believe there is a court clerk assigned to this building, and the court clerk is to accept all filings, and you expect the court clerk to carry out their duty and obligation to perform their job in which they have been assigned. There you go. Thank God this thing's recorded. I ain't got to say it again. So there you go.
That was a good one. I like it. It's a good idea.
And you mail it. And you mail it. And you mail it. Well, you mail it to them. You don't go there, because if you go there, they could give you a razzle dazzle. But if you live in a big enough county, because you said Northeast Ohio, so who knows, it could be like Akron or something like that.
There's a couple counties over east, Columbia County.
Well, I'm saying if you live in a big enough county, you could say to the lady, you could walk into any county courthouse if it's a big enough county, and you could just say, I don't care if it's a family court building you're walking to, a traffic court building. You could just say, is this a county courthouse? What do you do? Oh, traffic. Oh, yeah, I really don't have the time to go across town here. Just take my my paperwork and send it over to the other side for me if you can, will you? And they will. Or spend $2 and send it to certified mail. Don't spend $20 on register. Just do the $2 certified and get a green card. It proves that you submitted it to them. Okay, so what's the next thing you wanted to say?
Next question was enforcement of your claim. Are you putting anything in after you've done your claim, like if maybe some UCC file, or I'm not with the UCC. A guy could say, like, if you don't allow me to enforce my claim, then I would maybe do a public notice on you or something like that, which would be a UCC filing. something like that on the bottom end of your claim? Would something like that? Are you thinking that way too, or?
No, because that system's too simple. All you have to do is file your claim. Like I said, once the clerk of the court lady has the claim, and you create a summons for them to appear. And summons is kind of a tricky word, because summons means that somebody's granting you power to drag somebody else in off the street. Like, you just don't have the power to grab people off the street unless he's causing you harm at that particular moment of time. So if he's hurting you at that particular moment of time, you have every right to put your hands on him. But if he's not hurting you like an imminent danger or threat, you don't have the right to put your hands on him. So you have to summons him to appear. And then the clerk of the court, see, that's where you have to get kind of be happy with the clerk of the court, because for her to issue that summons, she's actually has she's going to turn that summons over to the sheriff's department, and a deputy is actually going to touch somebody and drag them into that building for you. So that's why you kind of want to work nice with these court clerk ladies. I mean, you kind of got to put them, back on their heels and say to them, with like I said, what I first said earlier about how you get the paperwork just to be filed, and then once it's filed, then you go for the summons to have the person appear, and then everybody already knows. With the default judgment kind of thing, I still want them summons to appear. I don't want them to win by default, and I don't want to win by a summary judgment. I want to win by that person being dragged into that building. And now they're standing in, my name's Karl Lentz, I want them standing in the Lentz court. And I'm telling them for the last time, you're either going to answer me or settle this matter, or we're going to let the jury render its verdict down upon you. And then it's done for all time. There's no appeal, there's no void judgment, there isn't a dog, is like sick in the hospital, or none of that nonsense. It's over. So I'm still going to want them to summons them to appear. If they don't appear, I'm going to tell the sheriff to find that guy and drag him into this building so he could hear it out loud. I'm going to read and press it upon the record in open court under oath or affirmation. And it's going to be done for all time.
Okay, and the other thing that says is maybe it's sort of a...
Well, wait a second. Hang on a second, because you asked me about how you enforce it. So once it's been witnessed by somebody that the court clerk assigns, somebody in a black robe, she's going to sign that person or that man. It could be a file clerk who witnesses it, especially if they know there's really nothing going to be going on. They have temporary judges. They have people who just, like, hey, they could call up across the street who's an attorney and say, hey, we need you to come over here and sit on this thing for us real quick. Like being a magistrate. They call her a magistrate at 2 o'clock in the morning. She's also the school bus driver. She's also a school cafeteria nurse lady, and she's a magistrate at 2 o'clock in the morning. So it's just different hats they wear. So it's like, hey, we just need you to sit on this case because nothing's really going to happen anyway. So that's what I'm trying to say. So then all you're doing then is the jury's going to hand down their verdict. You're going to hand it to whoever the clerk assigns to sit to hear witness of what's going on. And if you take a look at any standard like court orders, you'll see it says like witnessed by, and usually a judge signs that, and then underneath it, the court clerk signs her name, and she puts the seal of the court on it, and that's your judgment. And then that judgment you could stick on your fireplace on your mantle, look at it forever, or you could go down to the county sheriff's department, you do a writ of attachment, and then you could tell him what you want him to seize. And then you tell the clerk of the court, once you get the judgment, well, like I said, I'll skip the step. Once you get the judgment, then you could file for a writ of attachment. And then the clerk of the court, she will stamp it and say that there's been a judgment against you for, 50 cattle. And then say the clerk of the court witnessed that, that one of its, somebody that they delegated to hear the matter witnessed it go down in court. Now that they got the judgment for what the jury said, okay, 50 cattle is to go back in this man's hands, what will happen is then the judge, you go to the clerk, I want a writ of attachment, and I want the sheriff assigned the matter of collecting the property. If it's not 50 cattle, say it's $50,000, what the sheriff will do, if they have a writ of attachment and they have a warrant for the debt, what they will do is they will go onto that person's property and they will take every single thing off that person's property They'll take everything, and they'll put it in, auction it off until that $50,000 debt is, back to you until that judgment is satisfied. So that's the enforcement part. So it's the sheriff's department that does the enforcement for you. They're the posse.
Yeah.
So now you go to the third question.
Well, the third question was sort of like I said, was using some maxims of law. I thought that might be because they're real short. If you really look at maxims, there's like 3 or 4 words. That's it. Like exactly what you're saying, but just use your that's what I was thinking. I mean, just an idea. It's put across my mind, but it doesn't have to be. But I kind of like it too.
Oh yeah, I love the maxims in law like that. But it's so funny. Like you got to be careful with any kind of maxim. It's because there's always a yes and a no, because you've always heard that maxim, like he who hesitates is lost. But then in the same breath is, look before you leap. So which one is it? Should I look before I leap? Who hesitates? Well, I should just jump.
Yeah.
So the whole trick, what I tell people, it's not so much the maxims, it's just the way our great-grandpappy used to pass things on real quickly to us. And they gave us these little maxims to live by. But it all depends on what is the time, the situation, and what is going on in that particular moment in your existence on this planet. So he was just giving you some advice. You don't have to do it to the letter. It's like when you say, oh, look at the Constitution says this, and the Constitution. No. That's just really, really good advice that people 2, 3, 4, 500, 5,000 years ago wrote. But obviously, you're going to take and choose what you want from it. It's like a menu. I'll take that advice. I don't need that. Forget about Section 3. Who needs Section 7? I don't care about that. I'm going to live my life based upon these 3 sections. I'm done. Okay, so you got this case that you're creating. It's taken you guys years and years to write this stuff. And you guys got this suit written inside of the case, and you got all the exhibits and evidence, and oh boy, you got your little statutes and UCCs all lined up, and oh, that's right next to this, like packing a suitcase. It's like a shaving kit. You got your accoutrements, like you got your neckties, your bow ties. Oh boy, look at this snazzy rings I got. And you're packing it all in your case, and you're going to take a little trip to this far-off venue called court. Well, you're going to take this little trip to a far-off venue called Saudi Arabia. So you got everything all packed up. And I said, this, of course, was a woman. I said, so you got it all packed. Now you're going to Saudi Arabia. First thing you do, you step off onto the soil of Saudi Arabia. You shake somebody's hand. You say, hi, how you doing? And you're going to jail. Next thing you know, you're sitting in a Great Ball Motel in Dubai somewhere. I said, because just because your case was packed beautifully, and just because you had everything in your case perfect, when you walked into that venue, as soon as you opened your mouth and extended your hand and you weren't wearing your burqa, you went straight to jail. Even though you planned this trip to Saudi Arabia your whole freaking life, you didn't know how to act when you got there. You packed your case great. Oh, you had your suntan lotion for 120-degree weather. Oh, you had your 10 bottles of water from dehydrated. Oh, yeah. But you didn't know how to act when you walked amongst the people there, their laws and their customs and their practices. So this is what happens when you guys walk to court. You guys work all this time on packing this lovely, beautiful case, and you spend zero time saying, well, now what happens when I walk into court? Well, you're going to open your mouth, and 2 seconds later, the bailiff's got you, and they're dragging you off to jail for contempt of court or psych evaluations. Okay? Does it kind of make sense?
Yeah. I mean, keep your mouth shut. You're in court.
Yeah. Well, that's what I'm saying. It kind of makes sense that you mastered packing a case. Oh, I'm telling you, you packed a case like you got no business. Nobody. You're the best case packer in the world. Okay, now you just walked into this strange venue, and you told that out of protocol, you had no idea what you were doing. You just opened your mouth. You just thought you said hello when you were shaking everybody's hand. Next thing you know, you're sitting in the Grey Ball Motel for contempt of court, and at the mercy of the judge, she's going to let you out or not.
I am trying to get access to a court of record common law in the federal district court. And I received a couple days ago a notice, which is very apparent to me that they have reclassified me as a plaintiff and the other people as defendants. And it's minutes of the court, minute order in chambers, So even though I have put 2 written documents in to switch it over, they're still not doing so.
Documents in.
I'm sorry?
What 2 documents did you put in? And just because you don't see it doesn't mean it's not there. Just because you don't see it on PACER doesn't mean that it's that matter of being moved over to the right side of the court. The clerk's aware of it. You're saying you don't see it on PACER? Is that what you're saying?
No, I'm saying that according to this document I received from the court, United States District Court instead of Federal District Court, it's got minutes of the court. It has us classified instead of as claimants as plaintiffs, instead of them as respondents as defendants, and it has the judge, the clerk, and I don't need a judge. Okay, I'm just asking them to be able to do my summons, and I've asked them to correct it from this administrative side of the court over to the common law court of record, and they're not doing it.
What makes you think they're not doing it?
Because they're classifying us as plaintiffs and defendants, which is not the case.
Well, what I'm saying, whether they call you an apple or banana, you're still a man or a woman. What I'm saying to you, what are you trying to move through this court?
I'm trying to move a claim for our land and for them, our land and home, for them to take their hands off it. They're still trying to take it. We had sheriffs here again on Monday, and they are just ignoring the fact that we have quiet title in a different court and by other processes, and continuing to move against us physically as well as against our property. And the claim is that we hold a quiet title claim established by verified court, public, and published record to the private land and house, and that they have caused us removal under threat, duress, and coercion, and breaking clothes via forceful entry and removal by eviction, evidencing trespass and bad faith.
Well, let me try to catch up a little bit. What's going on here? What's going on is that you're trying to move a paper world into a common law court, right?
A paper world? I'm sorry?
You're trying to move your paper world into a common law court, right?
Not necessarily.
You're saying the common law. Okay, if the common law is basically unspoken, it's basically unwritten. Okay, it's basically what's customary to the people within your community. Okay, let me make it simple. Instead of saying the quiet title and all that stuff, I'm not even going down there.
Okay.
Say, does everybody in this community know that I live here on this farm? Like when I first moved here, a couple of months after, the deputy just knocked on the door, and I let him walk around the house and in the house, and I guess you just hi, meet and greet. But he's probably trying to figure out who's this crazy guy with all these dogs and cats running around up on top of this mountain. Is he making crystal meth in here, growing pot? What is he? What's he doing? So I let him walk around the house and just like neighborly, hi, how you doing? Now everybody knows, it's a well-established fact that this guy lives here and who I am. Okay? So see, that's more law. So now when I move court, I say, and somebody like a bank wants to say that this mountain or this farm where I live on, it's ours. I can move it into a common law trial by jury and say, who lives here? They say, oh, you do, Carl. There you go. Has anybody else ever lived here but me? He's like, well, yeah, I guess about 40, 50 years ago. I'm like, okay. There you go. Well, now you're trying to do, but see, what you're trying to do is you're trying to get the best of both worlds. What you're trying to do is you're trying to use their written laws and their documents and their procedures that all these lawyers established and all these governments and all these officials established, and now you're trying to drag it into a common law court. It's not common law. You're dragging in their statute world into a common law court. Now you're going to diminish your common law standing into that of a statute. It's written. You're following a qualified procedure. You're following all these procedures, boom, 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 that somebody else established. That's not just like Granny and the Beverly Hillbillies walking in and saying, that's my damn mountain. I've been there my whole life. Everybody knows me around here. It's my great-grandpappy's. That's common law. Anybody else who wants to, because everybody knows that 99% of the land on this planet right now has been now claimed under a land patent scheme by title companies and banks. So now every piece of planet basically on planet Earth has now got a land patent. See, this is how Granny Beverly Hillbillies would destroy these clowns. Thank God we got a common law country. She'd say, my great-grandpappy, I don't care what title company in Brussels or the UN or the United Nations or even in my state capital. I don't care what quiet title they made. I don't care what piece of paper they got land patent. Oh, it's called land patents, but you guys call it patents. So I'll call it patents to help you guys out, but it's really called land patents. If you want to play this nonsense with these people, and they believe like, well, now all of a sudden we're the banks and we're going to make, well, every property on the planet is now going to be called land patents, and we're going to claim everything as ours. All you need is one little old lady like Granny in Beverly Hills who says, I don't know nothing about no damn land patents and all that silly quiet town, but what I do know is this is my land. And everybody knows that I've lived here, my pappy lived there, and I don't know nobody, nothing. If somebody claims I own something, well, hell, let them come in this court and make their claim. There you go. Is that man going to appear in court? Lawyers can't appear in the common law court of record. Granny's going to be a slam dunk. And all you guys are going to be like, oh, my God, how did Granny win? What do you mean, how did Granny win? You're going to say she's an idiot. Yeah, she is. She's an idiot like me. She knows to not get involved with this crazy Looney Tune world of theirs. That's an idiot doesn't mean that. It just means you're incompetent. You have no standing, that you're not competent in a certain thing. And I'm not competent in this silly, land patent schemes that they got going on now. You guys just got done with some mortgage scheme that took everybody's house under. Now you guys are going to involve in some land patent scheme that the banks around the world are going to get you guys all involved in. It's just one scheme after another. And all you need is a normal common lady like Granny who just says, this is my land, and I'll drag you into any court, and I'll like to see you try to get me off of my land, and she's going to win. If you hold it in common law. If you hold it in their world, you're going to lose. So like I said, do you want to just get down like little old lady Granny and say, I'll drag you into any court here, and I'd love to see you take me off my land. I'd love to see an attorney testify. He doesn't know who's been here. That attorney doesn't know that grandpappy dug the first well here, and, everybody came to town. And no, he doesn't know anything. All he has is a piece of paper that says the bank is claiming that. That piece of paper is forgery. That piece of paper I want to wipe my butt with. Granny would go nuts. She said, that piece of paper, she'd spit on it. She says, I don't care about your paper. This is a common law land. There is no such thing as like paper in a common law land. But you guys want to keep trying to drag paper and then in the same breath say it's common law. Okay, which one is it? English common law has tons of papers. English common law, yes, is a paper land. Not America. Well, not where I live. Not the United States of America.
Mm-hmm.
It's no paper here. So you people are getting wrapped up in this paper. And that's why I always say to you guys, why do you think that Trinzi versus Pagliaro case, a real estate thing about land, that no attorney ever came forward? The judge gave the judgment to like the bank. And then so the guy reminded him, hey, did any man come forward and make a claim for that land? No, a lawyer for the bank did. So the Supreme Court overturned him. So like I said, if you want to really understand my stuff, well, quiet title and all that other stuff, you want to talk about it for hours and deeds and absolute deeds and continual deeds? Oh yeah, I could talk about deeds all day. A big deal. It's a paper world. And they're going to always have some way in paper to beat your piece of paper. There's one piece of paper on top of another. I want to say, you know what? Stop all this paper because they're burying us with paper. There's one scheme, Ponzi scheme after another scheme. You got to stop. These people don't want to work for a living. They just want to keep pushing paper around while hard, decent working people are sweating and breaking their butt to make an income. And these guys are pushing the paper world around on us. All you have to do is say, thank God, man, these people back in the 1776-ish decided to make a simple constitution that we could all abide by. It says that, this land is a common law land. And no bank is allowed to own land in this country. That's a guarantee because the land and the people were the same thing. Your mama ate the grass and the berries and the roots and the potatoes that came from the land. Without the land, you would not be here. You would not exist. The banks can't own people. We, the people and the land, were one. The king and the land are one. The king and his people are one. The king represents us. We are the king. We are the clay. God got Adam from where? The soil. He took a bunch of clay and he breathed life into Adam. We're from the land. These banks can't take our land with a piece of paper. People forgot the Bible. Say, hey, wait a second. And I'm not a Bible thumper here. You never hear me going off Bible, but I can if you guys want me to, but I don't want them. There's plenty of other guys that do that nonsense. But this is where all our laws come from in this country. This country existed 300 years before the Constitution. People don't forget that there was 300 years worth of law established in this country based upon people like pilgrims who just wanted to come here and be left the hell alone. So we were here in, like, what, 1500 when the Constitution was signed, what, 1800? That's 300 years of people living here, trying to sweat it out and struggle it out and realize, hey, you know what, we don't want banks from Europe taking our stuff. We don't want anybody, trespassing on us anymore. This is our land. And they said in 1800, well, let's put it in a piece of paper once and for all and sign it. And there you go. And now we can rely upon that. We got it right. If the amount of controversy were $20, and we could do it for a trial by jury, and we get all the little old ladies in our community to sit on a jury and say those bankers got to go, and those bankers got to go. And there's no court in the United States that could overturn, rehear, or retry the trial by jury under the common law. That's the 7th Amendment. Well, they call it the Article 9, but don't worry about it. You guys just, 7th Amendment. The first two articles weren't ratified, but that's silly. But don't worry about that.
I have tried to claim that we have been denied due process, twice denied trial by jury per Article 7 in the Bill of Rights.
Well,
and yet,
how do you believe you were denied due process?
Because I demanded and paid for a trial by jury in 2 different courts, and I never received it.
And when they didn't give it to you, did you sue the clerk of the court, and did you sue the chief judge for interfering with your rights to convene a trial by jury in a public building? You denied access to a public building. Did you sue those people who denied you access to the public building?
No, I did not.
There you go. Start there. Sue them. Sue them for interfering with your right to access a public building. Just because you weren't wearing a suit and a tie, you could go in that public library. Just because you weren't wearing a suit and a tie, or you wanted to wear a hat, didn't mean they could kick you out of the library. Just because you weren't wearing a suit, a tie, and a hat, doesn't mean they could kick you out of a public courthouse. They can't do it. So, you guys got to start putting these people back on their heels and saying, hey, you want to start messing with us? We're going to start messing back. We're going to start suing you.
Well, I don't mind adding the unlawful detainer judge to my suit. I have the head of Fannie Mae on it, but that's going to be a difficult person to serve. The attorney is 450 miles away because our state is so large, so that summons is going to be difficult as well. And then the local person that I'm getting the we're getting the slack from to accompany the sheriffs out and kick us out twice now, going on 3 times, going on 4 times, is a local realtor. And of course, the people that she's hiring to come catalog our stuff so they can sell it off. Right. And so I'm in a push-to-shove situation here. I feel like I'm not getting access to the common law court in the federal district court, and I was looking for them to actually sign an injunction order to protect us against this sort of nonsense, and that, of course, has not been forthcoming either. And
the problem is, like I said a million times, you guys are trying to play attorney. You're using words like injunction. You're using words like quiet title.
Yeah.
If you want to think that you can outsmart these people by using their words, you're going to get clobbered. Okay? This is what I'm trying to say. You can master this stuff for the next 500 years, and you are still going to lose. You got to stop using their words, and you got to start understanding how to, because you can see the inevitable is coming. No matter what you're trying to do, you realize you're not Donald Trump. You realize you're not a billionaire, and you realize you're going to lose. The Trump that your great-grandfather gave you was a common law court of record. And if anybody interferes with that right, whether it's a constitutional right, a statutory right, or a common law right, every single person in that courthouse understands that you can sue them and take all of their stuff away, all their personal belongings away. You could take the court clerk's house, a car, a paycheck, a pension. You can take everything from her, and so does that judge. They all understand it. I have the court memo that says if you don't believe that we're providing you with enough coverage to protect yourselves from suits when people say and sue you for interfering with their statute, constitutional common law rights, you may provide your own private insurance to cover you when you're going to be sued. And you will be sued eventually by somebody when somebody claims that you interfere with their rights by accessing this court. They're going to sue you, and they have the right to sue you. And if you lose, we recommend that you get private insurance because we'll only cover you for whatever X amount of dollars.
Mm-hmm.
All know they could be sued. They're not dumb. They all know they could be sued. So everybody, you guys could be all saying, well, you know, who's going to hear them out of blah, 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 blah. There's settlements all the time. You hear lawsuit settlements all the time. If the lawyers were just running wild through this country, every single person would lose, and there would be no such thing as a settlement. They'll make a settlement. So like I said, it's just that people you're trying to mix both worlds. You're trying to mix a statutory world with a common law world. You're trying to mix them both. And what's going to happen is, like I say to people, is just make it simple. Say I'm a man. I'm making a claim. I'm a man. I'm making a claim. Then I'm going to say I'm a man, Karl Lentz. Well, okay, he's saying that he's a man, Karl Lentz. Okay, so he's probably German. Okay, and he's a dad, probably, and son. Okay, I just diminished myself from being a man. Then I said I'm a citizen of Virginia. Okay, there you go. So now he's not just like this man who, you know, the greatest man on the world. Now he's a guy in Virginia, in a little county called Rockbridge, in a city called Dent. And I happen to be residing now in a penitentiary. So I went from being at the highest status position I could possibly be in law, a man, and I diminished my capacity by saying I'm an inmate in a correctional facility. So now I'm basically saying that I'm a ward of a state, and I basically have no rights because I did somebody wrong. Why in God's name would I keep dropping my status down? I keep putting all these more words and words on top of me and all this paperwork on top of me. Why don't I just say I'm a man and you're doing me wrong and I order you to stop? There you go. And that's the whole beauty of a common law trial by jury. That you just convene your neighbors, you get 12 people to seat there and say, you got to stop them from doing it. Now we'll get the sheriff's ass after you and he's got a posse behind him and you ain't coming into our damn county. We don't give a damn what bank you are. We don't give a damn what federal government you are. The sheriff says you ain't coming across. You ain't coming across. Everybody knows how wonderful the sheriff stuff is. You just got to get...
They use the sheriff to kick us out twice.
Because you're playing lawyer. And he has to do it. He has no choice. If he doesn't execute that judgment or that warrant, you could turn around, the bank is going to turn around and sue that sheriff, and they're going to personally take the sheriff's house and the sheriff's car and the sheriff's pension and the sheriff's paycheck. If he doesn't do what the bank got an order or a judgment from a court, he's going to be liened, and he's going to have his house stripped down. That's what's going to happen to him. It's nothing. You're doing it because you don't know how to hold a court. Like this poor lady from Canada. I was hoping she was going to come on tonight and explain to you people, you know, what happened to her in court. And she just couldn't hold court. That's all the problem was, that she couldn't hold it. But Greg's on the phone, so that's good, because Greg's a good talker. And I'm trying to say I can't find that lady from Canada on the board.
Mm-hmm.
And but Greg, you want to try to help her a little bit here, man?
Hello?
Greg, well, I'm just asking Greg to unmute himself. Because he's going through bank foreclosures. He's got his house doing the old foreclosure. He's got a couple of days before, you know, they're going to drop the hammer on him. So that's why I try to get Greg to come on and talk to you folks. And because he'll tell you his stuff that he did exactly what you're doing, and then he's trying to mix it with my stuff. So he took your method as far as he could, and it crashed. Now he's trying to mix the both and see if he could get something coming out of it. So maybe he could tell you.
Well, that's not exactly correct. I'm not trying to mix the both.
Isn't it both?
The way that I explained it to one of our friends up here that was also helping with the administrative process was the way I look at it now, and you know, hats off to Karl for helping me, you know, really start seeing, you know, the whole big picture, because you know, this whole educational process that all of us have been going through in terms of law, legal, you know, rights, duties, you know, powers, all that stuff. It's a huge ocean. It's a huge ocean. And all of us start learning the same way from stuff that the system wants us to learn from grade school through high school through college. So, you know, it's nobody's fault that we end up ignorant, because that's where the system wants us to be, because the system is very happy with us staying nice and easy to control. But anyway, the way I look at it now is that there's this big ladder of jurisdiction. And if you just picture a ladder, up at the top of the ladder is God, and down at the bottom of the ladder is hell. And there's every jurisdiction in the world in between. And because I'm a man, I've got hands and feet, God willing, and I can climb up and down that ladder. And I can go sit on rung number 2 right next to God and be a man. Or I can take steps down and be a person. I can go down and, you know, establish an LLC and be a corporation. I can take an office and be a servant to people. You know, I can do all these different things, and I've got the choice as a man to go and don those different garments, don those different jurisdictions. It doesn't mean that I'm locked into it. Nobody puts a handcuff on me on any of those rungs and says, you're stuck here now. All right? That's what the system teaches us through the educational process, is once you choose a jurisdiction, you put a handcuff on you and on that rung, and there you are for the rest of your life. Okay? Sorry, you can't go up, you can't go down. And that's not true. Okay? So as a man, you can be like running up and down that ladder. And we go down a couple rungs to be a person, and then we go down a couple rungs to have an estate, and we go down a couple rungs to interact in commerce. And we do all these different things, and we try to do them in honor according to the rules at that level of the ladder. Okay? If we follow all the rules at that level of the ladder, and the other people at that level of the ladder cheat us or are dishonorable, and we can't find an answer at that level because the fix is in, the only solution is to take a couple steps up the ladder to a more powerful jurisdiction. All right? I mean, theoretically, you can go all the way to the top, look at the sky and say, God, strike him dead. You know, but there's a very long list of appeals with God right now for people asking God to strike other people dead. So he's really backordered on that. So, you know, it might be a very long time before a tornado or a hurricane takes out your enemy. You know? So the next best thing is to just don your skin, get naked and be a man, and just show up as a man, which is the second highest authority in the universe under God.
I comprehend that, and I did it as a man and a woman, okay?
Right, well, man, okay, man I use generically. Okay.
I understand. I understand. Okay. And I've claimed protection of the Bill of Rights and named the particular people in this particular case as wrongdoer respondent. But they're putting me in the wrong court. They're not allowing me access to the common law. And if I'm not making this simple enough, then I can say, okay, we live here. We developed this land. We have possession of it and the home. And it's ours. I mean, I can keep it that simple. I was looking for an injunction to protect us from the sheriff coming and kicking us out again. And then I was making a monetary claim for trespass of $5,000 per day per person since the first eviction. So it is, you know, it's figured out that particular way. And based on that, it's between $2 and $3 million. So that, you know. But the thing is, I can't get the court to put me in the right common law people's court. You know,
well, but you're not gonna.
Greg, tell me about what I was talking with you the other day about. I said, Greg, just throw a stay in the mix and just gives you a little bit of breathing time. Just tell her I'm doing a stay.
Yeah. Carl was suggesting is just put an order in for a stay to stop the bus.
In order to stay,
yeah.
Okay,
you put an order in.
I put an order. I put an order in, but okay, just a stay of what? Just a stay of eviction?
A stay of everything, whatever's going on.
Okay. All right. and I would put that into the federal district court.
You would put it into the same filing as where the action is taking place that has supposedly given the bank and their attorneys the right to do what they're doing.
Okay, so that would be the lower unlawful detainer justice court, so called.
Okay.
Order for stay, okay, but that's not the federal district court.
No, but you're not in that court.
Well,
no. Okay, now we got to talk about in and at. All right, you're not in the court. You're coming at the court. You're coming from your court. Your court is ordering their court to stay.
Okay. Now, I understand about my court as a man or a woman, that we have our own court, all right? And I've done that before to no avail. Okay. So, but this order for stay, as the movement, it's like we're looking for one of their people to verify it, you know, to put their stamp on it as well. I don't think I even need that, but I seem to, because although I did do a cease and desist order to the sheriff, and that seemed to help Monday when they came, and they did not come onto the land or the home, and they did seem to respect that based on that and the land patent and the notice that I put out to them by way of someone else through my door. So,
okay. Now, did you go through a full administrative process where you did the whole TILA and RESPA thing, where you?
No, I didn't do RESPA. I didn't do that.
You asked the creditor to prove.
I did a removal. I did a removal of their. I did a revocation of their power of attorney and trusteeship on the deed of trust and also the promissory note. And then I did do an administrative.
Yeah, I did that back in 2009. I fired all the trustees, appointed new trustees, did all that stuff, and we lived happy as a clam till from 2010. They didn't say boo to us, and then at the end of last year, they did a fast move to go and make a motion and bring this thing forward. All right. So I don't know what transpired between the time that we put the brakes on it with a foreign judgment and the end of last year, or maybe they were just trying to just throw it out there to see what would happen, you know. But nonetheless, we're back in play with them. I thought it was over and done with, and we were, like I said, it was just over, and it just popped up again. So I'm kind of learning on my feet on this step myself. My trustee went into the court and basically told them on the day that they were petitioning for a judgment to have a foreclosure and sale that they couldn't do it because there was an existing foreign judgment in the file. And the plaintiff's attorney, the bank's attorney, goes, well, there's something in the file, but it's certainly not from this court, you know, basically admitting that it's there. And the judge refused to give my trustee audience because he goes, you have no standing here. And it's like, oh, you know, he's had standing for 3 years. It's been on the record. It's been in the court. It's been filed with the county recorder, the Secretary of State of Illinois, everywhere. You know, it's like, you know, you guys are just playing like you have your head in the sand. Mm-hmm. And so the judge is like, well, you know, I guess I have to do this, you know. So, well, as I say, the judge is perfect. The judge couldn't possibly have done that because the judge can do no wrong. The judge is a theoretical perfection on paper. Okay, and when that black robe that you wear is perfect, but the guy inside it, he can screw up. All right, mm-hmm. And so the only way that judgment could have been passed in favor of the bank's attorneys was if the man stepped out of the robe and did it himself. That's the only way. And so that's why the guy.
Let me just tell lady, because you got a little bit away from the stay of the execution, the stay of judgment, just the stay.
Sure.
You know, what you're doing is you're basically telling either one of the courts you want to go to with that. What you're basically saying is that there is like an appeal, or there's the matter being tried in another court, so don't execute the judgment from this court while there's still a pending case or a claim being heard in another court.
Okay.
Okay, Greg going a little off on me there. I just wanted to tell you to a stay. And
okay.
all the stay is, and then what you basically say is you tell the court that it's going to be extreme hardship, and you will suffer irreparable harm if this execution of this judgment goes while a case is pending in another tribunal. And
okay.
They were trying to still negotiate a settlement with these people. We want to pay our debts that we believe are due, and we're still trying to administrate this on a private side. So at this time, can you please? That's all the stay is. That's all you're doing. You're just saying stay, stay, stay. And like I said, all your paperwork, like Greg was saying, all this paperwork that him and his buddies do, I'm telling you, you guys could be the master of paperwork. Just like this lady in Canada, master of paperwork. That's only 5%. The other part is when you get when you have to speak, and you have to talk to somebody in a black robe or a court clerk, they can see right through you that you're all paper, that there's no substance. You have no idea what you're really doing. You're just making the stuff up as you're going along, basically. So you're going to lose your common law standing because you're going to start talking like an attorney. And they're like, oh, we thought we had the Queen of England here. The Queen of England is going to say 2 words, and we're going to snap to attention. You start going off on 50 pages, 5 pages, 2 pages, more than 1 page, you realize they're not dealing with the King or Queen of England. They're dealing with somebody who thinks they want to be an attorney. A man only says, if a man makes an order, just like when the judge passes down an order, he says, I sentence you to 15 years to life. Next case, how long was that sentence? He said in what, 6 words? And that's where you're going to spend the rest of eternity until the day you die. He didn't write 1,000 pages of why you're going to sit in a cage. He just said, okay, this court orders you to spend the rest of your life in jail. Both gone. There you go. You got to show where you are the court. It's the granny court, or it's whatever. I don't remember what your name was there, but it's the what's your name?
I'm sorry.
Oh, I said what's your name?
Oh, my name is Tricia.
Okay, it's the Tricia Court.
Mm-hmm.
Tricia going to create an order, and like I said to people a million times, when you go to McDonald's, you want a Happy Meal. Are you going to give the guy a 500-page order, a 500-page suit, and say how to grow the cow and what kind of soil to use and what kind of manure should fertilize the fields? No, you're going to tell him I want a Happy Meal. Here's my $2, give me it. And that's what all these stays are and all these orders are. Everything's just boom, 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 done. Take a look at a template of an order from any of these courthouses. They're 2-3 lines. They give you to write the order on. And that's it. You don't have to back it up with all this other nonsense. The other side is they say, we don't understand your order. Can you please explain it? It's like if you walk into McDonald's and you say, I'd like a shrimp scampi and some nice down Perignon with some fava beans. They'd be like, what? Can you please explain your order? You not know where you are. You're in McDonald's. We can't do that. Is that what you want from us? You're in oh, wait a second. You want to go next door to the common law fava bean French bistro. You're in the wrong place. This is McDonald's. This is all we do. We don't recognize you here. We don't recognize your order. We can't help you here. You're going to have to go someplace else. So then if you go next door to the common law, you go to the common law place, and all of a sudden you start ordering Happy Meals and fava beans. And go, lady, what are you doing? You're just confusing the bejesus out of us. What do you want to do? You know what? This is just all frivolous filing. You know what? Get out of our building. You know what? You're just a nut job. They'll throw you out of McDonald's. They'll be patient with you people as long as they can tolerate it. But, I couldn't imagine these poor clerks and these poor judges having to decipher what you want to do. You got 10,000 different things going on here. You got 5 different jurisdictions in the first sentence. And you want me to sit here and decipher it? Come on, lady, what do you want? What do you want from me? It's just like asking a guy at McDonald's. Come on, what do you want from me, man? Come on, pick the menu. You got 7 choices. What do you want? Stop coming up with this crazy stuff. This is all I could do for you. You don't have no standing to do that here. You're standing in the wrong line. You should get over to the other courtyard, go across the courtyard and go get what you want over there. Maybe they could help you. So like I said, make it simple for these people. 1 page done, boom.
It is the order of court for stay and cease and desist from any and all actions and claims to the address pending resolution of this case claim. Is that simple enough?
You just say you just want to file a stay. You say you want to stay at execution. Let's say for an unlawful detainer. This is more like an unlawful detainer now, right?
Okay.
is what you got going on, I presume. I'm just guessing. This is some sort of stay of execution for an unlawful detainer. They're trying to get you out, right?
Yeah.
Okay, well, this is what you do.
It's called a writ of restitution is what it is, and an order for eviction, for removal. So,
right, okay. That basically goes along the same lines. What all you're basically saying is you tell the courts that there's a case being tried in another venue, in another jurisdiction. Or
I would put the stay of execution in the lower court and also in the federal district court.
Well, who's got the judgment? The lower court's got the judgment, and they're going to.
Yes, the lower court, and they're going for it again, even because we pretty much rebutted it and used it for. So.
To me, it doesn't matter if it's a higher court, equal court. I don't care. Whatever court has got the judgment against you and is going to drag you off your property, that's the court you want to order them to stay, and don't execute. Don't let the sheriff's department, because the sheriff's department only moves under the orders that come from that court clerk. If the order doesn't come from the court clerk, he can't do anything. He just sits there with his hands on his butt waiting for an order that she's going to give him. You just tell that clerk court, please stay the order of execution because there's a procedure going on in federal court, Mexico court, Guatemala court, I don't care. But you say, and if you don't stay the order, the bank obviously is not going to suffer any irreparable harm, damage, or injury. But if you let this order executor all over me, it's going to be irreparable harm to my property. So the district court lady, depending on how nice you've been to her in the past, that's why I say to people, if you don't know how to act in court, guess what? They're going to run you like a freight train, and they got the power to do it. And you can just cry all you want and say they're cruel. How did you act when you got there? And that's what I tell people. You don't know decorum and how to behave in public. Your mommy didn't teach you right. I can't help you with that. So the clerk will say, give her a thumbs up. You know what? That lady's a real nice lady. She's been real nice to us, and she's trying real hard. And you know what? Toss her a bone and give her a stay of execution. Because honestly, the execution's done. They can slam it in any time they want. What are you going to do about it? If it was you, if somebody owed you money, and somebody owed you $10 million, and they were sitting on a $2 million farm, you better believe you'd want that sheriff to execute that order and throw those clowns off that farm. Because it was my great-grandpappy's farm. I don't care. You owe me $10 million bucks. Sheriff, seize her property and throw off, and I mean now. You're not going to let the lady hold you up for $2 million for years at a time. You're going to say execute it and do it now. 21 days, honey. Give me the money or you're gone. And so that's the only good thing is that you can say, well, we're dealing with a bank, and you can basically say stay the order because, honestly, the bank is not going to really feel any pain by me still trying to work with them on the private side. Now, if you guys want to go down silly land and say there's no such thing as money and credits, I'm not going there. I am not going there. That's such a waste of an argument. It's not even funny. But what you could do is, like, you could say, hopefully, maybe the district court lady isn't in collusions with the bank. She's not getting a kickback from the real estate people, and maybe she'll actually feel bad for you if she likes you. You guys got to understand, you're dealing with people. You're dealing with animals. A cat is going to do what a cat does. A cattle is going to do what the cattle do. A man or woman is going to do what they do. They're motivated by something. Now, this clerk lady is going to be motivated by something. She's going to say, well, she's always been nice and polite. Or she's I feel bad for her. Or these horrible banksters. She still has an opinion. And you got to hope that the lady that you're dealing with on the other side of the window is a decent person. That's all you can hope for. Which is, when it comes down to it, you're still dealing with another human being who's no different than you. They can still have hates and prejudice and animosities like you have towards them. They could have the same feelings back towards you.
Mm-hmm.
So you at their mercy. You know, that's the way this country's set up right now. And I'm just trying to show you people how to get it over to, like I said, get it in front of a jury. So you want to stay the execution and then the judgment, and then while they're staying it, you want to. Well, like I said, it's up to you. I wouldn't. There's not one damn thing I'd put in any type of court as any kind of quiet claim and nonsense. I'd attach it as an exhibit, maybe. But all I'd do is make a simple claim that that's my land, that's my property, and no man is being harmed and injured by me staying on that land. And if the bank wants to come forward and make a claim that they've been harmed by me occupying this part of the planet, let them come forward in 21 days with their answer, and I'll negotiate some sort of settlement with them to stay on this land. If no answer comes within 21 days, I'm going to drag them in here in front of a jury, and a bank, just get a summary judgment. A bank, you just get a summary judgment, default judgment, because they'll never grow a set of lungs and never be able to avoid the judgment against you. Because this is a common land.
That's why you name in the federal district court, you name people. You don't name corporations or companies.
I don't want to go and explain corporation because I am a corporation. So, like I said, I don't want to go down that silly land. But what I'm saying is, to speak in court, you've got to be in common law for it to be pressed upon a record. It has to be done with law. It has to be viva voce. You have to speak it and press it. You can't make Frank Sinatra couldn't make a record without the words coming out of his mouth. That's right. The way. That's common law. I don't care about all your silly paper. Your silly paper can't speak. I don't care about the bank silly paper. It can't speak. Can it speak in the administrative court? Yes. Can it speak in tax court? Yes. Can it speak in bankruptcy court? Yes. Can it speak in common law? Common? No. It can't. Does your paperwork fly every place else? Yes. Right. Now you're trying to bring in common law. And now what? Now what's that supposed to do? Is it going to speak? Is it going to take the stand? Can I cross-examine it? Is quiet title going to talk back to me?
No.
No, of course not. So then you're trying to say, well, I got all this stuff, common law. No, you got your word, your belief, and your thoughts, and your heart, and your mind, and hopefully the community around you. That's what you got in common law. That's all you got. That's common law. If you ain't got that, you ain't got nothing. Then the people don't care. I guarantee. Like I said, the Trenzi versus Pagliaro. And Greg, what's that case? That Green River case?
No, Credit River. Credit River, Minnesota.
Yeah, I've used that before. And when we did do a U.S. District Court case as a plaintiff, as far as protection for a period of time, and they eventually dismissed the case and would not give us our trial by jury there. That was the first court we were. So, I used the Credit River decision as doing that. But obviously to no avail. So
they can't dismiss your case.
Well, they did.
They dismissed their case. They didn't dismiss your case. They can't. They have no right to dismiss your claim. If you have a claim, they can't dismiss your claim. They dismissed their case. They have no right to touch your claim unless you surrender it.
That means that they converted your claim to a complaint and they dismissed your complaint.
Right. Or you surrendered your claim to them. And you say, at no time did I ever surrender my claim to anybody in this building.
Well, they did. Yeah, when they did the judgment and the order, I did send those back rebutted, based on the fact that the so-called lenders had no documentation or no standing.
What I'm saying is, you use this word again like rebutted. See, I don't use words like that. Can I go off on you guys with that, sub-rejection and rebuttal? Oh, sure I can. But why? This is simple. You just had to say to them, oh, you believe somebody in this building, this federal building, somebody in this building believes that I surrendered my claim to them. Who's saying that I surrendered my claim for somebody in this building to touch, or a judge, or adjudicate upon, or try? No, I thought I made it clearly, quite consistent on a caption, on a lawsuit. Please say trial by jury. Are you a one-man trial by jury? No. Then what are you doing? Who did this to me? Who interfered with my right to a trial by jury? Make them answer it. There you go. Just say, who's the man, who's the woman, who put on the big boy pants and decided that they're going to interfere with my right to trial by jury that's established and protected and secured to me by the 7th Amendment? There you go. Who put on the big boy pants and did that?
Well, that's one of their federal district court judges, I can tell you, and now it seems to be the unlawful detainer judge as well. One
step at a time. You guys have the big problem of writing these ridiculous letters, asking hundreds and hundreds of questions. Why can't you just ask one question? Because, like you said, okay, when this thing got dismissed, that's exactly what simple as I do. Who can show or who can prove that I surrendered my claim to anybody in this building for adjudication, to judge, to open up a review or give me their opinion? I don't care anybody's opinion. I said trial by jury. What part of trial by jury didn't you understand? Now, who did this to me? And you just send them a letter. And they say, well, we did, according to Bob versus General 1992 or under the Alabama Code or Virginia Code. I don't care. This is a common law claim. You write back and say, maybe you did not understand. Did I not make this claim simple enough? I am a man. I have been harmed. They used a forged instrument to interfere with my property. What part of that says something about Virginia or Alabama or United States or Mexico? Show me. Show me. Show me what this was moving under. This was moving under the common law. This wasn't moving under any form of jurisdiction other than the law that's common to me. And to that trial by jury. You're trying to bring in some other jurisdictions' opinions. You're bringing opinions from the Supreme Court. You're bringing opinions from the federal courts. You're bringing opinions from state courts. I don't give a rat's ass about their opinions. They're lovely opinions, but I don't give a crap. This is my claim. This is what I'm claiming in front of the jury that I'm entitled to. This is by right. Who are you to tell me that it's not mine by right? You're nobody. Back the hell off. Let my claim go in front of the jury. Leave me alone. I'm going to sue you. It's that simple. You don't got to put a mountain rule. Look at these quiet titles. I mean, going there with this silly stuff. It's simple. This stuff is way too simple. Maybe it's because you're asking me the question and you don't hear it while I'm saying it. Maybe you got to listen to it back again a couple of times. I said, well, now I think I'm understanding what Carl's saying. I know Greg's catching on. I know Greg's not doing any ridiculous. Greg's stuff is getting really good. I mean, it's pretty funny. Yeah, it's pretty funny. Compared to what he used to do like that, he was like, oh, my God, Greg, stop. And he wrote me something yesterday. He said he couldn't sleep. He wrote, like, the last 3 or 4 paragraphs was starting. I was like, wow, man, this guy's drinking my Kool-Aid, man. It's starting to click a little bit here.
Great.
But it takes a while, guys. It's not going to come overnight. Greg went to all the seminars like you guys did. I told him, who's this guy? And I was like, oh, I went to his seminar, him and his wife. He's a big guy. Greg went and followed everything you guys did, man. So I understand, you know, that this stuff is hard to mix with my stuff. Mm-hmm. But you guys are trying to do it. Well, what do you say, Greg?
Well, what's the good news is that just because you did a bunch of things in other jurisdictions doesn't mean it was a waste of time.
No, it's a learning process.
Those things, no, it's more than just a learning process. For example, we did an entire administrative process, you know, being very nice and polite and sending the bank and their lawyers a whole series of requests for them to prove certain things according to what the law is of their franchise. Banks are franchised by the federal government. Right. They're supposed to operate within certain rules, and so you can't attack the bank as according to those rules from common law. You attack the bank according to the rules. Okay, so you climb down the ladder to the rung where the banks live, and you do that process at that rung, and you complete that process. And if the bank and their attorneys fail to follow the rules according to what their franchise dictates, they have violated their trust with the federal government. Okay? And if all that is properly documented, done through third parties, you know, neutral witnesses, notary presentment, and in my case, we even concluded with a 3 notary tribunal passing judgment on the entire process, and had that recorded with the courts and recorded with the county and the state. And then the whole thing was perfected, and the UCC1 liens were established. So the entire thing is done. It's over and done, signed, sealed, delivered, and technically the bank owes me $5 million. All right? That's their confession. Now, they're ignoring all that.
Of course.
So, of course they're going to ignore all that because it's coming from the jurisdiction of the notary tribunal, not from their circus. Okay? Ringling Brothers, it's like before Ringling Brothers and Barnum and Bailey merged. Okay? You know, our judgment was at the Ringling Brothers circus, and they're at the Barnum and Bailey circus, and they don't recognize the entertainment in our center ring. And until you can find a way to merge those 2 circuses into one forum, it's always going to be stuck like that. So the way you merge them is you have this wonderful thing that you did in your circus, and it's valid, and you have to go and then find a particular rule or regulation that they're bound to in their circus, and that is called the full faith and credit clause.
Yeah.
Every single court is required to give full faith and credit to any other valid, lawful jurisdiction. Okay? And we call them foreign jurisdictions. And foreign doesn't mean France or Spain or Mexico. It means anything other. If you look at the rules, if you look at even in the United States, you go through their own codes. They say the United States and the states are foreign to each other. As simple as that. All right? You know, it's a foreign object in your eye. Okay? Something that's not part of what's normally there is foreign. And we just have a tendency of thinking as foreign as being international. But, and you can argue the case that we are international. And as Karl says, he's his own state, and I'm my own state, and I'm a corporation, and I'm a person, I'm whatever the devil I'd like to be. And the wonderful thing about being a man is that you have the flexibility to move yourself. It's just like you have a really, really big walk-in closet with all kinds of cool costumes that you can put on. And you can just go pick out which one you want to wear today.
Yeah, we're going to do that. Great. We got to do that one day. You got to remind me, man. We got to do a foreign judgment show. We could do hours on that because that's a damn good one. And that's how a lot of you guys can get this stuff. But like I said to the lady, if the court clerk might ask you when you want to do the stay, they might actually have I was just thinking, they might have a printed form, and if she says if you want the proceedings, she might actually use this phrase. It's called held in abeyance, and that's the same. That's what you want. She might do a writ, or she might ask you, do you want to do do you want it held in abeyance? And that way, at least you kind of an idea, because that's a common word here in Virginia they use a lot. Okay. And I don't know where you live, so I'm just saying, I'm just throwing it out there. If she says something to you, just say, good way to go.
So where I was going with this was that I established through my trustees a lawful foreign judgment that has the power to withstand a challenge all the way to a Supreme Court. The Supreme Court cannot overrule the summary judgment of the 3-member notary tribunal. They cannot. All right? So, if the Supreme Court can't overturn it, why can Chancery Court ignore it? Right? They are failing in their duty and their oath and their honor. All right?
Yeah.
And so this is actually a federal crime, what they're doing.
Yeah, if you want, like I said, Greg, why don't we do this like on Saturday, man? We talk about this because I think that's a great thing. But like I said, just make sure there's nobody here with family questions, because I do this like for moms and grannies. This time, day.
So to conclude, all those things that we have done in these lower jurisdictions are available to us in common law as evidence and proof of our good faith, of our willingness to work with people, and their failure to respond in honor.
Right.
And that's the evidence. You don't say that that's the base. You don't go and cite this rule and that rule and this rule and that rule in common law. You say, you stepped on my foot. All right? And it hurts. I had to go to the foot doctor, and he had to peel my toenail off, and it cost me $150. Right. Okay. There's your claim.
Hey.
Now, you don't have to go into explaining why you stepped on my foot because you were mad at me because I was looking at your sister funny.
What happened between like 9 and 9:30? What kind of happened? Can you set it up a little bit?
Well, between 9 and 9:30, we were waiting out in the hallway on some chairs outside the courtroom for other cases that were being heard at the time that were kind of going over their time. We were scheduled to begin at 9, but we had to wait for other cases to finish up.
Okay, when you had to wait for other cases to finish up, what time were you summoned to appear?
We were summoned to appear for 9 o'clock.
Wow. So what if you were summoned to appear, what you said, somebody else was summoned to appear at 8 o'clock or 8:30?
We assumed that they must have had to start there for 8:30, 8:45 maybe, and they must have gone over. And they recessed, and instead of taking us back, they just finished their case. So they recessed and then took their case back into court, and then it went on until about 11 o'clock or so before we got in there.
Okay, so now does it make a little bit of sense why I say, you know what, just put it down for a couple of hours?
That's right.
So that way you could say, hey, did anybody come to this courtroom between 9 and 11? We just walking in here at 9. You know, we would reserve the room for 9. But obviously, you know, somebody's, discourteous and, courteous, discourteous, and they believe that they could occupy this room when we had it reserved for us at 9 o'clock. So it's like somebody had at the clerk of court's office felt that they could be disrespectful, and they could schedule two parties to be at the same dance at the same time. Like we were all dressed up here to go to, a formal dance, and she had scheduled this courtroom for somebody else at the same time. That's like really discourteous. So, but anyway, like I said, you make it go for 3 hours then. We make it go all day. It doesn't really matter. You say, I'll make it from, 9 o'clock till 4 o'clock, 5 o'clock. I don't care. Anybody comes into this room, with a claim, let us know. And you just, that's how you hold court. That's actually called like holding court. You're holding court. You're waiting for claims to come in. That's holding court. You're considering that venue your place of business. It's your courtyard. Or like I said, like when you, just like I'm sure you folks have courtyards up there in Canada where, they have like a coffee, club over here, and you walk across, you got a bookstore, it's a court.
Right.
And everybody conducts business there. That's what you're doing. You're conducting business in this public building. Not a private building, it's a public building. So you get into there at 11 o'clock. Did you explain to them that, hey, we had a claim hearing, we had a claims going to be submitted here between 9 and 9:30? Did you bring that up on that?
No, I didn't bring that up.
Okay. Do you understand why it's really important to bring it up?
You might have to go back over that with me.
Okay, well, it's really important to bring it up because that's the only business that you had in that venue inside of that public building that day. You had nothing else to talk about. That's all you wanted to do was accept claims that day at that time and get out of there. That's all you wanted to do. And all you wanted to do is get somebody who is assigned by the court clerk's office, some guy in a black robe. It could be the bookkeeper. I don't care if he's the accountant, and he's just assigned to be there that day as a witness. So when you create your order, like I, Jesse, as no, person came forth on this court on this day, from 9 o'clock to, 12 o'clock to make a claim. I ordered the immediate return of said property, see attached Exhibit A or whatever. Or you could actually put it in the order, the actual name of your property. I would demand the immediate, and you can make 4 orders. 1 kid, 2 kids, 3 kids, 4 kids. That's fine. I return the name of Baby Joe, Baby Billy, Baby Bob. You can say, and then make it 4. So that way, when you give it to the sheriff's department, he'll go find each kid in case they separated him and put him in multiple locations.
Right.
And make each separate order. That's fine. And then what you do when you make your order, you sign your name, you put your thumbprint on it. That's fine. That's cool. And underneath it, you put witness, and then that guy in the black robe would witness it. And then underneath it, you write on your order, clerk court or court clerk. And that's it. And then she would sign her name, the witness would sign it, the court clerk would sign it, they put the seal on it, and now you have an order in which you could go down to the sheriff's department and have them executed on your behalf, or you could stick it on your mantle and never do nothing. But now you at least have your order, you have your judgment. And the order's been, acknowledged as a legitimate order. So now you could actually have it go executed if you want. If you don't want to execute it, don't execute it. It's up to you. So like you said, 11 o'clock, things started. How did it start? Like, what went on?
Well, it began first off by the judge addressing the Minister of Social Development's application first, instead of our case first.
What was the application?
The application is for custody of our children for 6 months, even though they've already had them for 4.5.
So they wanted suspended them for an additional 6 months?
For an additional 6 months, and now they're trying to go for permanent custody.
Right, but this one that day was for 6 months, right?
That's right.
Okay. So what did you do when they started talking?
Let me try to remember this now. When they started talking, first the judge said what they were there for. They were there for the matter of the Minister of Social Development's application and checking to make sure if there were any preliminary issues for the trial and whatnot, and we're checking to see if all the parties were there. So they went through, and once they came to us, we didn't confirm our name as he requested. We simply stated that we were there as a man and woman presenting ourselves in case for the court.
Right.
And that's when he kind of jumped down my throat right away. And basically, I asked you a question, and you're going to answer me the way I asked you, and this is my courtroom, and blah blah, and then I looked at him and I said, "Why are you intimidating me?" Very just matter-of-factly and very sweetly. And then he just kind of calmed down, and yeah, because it's all on the record, I guess. And he said, "Well, are you not, Josette Arsenault?" I said, "Well, I am a woman here presenting myself in case for the court." So he finally just basically gave up and big rolled the eyes and the sigh, sat back in his chair, looked at us, and then just decided to proceed with the other party.
Can you still kind of see why it's going on the way it's going? Can you tell everybody why, so I don't have to tell them?
Well, first off, I disobeyed my own court rules, so I'm in contempt of my own court already because I'm there past the time I'm supposed to be. So it technically wasn't our court anymore; it was his court. So he was making the decisions then at that point,
So what I'm trying to say is, what's happening is you just wanted to establish court to accept claims. Other than that, there was no other business for you. There was no other business for court that day, as far as you were concerned. There was no business for the Arsenal court that day. Anything else was moot. It didn't matter. It had nothing to do with you.
That's right.
Yeah, less what these people are talking about, you couldn't care less. What 6 months they want, 6 years, 60 years, they're just trying to do it to intimidate you and scare you and shake you off your claim. They're trying to get you to understand you better start playing ball or you kiss these kids goodbye. Did you kind of feel more that way? It's like they were trying to intimidate you?
Oh, definitely, definitely.
Yeah, so that's a good, so I'm pretty accurate of what like I said, so you could definitely tell, oh, Carl, you've definitely been a family court before.
Yeah, definitely, because the social workers and whatnot won't even talk to us anymore. They've got the big hate on for us, and
they won't talk to you anymore.
No, they won't let us see the kids at all. They won't answer our phone calls or anything like that. You
can see a lawsuit is coming. There's no doubt about it. When they know a lawsuit is coming, they'll tell everybody, don't say a damn word to these people. Everything you say will be used against you, and these people will take your social service pensions and your bank accounts, and they garnish your paycheck, and there's nothing the court could do to stop these people from suing you individually in your individual capacities. Don't say anything to these people. You have an attorney that represents social services. Let the attorney do all the speaking for every single person in this social service organization. You see why they're clamming up? It's not because they're clamming up because they don't like you. They're told, you shut your mouth or this lady's going to own you.
Right.
Okay, that's what's really going on. Not whatever you think might be going on. That's what's really going on. They're now being warned. You're going to be sued and you're going to lose everything. You better just let us take care of this because these people are going to win. So now everybody's just told to shut up. Don't testify. Don't do anything. Don't take no witness stand. Don't do anything. So now what's the other thing that you really missed that's really important? You realize why they did what they did to you.
I'm trying hard to think about that.
You said it earlier, believe it or not.
Did I already say it?
Said it a little earlier. Why did they treat you the very first hearing? Why did they not respect you when you were talking? Why did they totally...
Well, because, first of all, we talked too much, and second of all, they didn't understand anything we were saying. We were just confusing the crap out of them.
The reason why they can't recognize you is because you haven't made a claim yet. You have no case before the court. You still, to this day, have no case before the court. can't see you in your capacity in which you wish to stand. They still see you according to the social services or Canadian rules or whatever.
That's right, right.
You have to file a claim. You have to get your own case in there, your own suitcase with your own claim, with your own accoutrements, with your own witnesses, with your own exhibits, and you need to make your own claim and drag and define what the social service thing is and drag it into your case. See, right now they believe that they are the controlling party. Of course they wrote the rules for them to win.
That's right.
So now you got to write your rules for them to lose. And there you go. And then that's when you get it up to the jury. And then the jury will determine whose rules work for them. To the jury. Not for you, not for them, not according to any constitution, not according to any Bill of Rights. The jury is going to throw it all out. And they're going to determine whose rules does the society like. And that's why I warn you. You might get a jury who'll say, you know what, you guys are a bunch of wackadoos. You know what, I'm glad social services took you kids because I'll take them too. So that's why you got to be careful sometimes when you ask for a jury. Honestly, it's actually better to go before a black robe one when it comes to something like this because the trump card is the common law. Trump card is the claim over the complaint. So if you have a claim that you won the lottery, and you go to the lottery commission, the lottery control board, you say, look, I got the claim ticket, I won. You're going to get the cash right there. If you're going in and saying, well, I'm a woman, gay, in a wheelchair, and I'm Hispanic or black or Oriental, and I'm Buddhist, so you discriminated against me from winning the lottery, so I'm going to file a complaint that only white people seem to be winning the lottery up here in Canada. Your complaint is basically going to be falling on deaf ears because everybody says you're ridiculous. That's not the rules of the lottery. What do you want us to do for you? Well, you just gave it to that white lady over there, a lottery winnings. I want to because she brought a claim. She had a claim. You have a complaint. Well, you know, what are we going to bring? Everybody who lost the lottery this week, we're going to pay them too? So see what I'm trying to say? When you have a claim, they understand that trumps the state's complaints.
Okay.
Just because they say it as a complaint, if we lived in France, you'd lose. Because that's just the way they work. It's on Napoleonic code. We got lucky, and some great reason, our great-grandfather somewhere in the past decided, you know what, this is going to be common law, because we don't trust the people who write the codes. We don't trust the people who write the laws. We just don't trust them, because they're usually lawyers and guys who went to college and know how to wrangle words. So you know what, the guys who actually are competent to read and write, they always try to figure out a way how to get over on the common people who don't know how to read and write. So the next thing will be enslaved to these people who write the codes. So that's why in this country, and that part of Canada as well, also believes the same thing, that our grandparents were wise enough to say, you know what, even the people who can't read or write, they have just as much right to claim property as a guy who could wrangle the words and, talk, snappy in court. As long as a man comes with a claim, you know what, it doesn't matter how well he reads it right. We're still going to give the guy his day in court. So thank God our forefathers decided to do it that way.
That's right.
So what else would you like to add in from there? Do you have anything you'd like to add in there?
Well, at this point, we haven't given up. Now we've got our claim that we're preparing. It's still just going to be the one page, and we're going to go file that on Monday and start the process or Tuesday, depending on when we can get into town again. But yeah, we're going to try this again, and this time try to do it the right way. File our own claim with our own court instead of filing it into theirs.
Right. Like I was saying to people, there's no definitive right way, wrong way. But it's more of to me, it's more like, are you competent? This is a competent way. You could do it the legal way. You could do it the law way. You could do it the admiralty and divine comedy way or divine ministry way. Whatever you guys want to do, that's fine. There's nothing wrong with it. It's a different style. But this is the style that we are fortunate enough to have in this nation that will work in our behalf, because somebody was smart enough a couple of hundred years ago to say, hey, you know what, let's make it this way in this country. Well, like I said, when I said to the U.S. Marshals, I said, look, eventually all my common law nonsense that I'm teaching everybody is going to get thrown away. And we're going to go into a code world. It's going to go into a police state, and everything is going to be under a code. And there's just going to be people who are going to take this over into a nanny state and then tell me what's best for me to eat. and it's going to be according to a code. And and the jury will be just told, you have to do what the code says. Regardless of what the jury believes, you're going to have to do what the code says, because it's going to be a code world. And that's the law that everybody in society consented to, because you're elected politicians, and those people went and wrote the laws for you, which bind you into those contracts, because they're your lawyers. Since you're too busy doing whatever you're doing, you're allowing representatives to bind you into contracts with the rest of society, because you don't want to do it yourself. So you trust people to go be your attorney, to be a legislator, or your congressman, or, your minister of, or whatever you guys, elect up there. And there you go. And that's how you get your code world going.
Right. Now, Karl, do you think, in our case, that it would be more beneficial to go just before a judge or to request a jury? Because the judges don't seem to like us very much, so we don't know if we want to place our trust in just a man in a black robe.
Oh no, believe it or not, I really no, because he knows the law. He knows the law a lot better than the jury does, believe it or not.
Yeah.
Oh yeah, and he knows that he's going to make himself liable. Like I said, when you talk to him, you've got to make sure. Like I said, I forgot who I was listening to not too long ago. They said, like the prosecutor called the judge by his first name, and then he tried to call the guy in a black robe by his first name, and the judge went bananas. So what's funny is if you write to the man in the black robe, or talk to the man in the black robe in his first name, you're making him personally liable to you. If you call him your honorable majesty, whatever you guys call these guys up in Canada, your magistrate or whatever you guys call these folks, you're basically letting him hide behind a robe. And that he's not going to be liable for anything. You say, hey, Bill. You're like, what? Bill, your name's Bill, right? Yeah, okay. Well, did you witness anybody coming in here today, Bill? Well, you can refer to me as magistrate. It's like, okay, so Bill the magistrate. Yeah, okay, Bill the magistrate. Okay, Bill the man, Bill the magistrate. Okay, but you do know you're a man, right? And he'll say, well, absolutely. I said, okay, well then it's magistrate it is, as long as you realize that you're a man. You're in the capacity of a man right now.
Right.
I'm looking at you as another man. I said, well, don't look at me as a man. Look at me as a magistrate. I'm not going to do that, because this is common law. If you have anything to say in a common law court, only a man can speak in a common law court. If you have anything to put on the record, you have to do it as a man, not as an actor, not as a representative. I'm holding to you. If you want to put something on this record, if you want to open your mouth and say something, the only person who's going to be able to put something on the record is a man. See what I'm saying? Like I said, it's like when you press a record. If you're Elvis Presley can't let his lawyer go into the recording studio or deck of records and press a record for him.
That's right.
It's ridiculous. It's not an Elvis Presley record. It's a lawyer record. So see, like I said, I hope like this kind of stuff is starting to make it calm people down a little bit when I talk. I try to explain things extremely simple. I can't imagine any simpler than I explained to you folks. So what's great is you got an exhibit now that nobody made a claim on that date. So you gave them fair warning. You gave them notice. You gave everybody the opportunity to, make their claim. And they did it. So that's great. So you really don't have to wait for 21 days for anybody to answer, because you just said, hey, you know what? I want it now. You could basically say Monday, if you write it like that, you could basically say, hey, I want the return of the property now, since Judge Bob, no, don't say Judge Bob, say Bob, the man who sits in the capacity of the robed one that day, or whatever you call him up there, the magistrate. What do you guys call him, magistrate? They're
magistrates here, yeah.
Yeah, okay. So, Bob, the man sitting in the capacity of a magistrate witnessed firsthand that nobody brought a claim as ordered on, see Exhibit A. I demand the property returned immediately, post haste, and if anybody interferes with the return of property, I'm going to charge that person $10,000 a day until the property is returned. There you go. That's a nice, easy, simple claim. So good thing I said it, record it, and now go back and listen to it, because I ain't going to say it again.
That's right.
I just don't know how not. Like I said, because if I said it again, I'd probably mix the words up a little bit and not really confuse you poor guys. I'd probably add something that takes them away. So it's better to go with what's in your gut and what's in your heart and just say it, because you're the one who's going to have to keep repeating it in open court, not me. So kind of have the idea of where I'm going. and then just twist a little bit if you have to, but try to make it as simple and as plain as just what I just did. I did not use one legalese word. I did not use one language other than plain, simple English that every jury person who's going to be seated will understand. I didn't use any Latin legalese. I didn't use, Spanish. I didn't use any tricky phrases. I didn't use anything fancy. It's common, one-syllable, two-syllable words, and I'm done. And it really drives them bananas because they can't answer it. There's nothing for them to say. They're like, well, that was pretty simple. What are we going to do? Well, how can we tell them no? You better have a damn good reason why we're telling them no, because I can't think of one.
Yeah.
See what I'm saying?
Yeah.
Pretty scary.
so scary. It's just so simple.
Yeah, because like I said, it really freaks people out because you can't believe the emails I'm getting. It's like, where am I losing you folks? I can't imagine any simpler. And people try to keep using this fancy stuff that they want to be a lawyers because I guess like, well, how long have you guys been doing this? Just the 4 months, or have you been like involved with this stuff for years?
Well, just this particular portion of the law we've been in for just since this has happened, the last 4.5 months. But we were studying a lot about government and how the laws technically are like the codes and statutes are not what's supposed to be law. We've kind of been into that for a couple of years, about a year or two now. So
just enough to just totally mess up your brains, just to totally confuse the bejesus out of you, right?
Yeah.
So like I said, do you understand, like if I had a teenage kid and I just explained to him how to do law, how much simpler his life would basically be if he just listened to me for like an hour?
Yeah, exactly.
Well, that's what happened with me and my mom. My mom was an IRS agent, and I was carrying groceries to her, and she wanted me to go outside and fix a car. So then we just got to a discussion on the way up the stairs into the kitchen across the living room. She basically explained to me everything about the IRS and the government. By the time we got to the front door, to the time I got to the kitchen, she opened up the IRS book. She told me to read the front cover. She said, what do you see in the inside cover? Welcome to the IRS 1040 Easy form. This is a voluntary compliance system. She said, what part of voluntary don't you understand? And then she just closed the book and said, no, Mom, I really want to know because I taxes, what pay taxes. She said, you believe you have to pay taxes? Yes. She said, let me try this again. You believe you have to pay taxes? Well, yeah. She said, okay, let me try this. You believe in a tooth fairy? Well, no. She said, but you used to, right? You used to take $1 when I put it under your pillow? So like a quarter. Like, oh, yeah. But now you don't, right? Yeah, okay. You believe in Santa Claus at one time? Yeah. You don't believe in no more, do you? Well, no, not really. No, you don't, right? No. Okay, I don't. Okay, good. You believe you have to pay the IRS? Yes. She said, okay, now watch this. You believe in Tooth Fairy? No. Believe in Santa Claus? No. Believe in IRS? No. She said, go out there and fix my car. That's all you need to know. And that's the way I've been living now since 1987. She was boom, done. I could talk to you folks on the internet for days and weeks and months on it, and I'm still not going to make you understand as simply as my mom did. She's like, look, you go fix my car, I'm going to go fix dinner. You do your job so I can do mine.
That's right.
And boom, we're done.
Yeah, I think our problem is, for the most part, most of us have been, we've been taught our whole lives that all this stuff is complicated and leave it to the people who know what they're doing.
Right, because what I'm saying is I could tell these people like a broken record how to do it, and they're just in total fear, and they don't really know. Should they trust me? So like I said, I trusted my mom, you said, well, come on. She had such high clearance in, the federal government. She was one of the best collectors for the IRS in New York City at all time, because she was a sweet lady. And she was like me. She was a sharp lady. But she wasn't stupid, and she was gorgeous. So it really was easy for her to make settlements. Because she'd say, if you don't make a settlement with cute little me, my boss Bubba, he's in a bad mood this day, so you sure you don't want to work with me? Because, I got to deal with you. So believe me, my mom had so many completion rates, it was scary. Just like if I was doing it, I'd have so many completion rates with people like, come on, work with me on this. Let me get you out of here. Don't you want to get back and do something else good? You know what? Let's just make it, how much can you handle? Blah, blah, blah. And make it as painless as possible, and just get on with your lives. Like I said to you, if they want you to fill out their forms, hey, you know what? You got to consent a little bit. You got to give up a little bit. Because they don't want to make it seem like this is going to be a runaway freight train. That all you have to do is one paragraph, one sentence, two sentences done. And they're like, holy cow, if everybody figures out it's as simple as this, how are we going to hold the floodgate back? We're going to have to give these people as hard as time as humanly possible and try to find a loophole. And, like they're all scrambling. The guys in the black robes, the clerks, the social service, they're all scrambling and how to try to interfere with your ability to hold court. They're doing everything in their power to mess with you.
There are.
You don't want to lose control of the court. And you're gonna take over control of the court. Like I do. I could walk in and take control of the court in like 2 seconds, and it's scary. They don't realize what I did. And by the time they realize what I did, they're like, "Oh my God, this guy's got the court." It's funny. So like I said, if you do walk in there, if you have to actually make a physical appearance, I'm telling you, all your paperwork, 5%, 10%, they really don't care. They'll read it, just make it a little short sentence. It doesn't really matter. Because if you can't hold court, all the paperwork you did was for naught. You're wasting your time.
Right.
I don't care how much you study. I don't care how much you do. Like I said, my mom taught me very simple with the IRS. Good. Man, anybody want to come and take me in and go around with me with under their little system, under their little beliefs? Oh, I'll say, okay. Boom, 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 boom. I was like, there you go. Now, what do you say? I say, well, we can't say because we're representatives and we're not Mr. or Mrs. IRS. That's right. When you get Mr. and Mrs. IRS here to make a claim that I cause a direct source of their harm, that I'm the direct source of the loss of their income, that they accrued damages, financial damages, financial loss due to my acts, I will be more than glad to compensate Mr. or Mrs. IRS who shows up. Until that day, I'm going to let you go off with like a warning. Don't bother me again. I'll dismiss this without prejudice. If Mr. or Mrs. IRS somehow magically appears with a properly submitted claim to court, my court, we will be more than glad to entertain any claims and will be more than glad to compensate them for my wrongdoing. That's it. I'm done. There's nothing they could do because we're not in France yet. Yet. One day, my stuff is going to be dribbled. They're going to say, oh, listen to this crazy guy in this old talk show. Oh, remember that? Oh, that guy's so funny. He's like Soupy Sales. He's like Don Rickles. Listen to this guy talk about common law. Oh, he's so funny. I'm serious. Our kids are going to be doing that one day if people don't wise up and realize how simple this is. And gets caught up in this crazy loophole. And this loop the attorneys got us in. Because that's how they control you. If you never hold court, you never got control. It's always under their control. It's always their court. Simple. This stuff is magically simple. Thank God this thing is being recorded because I really think this is going to help a lot of people. And thanks a lot, Jesse, because are you feeling a little bit better, a little different? I mean, how are you feeling as the days are going on?
I feel better. I mean, we have our moments because we did receive the other day some information that the social services are trying to really bury us and take the kids away for good and terminate our parental rights and the whole nine. So,
one good thing I know about TPRs, the termination of parental rights, you can demand a trial by jury in this country, in this nation. Now, I don't know what it is in Canada, but if they even have to play by their own rules, man, that's sweet. Yeah. So you could find out. Like, just make a couple phone calls. Don't say your name is Jesse, Just say, hey, you know what? I'm just wondering, talk to somebody in another county or something like that. Ask them, Say, hey, when it actually gets down to a trial, see, because that's going to be a trial. All this other nonsense is a hearing.
Yeah.
I went through 2 TPR trials, and both times when I went to trial, you know what the state did?
What's that?
They said they did not want to prosecute it this time. They wanted it dismissed without prejudice so they could come back and try me again some other time. But at this time, they do not wish to terminate my parental rights. So you understand how beyond upset we were because we wanted to be done. We were like, please take us to trial. Let's do this. Let's get the jury. Let's get it on. And as soon as they realized, now it's the trial. Now Carl's got the chance to put us up on the witness stand. Now Carl's got the right to do this, this, and this. Now Carl's got all kinds of rights because this is a trial. At hearings, it's a Mickey Mouse. Hearings are totally nonsense. So if you want to say, good, you got to get this different attitude, and you women got to get this different attitude like I did. See, because I was like, when do we have like a trial? And they're like, well, that's a termination of parental rights. Oh, let's do it today. Can we do it today? And they're like, no, that's supposed to scare the bejesus out of you. Oh, no. Let's do this now. And they're like, no. All the parents avoid it, and it's like the plague, and they're scared shitless. No. You're saying there's something called a termination of parental rights, and it's a trial? Want a hearing? Oh, can I put them on a witness stand? Yeah, oh, let's do this. And like, no, you know, that we usually have to work with you like 16 months or 2 years before we actually terminate. No, terminate my parental rights now. Let's get the trial on now. Do it, let's do this. And I was freaking them out. Because that's the only time when, like I said, if I could have a trial by jury, and when do I get to cross-examine these clowns? When do I get to put them on a witness stand? Well, that doesn't happen until the trial. Well, when does the trial happen? Well, first we go through all these, you know, adjudication hearings, and we try to see what the placement hearings, and then we try to do a dependency deposition, dispositional hearings. I don't know if you guys have a dispositional hearing up there, do you?
No, just the regular hearings to see who's getting their counsel, if they have their counsel, and then the pre-trial conference, which is what we just had.
If you do hear somebody call dispositional hearing, it's just saying, what position are we in? It's like a preliminary hearing. That's all dispositional is.
Okay.
But do you guys use a fancy word, or you just call it a preliminary hearing? Is that what you guys call it?
We call them G hearings.
Okay, a G hearing?
Yeah.
Like a letter G?
Yeah, to see everyone's position.
Okay, well, down here they call them dispositional hearings. So I was so tired of even thinking about another hearing. It's like, when do I finally get those clowns up on the witness stand? Well, not till the trial. Make the trial now. Get the dispositional hearing. We just want to see how the kids let's get it on. Everybody's here. Let's do this. I was like, no, they need time to prepare their case. What case? Let them get it on. I'm all in. You're like, whoa, wait a second. I'm all in. Let's do this. Terminate my parental rights right now, man. Let's get this on. Because if it's under your silly administrative things, I could take this over into my court. So you just get it on in your administrative court. Let's get this on. I said, if I lose, I don't give a rat's ass. I'm going to take it over to a common law court. Okay. I'm going to get a damn jury. Let's get this on. And they're like, oh, shit. You know, and like I said, both termination and parental rights hearings, I wonder if I got the paperwork for that. And I'll make it available. I'll show you guys that the state withdrew their claim or their willingness to prosecute at this time. They said, well, we don't want to prosecute him at this time. You know, they're working with us. I said, work with you. F you. How many times have I say F you? She's not working with you. I'm not working with you. F you. We're not working with you. We're never going to work with you. F you. Well, we don't want to prosecute them at this time. We see they're making efforts. Effort at what? Telling you F you? You know, the judge was like, this is crazy. I mean, the second time, man, I exploded, man, in court when they said that they're not prosecuting at this time. Because I really didn't know the rules of administrative compared to common law. I thought I was in common law. I could have sworn I was. But like you guys did, you make a couple of simple mistakes and boom. You know, you just said something wrong the wrong way, poof, I lost my court. I was like, hey, I thought I had my court. And then I go back and I said, oh, my God, I did use one of their codes, didn't I? Oh, my Jesus, Lord. I did use code like 36.1.51, subsection E. Oh, geez, I did say that in court, didn't I? And I lost my court. Because I didn't know. It took me years to realize, oh, my God, don't ever use this stuff other than as an exhibit. Because like I said to people, everybody laughed because they changed the code on me. And I was actually describing something really bizarre. Like laughing, so what's so funny? And then there's like, I guess you didn't get the memo. Alabama changed their codes January 1st, and now it's like June. I guess you didn't get the upgrade in your code book. Like, well, no, my code book was like, I don't know, written, it's in the library, I don't know, 5, 10 years, I don't know. So part of me, they changed the code just because they knew a clown like me was writing briefs according to their code. So like, ooh, let's change this code a little bit. So when he says this, it sounds really ridiculous. Because I was slamming codes in him. I mean, I was walking around like these guys you hear on these shows, and he like me was being able to whip out codes. Whoa, whoa, whip out this, Section 31, Section 33, Section 1 of the Canadian chart. You know, this is ridiculous. I was good, but it was ridiculous because they changed the code, and they specifically did it to me. And I went back and I looked up, and on the internet, oh, you clowns. This is exactly when I was submitting this. Oh, these people are smart. So everything that I wrote was thrown out the window.
Yeah.
Because it was the wrong I was trying to use their words instead of using mine. So like I said, thank God I went through 28 hearings and 2 trials because it really made me learn to stop using their nonsense, and that's what the judge actually told me. I actually went around like I had like you were seeing with the judge was pretty nice, you guys, whatever. I was going around with this judge because he let me talk, which was ridiculous. He let me talk for about 7 hours, which no dad gets to talk for 7 hours. He says, you got the floor. Convince me. The sun's not going to come up tomorrow. Go ahead and do it. Prove it. a negative. So I was like, yeah, thanks, buddy. So I tried it. After a while, he just gave mercy on me. He's like, come up here, and he gave me his business card. He said, look, let me just pass final judgment. Meet me on the hallway. I'll show you how to beat the state, and I'll show you how to return my ruling. And he says, oh, and you know what? The biggest favor you can do for yourself? Never use this damn case file number ever again. He's like, what? I said, but this is the case, and the kid is under the case. I said, don't. Man, I went around for this guy for about 15, 20 minutes, easy. I say, but I need this case. I need this. He says, it's not your case. So what do you think I get adamant with you people? Because I was the clown yelling at the judge, but it is my case. And he's like, it's not your case. My kids are like, it's not your judge. He's like, stop, call. But judge. And he said, call, file him up. But judge. And it's like, we were going around and around. It was so funny. He was like, oh, my God, I'm going to have to hit this guy in the head with a hammer. It's not your case. But my name's on it. It's not yours. And man, he couldn't explain too much detail because the state attorney general was sitting right on the other side of me. He would say, hey, judge, you're not supposed to tell this guy all this. Come on. Tell him a little bit, that's fine, but, come on.
Yeah.
You can't tell him
nothing. Away all the secrets.
Yeah, just tell him, just warn him, don't use this case again. Don't come back to family court and don't use this case again. Case number again. I say, okay, well, what court do I take it? He said, take it into any court. District court. I don't care, but don't come back here. I was like, but that's what it said, stop. It was so funny. Imagine this poor guy trying to help me, and it's like me trying to help you guys. I'm like, stop. I'm playing what he did to me. So that's why I'm too upset, because I see what you guys are looking at.
Yeah.
You got a couple of years of getting your brains messed up by watching the silly stuff on YouTube. And fortunately, YouTube wasn't really around back in 2001, so I really didn't get my brain messed up as bad as you guys are. But now you're visually getting it. I used to just hear this stuff on the radio. Now you guys are hearing it and seeing it visually, so it's really getting pushed down your brains.
Right.
It's embedded. Now you could actually remember seeing a guy on an overhead projector and pointing to the Section 1 of the Canadian, now Section 33, and oh my God.
Now, Karl, they have their trial for this, not this coming week, but next week, 5 days. And we're not sure, we're going to be trying to put in our claim again this week. When we put in our claim, should this kind of stop their trial, put it on hold until our claim is heard?
You say since there's all the parties are going to be convening on that claim on that day for that hearing, well, we're going to have my claim heard at the same time because we'll try to limit the expenditure of county resources or Providence resources and province resources, whatever you folks call it up there. Are you in a county or province? What do you guys call it? A district? What do you guys call it?
It's a province.
Okay, well then you say I'm trying to mitigate any kind of wasteful of court facilities while we're all going to be here. We're going to have our trial for the return of property at the same time, and you could actually make a claim for compensation at that time as well, because that's the or else part of the claim. Because nobody's really going to take your claim serious unless you throw an or else in there. Like I told you before, don't put a compensation thing at this time. Get your kids back.
Right.
They're not going to take you serious. You say, you know what? Maybe they'll take a dollar amount serious. Because that's what the Department of Justice man told my whole family. Because I said to them, they said, well, how much are you going to sue? Of course, I said, I don't know, what, like $1? He says, no, they're not going to take you serious. They're going to give you $1. And he said, no, don't do that. He says, you better put a big number in there and make it a whopper. He said, they're not going to take you serious. So don't make too ridiculous a whopper. Just say, I want $10,000 a day, something like that. I'm not telling you that's what don't, literally say do it. I say, but don't make it like ridiculous, like $1 million a day. Make it just enough that if you don't mow your lawn, the Providence is going to charge you $1,000 a day until you mow your lawn.
Right.
You see what I'm saying? So it's like, well, hey, you charge us $1,000 a day if we don't mow our lawn. I want $10,000 a day or $4,000 a day for each kid.
So basically, our claim is, we want our property back now, or else we want this amount until it's returned.
Right. If I'm holding my property, you could use the word like full bracket, naked possession, without rights. That's all it means. But you don't put naked possession on it because that's a legalese word.
Okay.
You say holding possession, you put naked, full corner, so that way they don't read legalese on that document. To say naked possession of my property, I'm going to demand $1,000 for each, piece of property that's being held by 4 different individuals, or one individual holding all 4 properties, or, however people decide to scatter. I'm going to actually go after those people who are holding my child in their possession, my property in their possession.
Okay, so we're basically going to put in our claim, and we'll say, you know, for the sake of not wasting resources, we'll have our trial in the same time that they want to have their trial, but we're going to have ours heard first, basically.
Mm-hmm. So what I would do is I'd find if you say foster care parent X, Y, and Z, or foster care parent John Doe, or foster care parent Jane Doe, if you don't know the foster care parent's family that they're holding in, say I'm going to charge the family, $10,000 a day until I return the child to my custody. You could go after the foster care parents too. They could definitely be sued.
So we could put them all on there, basically the social workers, the foster parents, that all those people we could put on the claim. That's good news.
Yeah, so like I said, we could work on a little bit on the compensation thing if you want a little bit. But like I said, I've read in like the Alabama Code, I think it's under Title 36, like Section 1, Section 5E, where it basically says that foster care parents can also be sued and can be held liable. And that the risk management of the General Liability Trust Fund sets up an insurance policy for when a foster care parent does something wrong to somebody's child. So like I said, you don't almost want to make your kids like lepers, that nobody wants to touch your kids at a foster care home.
Yeah, basically.
And be afraid to accept them in. Regardless that the judge gave them an order that they could walk off with your kids. It's like I said, so like everybody knows like that German thing, just because Hitler made an order that they could kill all the Jews, the guys who killed all the Jews actually died after World War II.
Rob Ryder's been telling us to go after these companies.
How can you possibly imagine? This is my opinion, okay? How can
I hear you. I understand. Mickey Mouse is a piece of paper.
Like having, okay, O.J. Simpson got arrested and tried for a murder. They did not arrest and try, what was the rent-a-car company he was working for at the time, or the football team, or, it wasn't an organization of men hiding behind a fictitious moniker. It was a guy. It was a man. All right? Okay? And if you're going to do a criminal charge on anybody, you've got to find the man or woman who actually committed the crime. Because a corporation cannot commit a crime. A judge cannot commit a crime. A lawyer cannot commit a crime. An office cannot commit a crime. Only the man or woman that breathes life into that office or into that corporation can commit a crime.
Well, this crime took place back in 1979 when they didn't...
Or who wears the costume. Who's ever behind that mask? Who's ever behind that mask? The person means mask. Who's ever behind that mask? That's who you can sue, behind the person.
Well, so I have to go after the CEO?
You can't go after the CEO.
The man behind the man that's filling the position of CEO.
Yes.
Yes, you could do that, but you couldn't sue him for what you want to sue him for. You could only sue him for being negligent or complicit because he didn't actually physically, intelligently, intentionally do the crime. He was responsible for the people under him who committed the crime.
Okay, let me give her a simple one, too.
What are the odds that the person that committed this crime in 1979 are still around?
Ma'am, let me answer this, Greg. Stop. Remember, no, I got it. Remember Bernie Madoff, ma'am?
Pardon?
Bernie Madoff. Everybody remembers Bernard L. Madoff?
Right.
Okay. Now, he had a company called Bernard L. Madoff Investment Settled Securities, LLC.
Okay.
So when they arrested Bernie, did they also arrest the BLM Investment Securities?
Well,
they arrested Bernie Madoff.
It's a piece of paper.
But they arrested Bernie Madoff because he ripped off a whole bunch of little old ladies, right?
I guess. I don't know the story.
They said, well, okay, ma'am, let's just go with this. Let's just say yes, he's sitting in federal prison now in Florida, wherever now, okay? There was a lot of trust funds he had a lot of trust with a whole bunch of little old ladies, and his investment company got out of their money, okay?
Okay.
So there you go. So did they go down there and they arrest the building? Did they arrest all the office workers? What do you want to accomplish by this going after this insurance company? Do you know one man who knows beyond a shadow of a doubt, like Bernie knew? Bernie Madoff knew where all the bodies were buried. Bernie Madoff knew exactly what was going on. He wasn't just a silent partner or a silent owner who just happened to live in, Puerto Rico or Guam or Virgin Islands somewhere. No, this guy was an active participant in the crime. So they went right to the top. They went right after Bernie. They didn't go after the second guy, the third guy, the fourth guy. They went straight to the top. So do you know somebody at the top who is personally has knowledge that he did you wrong and knew what he was doing was wrong? His company knew that they were attacking little old ladies like you.
They're doing it. They're doing it now.
Yeah,
can you? What I am claiming is that they're a title insurance company. All they do is guarantee that their search was accurate. Okay, that's what they guarantee.
Okay.
So if the search was not accurate, meaning there were liens, previously existing liens that should have been paid off prior to my purchasing, or I wouldn't, if I had known that there was a bankruptcy lien on my land, I wouldn't have purchased it.
Okay, so what you're trying to say?
This ongoing today. They're doing this to everyone.
Okay, well, okay, ma'am. See, this is what I should do. Anytime somebody calls, I should ask you guys flat out, what's the question? Because you're basically saying that you had a title company research some information for you, and they gave you some information that was not accurate, well, not totally accurate. There was part of it that wasn't, 50%, 10%.
Right, fraudulent.
No, ma'am. They had to have a deliberate intent to defraud you. It's not fraud. They had to have a deliberate intent to defraud, not fraud. So if they had a deliberate intent
to defraud me, okay, they defrauded me.
Out of your property, which is your money, your time, your labor, your efforts,
and
whatever.
Then it caused me all this money in property taxes as a result.
All the information on that piece of paper is not in error. I'm sure they spelled your name right. I'm sure they spelled the name of the property right. But I'm sure there's something on that piece of paper that you believe is an error, right? That research that they did for you, something on that piece of paper is an error. Okay, so the whole piece of paper isn't wrong. It's just parts in that piece of paper that doesn't fit a certain timeline or doesn't establish the proper person that the property was assigned to one time in the past. So there's just something on that piece of paper that you found out by doing further research that these people didn't do their job properly. Is that basically what you're saying?
Right, and they're doing it to everyone, not just me.
Hey, ma'am, you can speak.
Are you saying that somebody who works there made a mistake?
I don't think so. No.
So, well, Greg, let me try to work with this lady right here. So, ma'am, like I said, first of all, because this is going out to a lot of people, Greg. So, when somebody says something, I got to stop them and correct them so other people don't do this. When you make a claim, you can only claim for what you witnessed in your eyes at that particular moment in time in history. You don't know that they did this to everyone else. What you do know that you could swear on a stack of Bibles is what you witnessed.
They did it to me, right? Right. I'm just saying that it's an ongoing thing, and it's got to be that if they did it to me, they did it to everybody else. But I'm going for myself. Yeah.
If you presume, ma'am, because if you presume it, that's okay. That's just an error, a mistake. If you assume it, and you start spreading false rumors that everybody else they did this to everyone else, ma'am, you're setting yourself up to be liable to be sued for defamation or slander. So you don't just,
I hear you.
I'm trying to warn everybody, not just about this one particular case, not just it's all about you, it's all about me. It's everybody listening to this thing. You've got to be careful when you embellish a story because it sets you up for libel. You can't do that.
Okay.
But what I'm saying is you know that they did something on that piece of paper, and by you going back checking to check their research, you found that they did something by mistake or an error, but you presume it was a deliberate act to defraud you out of your property and to trick you in some sort of artificial scheme. Is that what you believe?
Yeah.
Now, what in particular do you notice on that piece of paperwork? Particularly on that piece of paperwork, did you notice that you believe there was cause you deliberate harm?
That there was a what?
What caused you deliberate harm? What statement or what sentence or what phrase or what was on that piece of document that you think that they deliberately gave to you to cause you harm, to give you, amuse you, to confuse you? What did put on there?
What they didn't put on the paper. A title insurance company is supposed to give you a list of liens.
Okay.
Right? And with a grantor has to say, these are my liens, right?
Man, when I stop you,
pay them off.
Man, the reason why I'm stopping you is because I'm going to ask you a really good question, just specifically about you. How do you know that that's what a title company does? Is that what a title company is supposed to do? Give you information about liens?
A title company gives you, they do a title search.
Okay.
And they guarantee their insurance, all their insurance guarantees is that their search was correct.
Okay.
So that there's no liens on your land.
You actually have a piece of paperwork established with this title company that says, look, if we are in error, we guarantee if we are in error that we will compensate you for any loss or harm that it might incur to you based upon our slack research. You have something in writing that says that they'll protect you from their slackers.
I'm not sure the exact wording, but that's basically what a title insurance is. The state of New Jersey is that the title insurance company guarantees title search.
Let's just get away from contracts and insurance right now. Anytime you intercourse with anybody, okay, when you go into the public, you're intercoursing with others in public. So everybody knows when you intercourse in business with others, especially a stranger, you might pick up a communicable disease. You might pick up something that's going to harm you. So when you are going to engage with somebody, or like they call it in the Constitution, they intercourse in commerce, because that's exactly what it's written in the Constitution of the United States. Google intercourse in commerce, United States Constitution, you'll find it. So everybody understands when you go out of your front door and you start touching other human beings, or you start contacting other entities, fictional or real, you can be harmed. Everybody says stranger danger. Mommy told you when you were a little kid. So when you intercourse with somebody in business, you better know who you're dealing with. Did you background check to make sure this title company was up front? Did you read the contract? Did you have a little trepidation? Did you have to put your little fears? It's just like dating somebody, courting somebody. When you're on a courtship, when you're courting somebody, you're going to judge them by their acts, by their reputation, how they establish themselves in the past, how long they've been around. Just like when you want to have a husband or wife, you're gonna background check them a little bit before you jump in with both feet and say, I'm all in. I'm gambling with everything I got. I'm all in. So all I'm saying is you better go back. You better look at that contract that you have with, I don't care if it's an insurance company, I don't care if it's whoever you got. You got to see in a contract that says if we make any errors, if any of our slackers that we pay $2 an hour to do this research for us makes a mistake, we are not liable. This is 100% on you. So you got to go back and really read that contract really good and come back to us and tell us, it doesn't say anything there about mistakes or errors, or it does say something about mistakes and errors, because right now it's just all conjecture.
You're saying, wait a minute, you're saying that they have errors and omissions in the contract?
They could say if there's any errors. If we make an error, it's not our fault. We did the best we could with what the tools we had available at this time, and this is the best we could do. It's just like if you hire somebody to lay bricks in your house. You could get somebody like a Picasso to lay a brick, or whoever's the world's greatest sculptor to come in your house and lay a brick. Or you get me. I can lay bricks for $2 an hour. Big deal. I don't lay bricks that good. Now, if you really want to hire somebody like Da Vinci or Michelangelo and he's going to sculpt your brick house, well, geez, it's all what you paid for. Based upon my reputation, you're not just going to say to somebody, hey, man, put up some bricks for me. Okay, you're going to say how long you've been doing business, are you bonded, are you insured, how do I know my house isn't going to fall down, or the first time it rains, or the motor's going to fall out of the joints. You're going to do a little research on these people. So like I said, so if you're a slacker, if you know you're a slack title company, maybe you actually wrote a contract to say, hey, you know what, to protect us from being sued, because we're really slackers, you know what, we're going to put all these kinds of warnings, caveats in our contracts and say, you know what, when you engage with us, you intercourse with us, it's at your own risk. I don't know if that's what your contract says. You really have to read the contract. Just because you believe what a title company should do, I can call myself a sculptor. Michelangelo could call himself a sculptor. Now, do you want to pay me $1 million to sculpt something for you, or do you want Michelangelo, based on his reputation? Who are you going to give the $1 million to? This is all I'm trying to say. Really read that contract and make sure that the services they provided for you, somehow they didn't try to figure out a wiggle room to get themselves out of being liable for you. See what I'm saying?
Well, yeah, but I don't see how defrauding me is part of a contract.
Part of them,
they can't cover themselves with the...
Go ahead, Greg. You can go.
Defrauding me, no? Can they?
Go ahead, Greg. Maybe you understood what I said. Go ahead, Greg. Explain that.
Richard, I don't see how you've been defrauded. Okay? Do you use a Microsoft Windows computer?
Do I use what?
Do you use a Microsoft Windows-based computer?
No, I don't.
Do you use a Macintosh?
Yes.
Okay. Now, if all of the stuff that you're working so hard, all the data and all the files and everything you typed up and everything is on that computer, and it turns out that there's a bug in the software that on April 25th, the whole thing goes explode, and everything you have is lost. You know you can't sue them, right? You can't sue them.
I'm not going after a mistake. I'm going after fraud, defrauding me.
I really want to emphasize this.
Okay, go ahead.
You don't know. You do not know if you're going after a fraud. You're going after something that has caused you harm. You do know that for a fact. Something has caused you harm. And
all right, then I'm not going to do a criminal complaint then.
It's raised the hair on the back of your neck, and you want to do something about it, but you're going forward without the complete set of information that you need to protect your claim. Okay? You're going forward not with presumptions, but with assumptions. You're going forward doing things that are going to come back and make you liable. The boomerang is going to hit, and it's going to come right back on you, and you're going to be nailed for making false claims. And you're going to go, what the devil happened? And you're not going to know.
How do I avoid a false claim?
Because, first of all, you have to have all of the information. You have not done, according to what you said, perhaps you have, but based on the conversation so far, it's my belief that you have not performed due diligence, that you have not really drilled down to find out who the wrongdoers truly are, okay? That, in fact, that there are any wrongdoers, okay? If there is a fact of an omission or an error, and you have not been able to tell us in this conversation whether or not your insurance policy absolutely covers errors and omissions on behalf of internet staff, that hasn't come forward. You haven't shared that with us. In this conversation, we're operating also on a number of presumptions, okay? And so it's really impossible to give totally perfect information back to you without totally perfect information coming forward from you. So, what I'm trying to say is, I believe, and it's only my belief, that you need to do more homework. You need to go and either communicate with the insurance company or the title company or the various different people to find out absolutely what your contractual rights are. Not your inalienable rights, your contractual rights. Okay? What is actually covered, what is actually not covered. Okay? And don't do it in a combative way, but do it in an investigative way.
Greg, that's really
find out the things.
Good. That's good, Greg. I'm going to break it down a little simpler for you because this is what everybody needs to know, not just North New Jersey lady. Everybody.
Okay.
Let me break it down a little simpler, Greg, because you went past it, and I need you to reel you back. Maybe you could do it a little better. But all I'm trying to say, man, is when you intercourse with somebody, the product of your merger with those people is your baby, and you're liable for that baby. Now, once that baby's born, you can't start saying, well, I have inherent rights to not own that baby. No, you created it by that merger, whether it was a fictional entity or a live breathing entity. When you intercoursed and you incorporated and you created a product called a baby, you're liable for it. So if you're going to say, well, I'm going to use God-given right and I'm going to waive all liability to this fictional product that I created by intercoursing, and I don't want to be held liable. It's like a guy saying, well, I don't want to be held liable for child support. What is the terms and the conditions of the contract and the parties in which agreed at one point in time? And then Greg took it from there, which was fine. What I had to stop you is to try to show you how it's no different in biological human intercourse with each other as when we merge with the two-dimensional.
In this case, what's the baby?
I got two words. Buyer beware.
You got to be careful who you're intercoursing with. The baby is whatever an abomination that you guys have decided to create together. If you didn't really read the terms and the conditions, and you really weren't skilled in intercoursing and reading the definitions, let me put it this way: if they wrote the contract, you better believe it was meant to get over on you. If you didn't read that contract and say, I'm not going to do this, I need this done, I need this guaranteed, I need this warranted, I need this held liable if this is wrong. If you don't make modifications to that contract that other side proposed to you, it's all on you. You had the right to amend the contract. You had the right to adapt. You had the right to read it and interpret it. So to me, is if you just said, I'm just going to sign it. Like, did you write that contract, man? No. Okay. Do you have any idea what those words mean? No. Why? Because you're not the creator of it. Like I tell people a million times, it's a freaking Picasso. You know what? Picasso just sees an elephant holding a banana standing on a blue bowl. Everybody else thinks it's universe and kumbaya and some sort of metaphysics, transcendentalization nonsense. It's not. It's an elephant holding a banana on a blue bowl. That's what Picasso sees. He's like, oh my God, how does everybody see that? I see an elephant. So he's the creator. If you don't create the contract, man, and you just say, I'm signing off on this some ridiculous belief of what the creator says it is, well then, what do you want us to do? You engage with them, what do you want us to do? You have to prove that contract was deliberately created to cause you harm. Good luck with that, because I'm sure they had a team of attorneys write that contract up. So, like I said, can you always take them down to the common law? Sure. Can you always play a common law game like me? One sentence, two sentence done? Sure. But if you guys want to keep doing this notary process, affidavit stuff, client hire, you want to do all this paper two-dimensional world? Well, then you better be really skilled in the two-dimensional world, because I have no time or desire to master that two-dimensional world when I could get this thing done in a sentence or two. So
Wait a minute. You're telling me that I should take them to common law court, and it's a different story?
Nope, because you contracted with them in good faith. Now, what you're going to try to do is you're going to try to play the common law trump card, and you're going to try to smash them because you think that they did you wrong. Can you go common law on these people? Oh, absolutely. But to me, that's not when you, like I said, if you make that baby, you pay for that baby. So, can you say, well, I can't really afford to pay all these child support payments? Sure, fine. What can you do, dude? We don't want to hurt you, buddy, but honestly, what can you do? $1 a day, $1 a year, how much you want to pay, But to me, if you engage with somebody and you engage with contracts with any level, two-dimensional, three-dimensional, fifth-dimensional, whatever creature that you're engaging with, you should live up to your terms and agreements of the contract. So you better be really careful that you read these contracts really well. Because to me, yes, you should be liable for the mess you create.
Let me jump in on this.
Go ahead.
Patricia, what this is like is, I'll try to draw a metaphor for you. Let's say you live in America, right?
I made a right.
And you live in America.
Right.
And you decide to go on summer vacation to Portugal. And while you're in Portugal, you meet this really fascinating couple with this little business, right? And they wow you and woo you, and they feed you, and they give you delicious wine, and they show you their entire family and their photographs from 16 generations, and you just absolutely believe in these people not because you did research, but because they're great at doing a sales pitch, all right? And so you go, I want to help you with your seashell business, okay? I want to be an investor in your seashell business. And so you make this agreement with them while you're on vacation in Portugal, right? And then you come home and you sit down at your computer and you do some research and find out that this family is a bunch of gypsy con artists from, like, you know, the turn of the century. And you go, oh my God, I can't believe I did that, right? And you go, oh no, I don't want to do this. I don't want to do this. These are bad people, you know. But you didn't have access to your own resources at the time. You were being loud and wooed and approving of the idea. So now you run back to America, and these people try to sue you across the Atlantic. And you go, nah, 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 I'm an American, you can't touch me, you know. And all of a sudden you find yourself in the United States District Court, and these guys are suing you. And you go, oh, they're criminals. Oh, it doesn't matter. You got a contract, man. You know, and it's like, well, but they've got this history of, like, ripping everybody up. That's not your case, man. Your case is this case. Your case is you signed a contract with this man and woman to help them with their seashell business, which, of course, we all know is bullshit. However, you agreed to it. All right? So at the time, you had the ability to say, you know, this is really exciting and interesting. Let me go back to my home and let me organize and sort out my thoughts, and I'll come up with a proposal for you. No, you didn't do that. You just jumped, signed it, and you, oh, I want to have sex with you right now. Boom. Okay, well, that's what you did. You married him, you had a baby. You made that contract. That contract is your baby. Now, you've done this all through your life. I've done this. We've all done this because we didn't all get trained to think like this when we were kids. You know, I'm like almost as old as Moses, but I'm just trying to tell you, I'm embarrassed for myself for all of the stupid and foolish things that I agreed to do over the years. So what I'm trying to say to you is that you cannot play jurisdictional immunity with common law. You are liable for what you do in any jurisdiction in which you have put your foot.
So fraud means nothing. If I was defrauded, it means nothing.
If you know what, you can't prove, you haven't proven to me, you know what, I don't believe you were defrauded. You haven't proven it to me. I don't even feel sorry for you yet. Okay? I don't even feel sorry for you yet. Matter of fact, if this is all you got, I think that you're just a loser. Okay? Honest to God. But if you can give me more, I might believe you. I might get on your side. I might get on the bandwagon. I might drive to Washington, D.C. and fight for you. But right now, you're a loser. All right?
So Greg means loser in a nice way because Greg actually did this nonsense. Greg always plays I always play the role, you pay your damn mortgage, Greg, and shut up. And Greg's like, no, they defrauded me, and I shouldn't have to do this, and I could prove this. So see, man, Greg and I play both roles. Greg will play the lovable loser victim of mortgage fraud and scandal, and then I'll play the hardcore guy in common law that just says, you made the agreement, you live and die by your agreement. So he knows how to play both roles. He knows how to jump on you and say you're a loser, but in the same breath, he knows how to play the loser because he's gone through a mortgage thing and he's trying to figure it out himself. How can he get out of this mortgage nonsense mess? He's trying to do the same thing you're trying to do. So
let me go back to the point that I was trying to make, Carl, was this. When you step into a different jurisdiction, okay, and I'm using the word jurisdiction really loosely, okay, when you go into a different neighborhood, okay, if you grew up in the Bronx and you decide to go to Manhattan, if you're on the Lower East Side and you decide to go to freaking Harlem, okay, if you're on the northwest side of Chicago and you decide to go down to the west side, you know, whatever, when you go to a different neighborhood, go to a different jurisdiction, you've got to be sharp to the rules of the neighborhood, okay? And if when you're in that neighborhood, you make a deal, and then you follow that deal to the nth letter, and you stay in total honor within the rules of that neighborhood, and the other side tries to cheat you while you are still following the rules, and you document the entire process, and you record the entire process. Then, if you can exit that jurisdiction or that neighborhood in honor, you can then go into common law and use that as evidence for your common law claim and try to achieve a victory. Only if you have clean hands and stayed in honor at all times within the terms and scope of the common law of that other neighborhood. Got it?
Well, let me put it another way too, because most people don't understand this simple thing. If you have a contract with you and me, and let me do Judge Judy, because everybody respects Judge Judy. Some little old lady from like New Jersey said to Judge Judy, well, I have this beautiful picture of a swimming pool from a Good Housekeeping magazine. And it was this beautiful blue color. So I got this guy who builds swimming pools for a living. And he says, you want that color tile for your pool? And she said, yes. You know, I want that color tile for my pool. So he said, okay. He went to Italy, spent $10,000 on the tiles, brought the tiles back, and installed it in a pool. When they filled it up with water, it wasn't the same color as was in the magazine. And the lady's like, hey, I'm not going to pay you for building the pool because I told you I wanted my pool to look like this. And the guy's like, no, you told me to get the color of tile to look like that color blue. So I got that color blue. She says, no, when the pool was done, I wanted it to look like this color when it was filled with water. She says, that's not what you told me. You told me you wanted color blue like this. Like you showed me blue on a bowling ball, or blue on a bird, or blue on a car. You just told me you wanted blue tile. You just say when the pool is finished, when it's filled with water, I want it to look like this. So when she filled it, it was a little off, not that same color. So Judge Judy says, ma'am, do you have a contract with this guy to build your pool? Yes. It was like, how much was it? It was like, like $100,000. Pay him every damn dime now. Fulfill the terms and the conditions of that contract. Then come back and sue the guy. But he gets every damn dime that you agreed in that contract to pay him, and you pay him now. You're in dishonor, man. And now somebody talked on Jack's show, one of the last Jack's show, and I went around with this man. This man is correct. It's called Rules of Statute Staples. It's an old set of laws, man. It goes back thousands of years. You pay every damn penny you owe that other person, then you sue them. You don't say, well, I'm not going to pay you because I don't think I like the service. I'm not going to pay you. No, you're going to find that judge, and that judge, like Judge Judy, she's going to say you have to pay every damn dime for that service. Then you're going to come back, and then you're going to prove to me he defrauded you. Then you're going to prove to this court that he deliberately went out, and he bought these tiles of this color, and he knew you wanted it to look that color when the pool was full of water. Prove it to the court. Then we'll turn around and hand you back your money, all the repair bills to make the pool look that color. But, lady, all the proof is on you. If you give him money to do something, a contract, you pay him every damn dime in full. Like I said to Greg the other day. Greg, I said, you're going to get a bond, you're going to pay that $200,000 mortgage off, you're going to turn around and you're going to sue the mortgage company. But you're going to pay every damn dime off. Then you have standing in court. Once that contract's proved, then you're going to prove they committed fraud. That's how you're going to do it.
It's really funny, Karl, because, in my profession, doing a lot of custom engineering for people, one of the things that we traditionally and customarily offer is, in terms of payment terms, somebody wants us to make something that never existed before, and so that's very tenuous to begin with, because it has high likelihood of a customer dissatisfaction, because everybody's operating on imagination, and you're trying to come up with a contract to describe something that never existed before. And so you don't even have a photograph to go off of. So at the very beginning that there's a high likelihood of customer dissatisfaction. So you write your agreements with the terms that say, okay, you're going to give us 50% up front because this is a huge investment on our part to develop this for you. All right? And then when we deliver it, you're going to give us 30%. Okay? And there's a 20% or a 10% left hanging in the wind. You could say, you can leave 10 or 20% out at the end for final customer approval. All right? That way the customer who wants something special knows that they have, you have agreed to give them a trump card, right? So that if they're totally not satisfied, their bitching and moaning can accomplish you not getting that last paycheck, right? Now, as a vendor, what you do is you structure your order, you structure your entire price so that your first two payments cover everything and you don't lose any money and you make a small profit, all right? And if the customer is happy, you get a balloon at the end, all right? And if the customer is not happy, you go, okay, you know what? We're done. You're not happy. You don't have to pay the last 10%. You don't have to pay the last 20%. I forgive you. You forgive me. I'm walking away. Now he can't even sue me because in terms of the agreement were, the last percentage was for customer satisfaction. Now, was he satisfied? No. Did he pay for customer satisfaction? No. That's what he would have had to pay. So now everybody walks away. He gets whatever the hell I built. I get the money that I freaking invested in it and a small profit that all my people paid. And everybody walks away and nobody has the right to sue anybody. Okay? Now, if you know how to write a corporate contract or you do business, like I've had to do for 30 years, then you know how to do that. Now, nobody ever does that with their own personal life.
Hey, Greg.
Nobody ever goes to a mortgage company or a lawyer or anybody else and bust them on that stuff. They only do it when they go to work in the morning. They don't do it in their own personal stuff.
There you go. If anybody needs a contract written, have Greg do it. He's a hell of a contract writer. Okay.
Sounds like he's covering his own ass there.
But this is what I'm trying to say, ma'am. Greg went on a little bit there, but
I mean, is that the way these contracts are really structured, so that the 20% or 10% at the end, they're not losing anything?
That's right.
Huh.
Right, because like I said, what's funny is like when people try to go down and they boo-hoo me a lot because I always bash the people. I always play the opposite side of the mortgage crowd, because the only people that are listening to this show, any show like this on the mortgage crowd side, are the people who are on the underwater with their mortgage. The people who bought their house for $100,000 and sold it to the suckers who paid $500,000 or $1 million for a $100,000 house. They're not listening to this call. The people who are listening to this call are the people who got this $1 million house that's basically worth $100,000, and now they're trying to find a loophole how to get out of it. So when I say, well, wait a second, you signed a mortgage and bank, mortgage, I say, what makes you feel that you should have the right to just walk away? Because you lost on this Ponzi scheme, because you knew it had to be a Ponzi scheme. You knew there's nothing in your right mind. When you added up all the board feet, all the windows, all the nails, all the material that it took to build that house, came out to about $50,000, $60,000. There's no way in the world you're going to possibly tell me that that house was worth $1 million. It's like they're buying a diamond. It's like they were buying gold. Like, look what's happening to gold. Gold's plummeting. You can't possibly tell me that $200 piece of gold a year ago is now worth $2,000. How do you figure that? And now everybody who's bought into gold at $2,000 an ounce because the world's going to come to an end, now they're taking a beating because it's going down to the $1,000 mark. And everybody's going to say, my gold broker defrauded me. He told me gold was only going in one direction. It's going up. Gold has been around since time. Ron Paul says buy gold. What, you going to get Ron Paul for defrauding you? It's you know, so when they started, so like one guy said bilateral, unilateral contract, it's like, nobody told you intercourse. Nobody told you to have sex. Nobody told you to do what you did. You did what you did. You had to know the risks of the game. You want to play the game? You want to put your feet on a bed, on a floor in the morning and walk out that front door? It's all on you. All on you. So you just got to be smart and know who you're engaging with and who you're intercoursing with. I mean, you could just bed hop from guy to guy to guy, or you could be one woman who stays with one guy for eternity. God bless you. Or you could be the bed hopper. The bed hopper obviously is going to have her point of view, the benefits of bed hopping, and obviously the woman who stays with one guy is going to have her benefits and why she believed the same thing that he did.
Constructive fraud.
Okay.
And the fraud is built into the system.
Right.
Constructive fraud. Okay? Now, the really cool thing, the thing is, if you could ever prove constructive fraud, there's no statute of limitations on constructive fraud. Okay? When there's a fraud by a man or a woman or somebody who's done something to you, you've got, even in their statutory rules, you've got a time limit in order that you can go back and defeat them. In their own rules, constructive fraud may be exposed anytime. If I wanted to prove constructive fraud by the Constitution of the United States, I could do it today, okay? If I could prove that constructive fraud, and there's no statute, I could do it today. So, if somebody has committed fraud on you in a constructive fraud kind of a way, while they may or may not be personally liable for it, the system is liable for it, and it vacates everything and everyone that was ever ruled against by virtue of that particular error in the system. Okay? So, the possibility exists if you can prove constructive fraud, and this is what they do as a matter of course. And eventually, if you win your case, as you probably will, and go back and recruit 1,000, 10,000, 100,000 other Canadians to come and say, you know, we got pooped on in the same way, you could actually come up with a case that could prove constructive fraud and overturn and vacate all of those judgments that were ever made by virtue of that particular operation.
Okay, let me stop you right there, Greg. Greg, stop. Because, like I said, I could actually tell you a case where this is a true case. Believe it or not, it's going to sound goofy, but you got to be careful when you use the fraud, like constructive fraud or fraud in the inducement or fraud in the factum. There's a difference. There's an actual case. I'm telling you, man, it's called Burrow versus the Superior Court. Okay, this is a funny case. This only happened in 1985. So we'll see if you can watch the silliness of this. The doctor, Dr. Stevens, called up the victim. Okay. And he's saying that he was Dr. Stevens from the hospital and that the victim had a life-threatening disease. So he told her, he presented her, believe it or not, this is true, this ain't a joke, with two options. The first option was to have a painful surgery costing the victim $9,000. You can Google this. It's BORO versus Superior Court, 1985. Two options he gave her. He said you could have a painful surgery that cost you $9,000, or she could have sex with him. And it really cost $1,000. Okay? So the victim had intercourse with the defendant, believing at the time that her life was threatened and that was the only choice she had to cure this horrible disease. Okay? This is true. The victim, upon learning the truth, brought the charges against the defendant for rape. Okay? The court held that this was fraud in the factum, and therefore there was no rape. Okay? It was fraud in the inducement, because the deception related not to the thing done, the sexual intercourse, but merely of some collateral matter, like the cure of the life-threatening disease. So that's what he really did. So you got to be careful when you use fraud in the inducement or fraud in the factum. Like when you say fraud in the factum, fraud in the factum is more of misrepresentation. It causes somebody to do something without realizing the real risk, the duties, or the obligations. It's like saying that let's see, John tells it, let's say some guy tells his mom that he's taking a college course on handwriting analysis, and for his homework he needs her to read and sign a pretend deed. So his mom signs like this deed, believing that, John said he's just trying to work on his lawyer skills. And well, John really has his mom sign this blank piece of paper or this deed, and then he fills in the rest. That's fraud in the factum. Okay, that's just flat out fraud. He just had his mom say, "Oh, I'm just doing some handwriting analysis skills. Can you sign this blank piece of paper?" So she signs a blank piece of paper, and he writes, "Well, you just transferred all your property over to me." Okay, that's fraud in the factum. See, fraud in the inducement is just a trick to try to cause somebody to do something to take away your real property away from you. Okay, it's right. Fraud, right.
And fraud in the inducement and fraud in the factum, on the statutory side, both have a time limit in which you can prosecute.
Good point. But when you claim that you're a man, you have no statute of limitations. Anybody doing you wrong, whether it's
no, but like we were saying earlier, sometimes we as men can move freely in any jurisdiction we want. If we're going to go and operate in that jurisdiction, there's a time limit, there's a statutory limit to prosecution. And so the point that I was making was that, fraud in the system. If the system itself is fraud, there is no statutory limitation.
What I'm saying, that was a great example that you gave us, that it was fraud in the system. But if she signs a contract and she works with these people, then there's going to be a statute of limitations on what she can and cannot do, because somewhere she signed a contract. So they will have latches on that, built into that contract, what the parties can and cannot do, what one side is liable for, what the other side is not liable for. But as long as she stays as a man or a woman and does not bind herself with this intercourse with this monster, because she's afraid of some crazy home disease she's going to get, she stays away from it. If this monster ever tries to claim that we had an agreement, she knew all along, and she's bound by these statutes of limitations. No, she's not, because she never had a contract. She never talked to these people. Anytime these people looked at her in court, she was like looking at ceiling tiles, because she's like, what? Are you talking to me? You got a claim against me? Is there a claim before this court? Yes or no? I haven't seen one yet. Well, I got all those people. Man, is that a claim? Well, no, it's a claim. I only answer the claims. I'm a man, I'm a woman. I only answer claims. I don't answer that. Anything else? Sir, Mr. Guy in a black robe, is that true? Does man only have to answer to a claim? Is there a claim verifiable before this court? Yes or no? No. Then what the hell are we doing here? Well, they want to just talk jibber-jabber about the code and how you're never going to get your kids. Okay, great. Is that based upon a verifiable claim? Is this not a common law proceeding? No, this is an administrative code proceeding. So, you think I'm some sort of code decipherer? You think I'm going to sit here and try to get some jibber-jabber and try to interpret code? You think I should get a code interpreter here called a lawyer and attorney to decipher your jibber-jabber for me? No, I don't trust any of this, because the first duty of that attorney or the lawyer is to this court, not to me, is to the court and the rules established under those codes. His first duty isn't to the rules of common law to protect his client. His first duty is to protect the code. The rules of the law that are before this court, his first duty is to the law. The law before the court, there is a rule established by the other side. Whatever the other side established as the rules of the court, as the law of this court, that's his first duty to do. So if I try to tell my attorney to say this, object to this, he's going to tell me, shut up. They're in compliance with the rules of the court. You say, no, I got these rights. Not in this proceeding, you don't. You're the defendant. You didn't establish the rules. You don't have those rights. You will have them in common law, but you don't have them here. Shut up and sit down and stop. And she said, but I have a constitution. You ain't got boo. I got the Great Charter of 1982. You ain't got squat. Sit down and shut up. The terms are written in the contract. There is no contract between me and your side. What? What do you mean there's no contract? There's no contract. Tell them to bring the contract forward. Oh, they definitely have to have a contract. They have something that binds you to that. Oh, I'm telling you, Judge, they don't. Tell them to bring it forward. Tell them to bring a law before the court. They say, the judge says, is that true? Is there any contract? Is there any law before this court? And they say, well, no, sir. It's like, oh, my God. You realize what you're doing to these people? The other side knows exactly what they're doing here. If there's no contract before the court, if there's no law before the court, they're filing a false claim. It's frivolous. It's a perjury. There's all kinds of words for that. For moving barratry, it's ridiculous what they're doing. Because, like I said, the very simple claim that I had Jesse do was basically saying, I, and then her name, and says, claim the wrongdoer's trespass against my property. See Exhibit A. And Exhibit A was her property. Number two was there's no law that exists which binds I to the wrongdoers. There you go. Since there's no law that exists which binds I to the wrongdoers, there you go. Is there any law that has a jurisdiction control over me? Is there a contract? Is there something that binds me to the wrongdoers? No, I have no idea who these freaking people are. I've never seen them before in my life. They just manifested themselves in front of me one day, and I have no freaking clue what they're doing in my life, but I want them gone. Okay, that's number two. Number three, I require the delivery of all said property to be under my jurisdiction no later than April 18th, 2013. Number four was I will place a charge of $1,000 per day per said trespasser and said agency for any failure in the restoration of property on said date. Number five, if the placement of all said property does occur on and or before April 18th, I will forgive those who trespass of their debt as I would wish others to forgive me of my trespasses or my debts. That was the whole lawsuit. That's all you need for a lawsuit. Nothing else.
I've been in contact with an attorney over an account in Mississippi over a traffic citation that my wife received on Easter Sunday. And he proceeded to tell me that I was not entitled to discovery. And when I asked him what their standard of proof was, he said, "What do you mean?" And I said, "Well, is this a civil or a criminal matter?" And he stated that it was neither. And that because of a law in Mississippi called implied consent, that I'm not entitled to discovery. She's not entitled to discovery. She's not entitled to basically anything. So he told me I've got three choices: guilty, not guilty, or contest the ticket. And I said, well, I don't have enough information to make an informed pleading at this point, and for me to contest the ticket would be dishonorable. So I need more information. And he goes, "Are you an attorney?" And I said, "No, sir." He goes, "Well, have you talked to an attorney in Mississippi?" And I said, "Do I need to talk to an attorney in Mississippi?" And he stated that it never hurts to talk to an attorney. Well, I got a little smart mouth with him, and I let him know what I thought about attorneys, and he hung up the phone on me. So I thought, he's sorry, SOB. So I called back to the courthouse, and I explained to them that I've got a situation, and I need to speak to the judge. Mm-hmm. She took my name and number, and she left it in the judge's box, is what she said. So they haven't called me back. That was 3 days ago. But the little tidbit of information that I did get was that it appears that if I don't enter any kind of pleading at this point, they cannot move forward. They can't move the course unless they have basically my consent. So I wondered what you thought about him depriving me the right of due process and equal protection of law. I mean, is that valid in their court?
Well, like I said, to me, when you come dealing with well, I'm saying, off the top of my, like I said, everybody has every human being on the planet, there's a law. Everybody creates their own law. But what the government recognizes, they recognize the way you would define law would be like categories like absolute law. You want to do it like a criminal law, administrative law, bankruptcy law, civil law. So like I said, if I just basically did it alphabetically order, which would be ridiculous, it'd just be like administrative law, absolute law, admiralty law, bankruptcy law, canon law, civil law, common law, constitutional law, contract law, corporate law, criminal law, ecclesiastical law, equity law, family law, federal law. So when you ask them, is this civil law? No. Is this criminal? No. Is it one of maybe these other 28? Possibly. Or maybe it's a private law established between a contract and you and Department of Motor Vehicles. I don't know. So like you could say to the other side, what law is moving this court? But you don't say it to the judge, you say it to the prosecutor. Who's moving the case before the court? Now, what did the prosecutor define the law as?
He gave me unsolicited legal advice.
There you go. What you need to do is submit a bill of particulars. You just say to him, okay, I got the bill. I got your bill. Now, I got your invoice. Now I need your invoice statement. Give me the bill of particulars. And one thing I need to know in particular is, what law is this? Show me the law that you're relying upon to prove your claim before the court, or complaint, I don't care, or civil or bankruptcy or admiralty or all those ecclesiastical, whatever other law that I just said, because there's billions of laws, billions and trillions of laws. We read laws every freaking day. So just because it's not civil, no, it's not criminal, you people just think there's two laws. That's ridiculous.
I got you. So it goes back to establishing to know what, not venue, but what jurisdiction you're in.
Jurisdiction. What's jurisdiction mean? What's jurisdiction?
I guess jurisdiction to me means the place of action.
No, I mean, that's a venue. Jurisdiction means gives you the right to control me. Control and jurisdiction is the same thing, because our contract controls you, and you perform a certain duties, obligations, and functions, and you have certain privileges and rights ascribed within that contract. Okay? There you go. That's jurisdiction. Not
well, I'll do some research. I'll pay what the particulars in. Thanks, Paul.
Right, because if I can jump in real quick, because what the legalese people are going to tell you is that it's got to be either
legalese.
Or subject matter. Right. I said that at the beginning. I said the legalese people will tell you it's got to be either in res, in rem, in personam, or subject matter. Okay? The whole point of it is that you cannot have in res, in rem, in personam, or subject matter if the law does not apply. And the law is the jurisdiction.
Not so much the law doesn't apply, if the law does not exist.
Okay. It does apply or exist. Well, what happened is the other I said.
He was attempting to misfly a statute to me.
It doesn't.
And I didn't want. I know it doesn't matter. I didn't want to get into it with him at that point. But even reading the statute, I believe he's committing constructive fraud.
That's okay. What I'm saying, he at this point has the gun. He has the whole ball of wax. It's his court. It's his court. It's his claim. It's his complaint. You haven't established court yet. You haven't filed a counterclaim yet. So you can't be a defendant. You want to be a defendant, you're going to get clobbered. So you want to operate under his law. You've heard me talk about this many times, right? You've heard me.
Yeah.
Okay. You have to understand. You have to establish your own claim. Okay. And so that they're moving this court with no claim before this court. There is no law before this court. Where's the law? I've asked him a million times. Where's the law? And he has to produce the law. And he can't do it. He can't do it verbally. You want to see it in writing.
In writing.
That would make them say, well, under Mississippi Code 48. No, you put it in writing. You show me. You show me. So you start square one. And you're not ready to proceed in any kind of tribunal or hearing or dispositional matter or trial until you're ready to go. You're going to stay in proceeding. You're going to stay in proceeding until you're confident to stand. Until you understand how the hell do you, I still don't understand how you're doing this to me. You're going to have to show me. Keep showing me. Keep showing me. And when it comes to a civil matter like this with the state can't force you to be confident until you're ready. You can just keep playing this ridiculous, if you want to do English common law, you can play this volley back and forth all the time. You know, as somebody files a complaint against you. And then it's in this subjection, and then it's a counterclaim, and you just keep volleying back and forth because this guy really don't care. Because the reason why he doesn't care is because he's getting paid. He doesn't going to care less if this goes on for the next 20 years. And while that ticket is outstanding like that, they're going to convert that ticket, that citation. They're using it as proof that there's that value of the ticket, $100 ticket, and they're that $100 ticket. And you know how people are trading on a derivative and all that.
Right. They're claiming it as asset.
Right. But what I'm saying is when you get to the certain point, I don't know if you've heard of it, see my thing, heard my stuff. I love tickets. I love citations because I'm going to file a counterclaim. And whatever the value is on that ticket is going to establish prima facie proof that ticket, that citation is worth $100. So not only do I believe that's worth $100, he believes it's worth $100. Well, now I believe not only is it worth $100 the citation, but that proves that now you've wasted my time, my resources, my energy, my patience, and I'm going to not only claim all equity in that citation, but I'm going to place damages of wasting my time for filing a false claim against me. So I love tickets. Explain to the folks how you would deal with in a summons to appear for a credit card debt or any kind of debt. Let's just do that. Let's make it blanket. What would you do if somebody claims that you own a debt? And how would you proceed? Because you're doing it exactly like everybody does. So,
well, first of all, it's not a summons to appear because we're still in the private going back and forth. From the beginning, you know, you're already jumping all the way to a summons to appear. I ain't going to go there. First thing happens is guy sends me a letter and says, you owe me this money, pay it. I go, okay, who are you? I want to find out who you are and validate the fact that we have a relationship and find out if there's actually a deal or a contract or if there was anything made or if it's just some crazy son of a gun from Arkansas trying to, collect money from some poor guy in Chicago. So anyway, after you get that settled, you go, okay, I guess we really do know each other, and I guess we really do have some kind of a deal. So what's your claim? All right, well, I think you owe me $147.25. Okay, for what? Well, stuff. I don't know, stuff. What stuff? Okay, well, you know what? that's great. But why don't you give me a validation? Why don't you send me like an itemized true bill or a bill of particulars that says this is the deal and this is what happened? Okay. And by the way, why don't you include a copy of the contract if there is one? All right. So time goes, and you get something which is on the order of, we don't care what you want, you're going to pay us anyway. And you go back and say, okay, well, I believe you're a franchisee of the federal government and the banking system, which means you have to follow certain rules, so it's RESPA and TILA and everything else. If it's residential mortgage, it'd be RESPA. If it's credit card stuff, and that'd be TILA. And so, you got to jump through these hoops. You might win at the end, but the federal government at least gives me the opportunity to put these barrel hoops up in front of you so I can watch you jump through them before you take my money, so I can at least be entertained for the money I'm about to pay. Why have to pay something to somebody without entertainment? So you get them to jump through hoops. But if they refuse to jump through those hoops, then you can go, aha, we've caught you, because the federal government said for you to keep in good standing with your franchise, you have to be able to do those barrel hoop jumps. And Greg asked you to do that, and you didn't, so you're a bad boy. Now, I've got a cause that I can go after him and say, here's your last chance to jump through those barrel hoops. You got to prove all this stuff. And let's say, obviously, if they don't perform, then that becomes an actual justifiable claim to say, I don't have to pay anything. All right? But let's say, just for the hell of it, that he does perform. He's the 1 in 1 million creditor who goes, I totally understand the rules, and I'm not going to be a poophead, so here's all the stuff I got. And you go, holy shit, this guy actually gave it to me. Wow, that's kind of cool. So take a look at it. And then you go, okay, this. Okay, do you have first-hand knowledge that I actually did these charges? Do you actually know that I did all these things? Do you have anybody that will witness that I would do that? Or is this just stuff that showed up on the record and went unrebutted because I didn't know and you didn't know, but now you decided to collect on this, and hey, maybe we're dealing with an alien using credit card numbers. Who knows? Or somebody down in Arkansas trying to steal money from you. Who knows? So anyway, you can play all this game and you go back and forth. And in a worst case scenario, if you decide to acquiesce and say, okay, I owe you money, you say, I'll give you $1 a month. And he'll go, no, that's not acceptable. I'll say, I'll give you $1.50 a month. Oh, that's not acceptable. So, well, that's all I got. And you can say, sue me, takes you to court, you document all that stuff, you go to court, and you tell the judge, look, I, in good faith, offered this guy. Matter of fact, I sent him a check for this and this, and he either cashed it or sent it back to me, and he refuses to deal with the fact that I've got, a hardship situation here, and I was trying to stand in good standing with him, but he's just being a poop. And the judge will throw the book at the guy for, not being honorable and accepting your best effort. And that's usually what happens. Nobody ever, or rarely ever, throws the book at you if you've actually got a history and recorded piece of data that says a recorded record. I'm being redundant to say a recorded record, but information on the record that indicates that you are actually operating in good faith to the best of your ability, because you can't get blood out of a turnip. And if you can prove that in statutory court, you can actually win. Carl's got a great case of a guy getting a sofa for nothing because the creditor was being a poophead. And so that can happen. You can win in your favor. Or if it's inequity, of course, the judge could come up with some kind of a compromise. Say, okay, on alternate months, do this, do that, and the other guy does this and that. And if you're in equity, you just say, okay, thanks a lot, sir. Have a nice day. If you absolutely want to dispute the claim, then you can try to, challenge the contract as to whether or not it's valid. You can challenge the law as to whether or not there's any law that says you have to pay them. You can challenge a bunch of other things. But after that, you start going into more esoteric stuff. Some people do. Some people actually challenge whether or not the currency is valid or if everything is already prepaid using your birth certificate, bond, et cetera, et cetera, et cetera. And there's from that point, you can branch into 12 other things that people do. So that's typically the scenario that people run into when they get popped on some kind of a credit card debt. And I'll leave it at that. And that's kind of like the overview. So, what do you think?
That was Greg. He kind of slammed it there pretty quickly. What me and Greg were talking about earlier, we were just basically saying step by step how you do it in court. And like I said, Greg went through this just like lightning just now. And all we were basically trying to say earlier was that my method is just to say when you're being summoned to appear, you did everything on the private side. All you have to say to the folks is, I just need to see the law before the court. That's all you need to do. But like Greg was trying to say, and I'll try to do it a little Greg was saying, is first you make sure that there's jointer between the parties. First you make sure that you know each other, that somebody's not just moving a claim or a debt in front of you in error. It might be just a mistake, the same spelling of the name, whatever. The next thing you just need to do is then you just say to friends, just bring forth the obligation of the debt. Just show proof of the obligation of the debt. Say, you know what, honestly, I don't remember you. Honestly, I don't remember having any business dealings with you. Or you could say, honestly, I don't remember that number being that exact amount. How, and like I said, everybody knows you can look into your local state courts, the rules of the courts, or you guys code, with the Code of Idaho, your state codes sections.
Oh, I just remembered, Carl. Here's a real world scenario. My friend Brian, he got a bill from a credit card company that said they wanted like $200 and something, and this is a credit card that he canceled in about 1996, and he's not used it since then. It was an early thing that he had, and he hasn't used it. And so some debt collector got a hold of this account and put this stuff together. And because he did have that account at one time and he remembered it, they were counting on him to just go, oh, crap, I forgot that, and pay them. And he challenged them, told them to go to hell, and they went away.
All right. So that what I'm saying is, yeah, let me let me go back to what I was saying there, Greg. All I was saying is first you want to make sure that there's no error. Make sure that there's nothing in dispute. Make sure that first you want to make sure you try to settle on a private side. It's like say, well, I have receipts that I paid you off. Maybe it's a computer glitch or a computer error. Maybe somebody who did data entry for your company failed to put this information in. So let me resend the information. I'll verify that it's true and accurate, and I'll show you canceled checks, whatever it is, to try to help you folks. Understand that this matter's been settled. So like I said, the only other thing you could do is, because every state code book has provisions within their code that if you're chartered as a business and you operate as under a license in your state, you have to abide by state codes. You can't just wing this and say this is a private affair, or this is a private matter, or this is a private business. You are now in the public when you're engaging with others, in the public. So all you're doing is, like I said, it's called statute of frauds. So a statute of fraud means that every single agreement that you folks did, and it started back in the 1600s, because actually it was started in 1677. Paper and pen became plentiful and cheap, and they weren't writing on sheepskins anymore. You could use cheap materials to write things on. And the people were starting to get educated by 1677. So any businessman was demanded of them to have it written in form of paper, parchment, sort of contract. It had to be written out, spelled out. Only to certain, under certain transfers of certain properties or possessions had to be itemized and had to be listed. Like say you went to McDonald's and you went to the drive-in and you ordered $499 worth of ham. By the time you get to the window, if you changed your mind and you didn't want those $499 worth of Happy Meals, you could just say, I changed my mind. Or what Happy Meals? I didn't order any Happy Meals. I ordered a Big Mac to go. And the lady at the window can't call the police on you and say that you failed to, pay for the services, because it's he said and she said under a certain dollar amount. But over $500, what the lady at McDonald's is supposed to do in almost every state code is go outside, find out who just made placed this order, write some sort of a contract saying, you will pay me $500 for these hamburgers. And that way, if you do not pay the $500, you are now bound, and I will take you to court, and I will definitely win. So that's what the statutes of large means. So when there's a certain dollar amount, it's all he said, she said. And if you're a businessman, like McDonald's, and somebody orders $1,500, $501 worth of Happy Meals, and then the guy pulls up, there's a couple of crazy kids, college kids made this ridiculous order. And they pull in to up to the window, and they don't pay. McDonald's has to eat it if they don't have a contract that's worth $500. If they couldn't prove it. So that's where the statute of large is. So if you folks definitely want to learn like what the statutes of large actually bind is like a marriage has to be in writing, in your state codes. Any contract that's going to take to perform a service more than 1 year, or a transfer of land needs to be in writing, or say an executive order of an estate, like you're creating a will or a trust, that has to be in writing. So there's no he said, she said stuff, or like a sale of something over like a certain amount of money. So there's certain conditions that must be in writing to hold in court when you're dealing with a credit card company, a mortgage company, Macy's, McDonald's, a taxi driver, a hotel, anything. Under $500, basically, you get into court and do this arguing, he said, she said nonsense. Over $500, if the person that's moving a claim against you, like a credit card company or a hotel or a taxi driver or McDonald's, does not have it in writing, they're going to lose, because they are to know that according to the code in which they're chartered and licensed to operate under, if they want to make a claim for anything over $500, it better be in writing and it better be signed. Because I helped somebody get out of a he said, she said nonsense because the person who was making a claim against them wanted $1,500 in compensation. And I told the lady, just said, hey, settle, work on a private side. And the guy said, the lady, F you, I'm not settling for anything less but $1,500. So all I said to the lady is, okay, hang on a second. I got the Code of Virginia. I'll pop it up. We're going to hand it to the judge. And the judge is going to say a simple thing to the man. Do you have this agreement between this and you, the man, who's a state licensed surveyor, and this woman, you have it before this court. You have the law, the contract, the law. You have the law before the court. And the man said, no, this was all verbal. And then the judge just said, case dismissed. And when the court thing was over, I tried to still work with the land surveyor, but he was extremely upset. And all I was trying to tell him was like, look, she'll still work with you on a private side. He was furious. And he didn't want to hear anything. Because I tried to tell him, look, if it's over a certain amount of money, you are licensed to be a land surveyor in the Commonwealth. You have to abide by certain rules. Now, if it's $499, it's basically he said, she said, and the judge probably would have tossed it to you, because why else would have you been on that woman's land? It must be some sort of an agreement, or you wouldn't have appeared. So there is some sort of a contract, an unwritten contract, an unwritten law, because it's self-evident that there's no reason in the world you just go hop on this lady's property and just start surveying nilly-willy. So this lady's like, yes, he did survey the land, but we agreed on a less of a price. And she was like, I'm willing to pay you this, but I'm not willing to pay you that. So the judge threw that case out on the poor land surveyor guy. So like I said, that's what I'm trying to explain to you folks, that when certain companies come after you, it's all he said, she said, up to a certain amount. The same thing with a marriage. Just because that woman points a finger across that courtroom and says, you're married, according to the state codes, they're going to say, do you have it in writing somewhere, ma'am? Because if the man says, I've never seen that woman in my life, that is not my child. I mean, before people were able to do a DNA test to prove those weren't your children, some woman could just walk into a courtroom and say, that man, this is his baby. And I got 59 witnesses behind me to say so that it's true. So it's just got a little dicey for like somebody who was rich or well-to-do who just won the lottery. All of a sudden, somebody's claiming them that they're their daddy. So, like I said, that's why certain things, should be and must be put in writing. For everybody's safety. It's not just for being sued, but the person who wants to do the suing. The land surveyor got flat out nothing in for his labor. So he should have put it in writing and had the lady sign it that she's willing to pay $750 or $1,500 or whatever agreement was. So let me just explain to you statutes at large. Statutes at large is a very important concept when you're dealing with any kind of relationship. I don't care if it's credit card. I'm just trying to make a blank generalization for anything that you folks might run into out there, not just one specific credit card debt or mortgage or title company. I'm just trying to throw a whole blanket thing out there for you folks to try to grasp what's going on here. So like I said, with me and Greg, all we were basically trying to say is make sure that the parties understand that each other have some sort of relationship between the parties. Then you make sure that that there's some sort of evidence of proof, and you can rely upon statutes at large. And I'm almost sure you could type it in, or I could actually send it to you folks. If you guys email it to me, I could actually send you what statutes of laws means. That I wrote like a little dictionary thing, and I could actually broke it down in very plain, simple terms that you folks can understand. It's called statute of fraud. So, and it comes from 1677. So, if you guys want to Google it for laughs, it's a really good one to know. Statute Staples is another good one. No, I'm not doing that right now. That has to do with the IRS, and it's 100% bona fide, and it's true, and it's dead on accurate. But right now, we're just going to do statute of fraud, because these folks want to know how to deal with going into court and out of court. Okay, the next thing that me and Greg were talking about was saying you could have, if a representative of a fictional entity is going to represent the complaint or the claim or the breach of the contract or the debt in open court, you want to make sure that that person has a delegation of authority or a power of attorney to move the claim. Like the man who's talking a little earlier, I don't know if it's Chuck or Dallas, is the man who was working in the construction company. He was giving us this great solution. I'll pay you 20 cents on the dollar, 10 cents on the dollar, 5 cents on the dollar. Well, okay, before you even start doing that, because that's insane, and I don't want to say that, before you even start doing that, you make sure that that person on a phone call talking to you has the delegation of authority to negotiate that debt. I mean, I'm not sure I could go online and I could find all kinds of people who owe all kinds of debt to everybody, and I could just start making cold calls. And I could start saying, hey, Mr. Idaho, hey, Mr. California, hey, Mr. Nebraska, you owe Bank of America, blah, 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 blah. And I'm here to propose an offer to you for 5 cents on the dollar. We'll wipe that out, and we'll send you all kinds of certification and verification and whatever paperwork you want us to sign, and we'll deliver, and we'll send it to you that debt is now satisfied. Okay? That's crazy. Because first you need to make sure they have the delegation of authority. And just because they went online and they found, like say I wanted to go online and go to Harvard or Yale and print out a college certificate and say, oh, look, I graduated from a master's degree from Harvard Law School. Just because I copied and pasted and I made a nice bond paper doesn't mean I actually have the accreditation to match what says on that piece of paper. So just because this man whips out this beautiful bond paper, delegation of authority, everything is stamped, signed, sealed, all kinds of nice gold fringe and all this kind of silly stuff, red borders and everything else, don't trust that piece of paper for a heartbeat. You send it over to whatever the debt collection agency or the loan department for Bank of America or Capital One, and you say, hey, have you ever heard of this guy? Because he's acting in your name. And he's stealing not only my money, but he's interfering with your right to collect on a debt. So make sure that the delegation of authority doesn't just come from the guy who claims to be the guy legit. He's like, oh, yeah, please. You're the legitimate guy? Yeah, please. You know what? Thank you. You know what? I didn't just wake up yesterday. You know what? I know what I'm doing. So make sure you get the delegation of authority or the power of attorney if you're dealing with man on man. If somebody's saying, well, you owe my mama money and she's in hospice care, so now you're going to have to work with me. Just say, okay, show me the power of attorney. Show me where she signed it. Show me. So first, then make sure you don't forget about the delegation of authority.
Hey, Carl, before you go too far, can I ask you a question about that?
Yeah, sure. Go ahead, man.
It's Dallas. Okay, let's say they do have a legitimate delegation of authority from this person that hired them to represent them or a power of attorney. Can Can the person that signed that delegation of authority or power of attorney be subpoenaed as a witness?
Oh, absolutely. But like I said, then you got to be careful because subpoenas only hold basically a 100-mile range. So it's going to be interesting if you demand that they appear, and they'll say, well, basically the code of, wherever you live, Texas or wherever you live, is going to say that the rules of court say that you can only subpoena them from 100 miles away.
Okay.
But wait. But if you look at Jennifer Flowers versus Bill Clinton back in 1997, she subpoenaed him to appear in Arkansas District Court. He tried to
talk about that.
Right. He tried to say I'm in Washington, D.C., and I'm an awfully busy man. I got my finger on a nuclear button, and the Russians are about to drop a bomb on us any minute. So I'm sorry I can't make it to Arkansas at this time. It's inconvenient. Sorry that she believes I grabbed her ass, but you know what? So what? We're talking about a national crisis. We're in the middle of a war with Kosovo. We're bombing all these Serbian people. We're killing all these Christians. We got to protect the world from these crazy Christians. We're busy up here. I can't go to answer every claim that somebody makes in some bozo court in the middle of Arkansas or in the middle of Nebraska. Next thing I know, I'm going to have 500 women claiming I grabbed their behinds. And they're all true, but what do you want me to do? Leave the presidency and go down there and answer them? The United States Supreme Court said, absolutely. If anything, you, more than anybody, since you're a public servant, you have to appear when your public calls you to serve. So it doesn't matter you're the president. You're actually way under Jennifer Flowers. You're not above her. You're way below her. I mean, the United States Supreme Court decision was beautiful. I thought they were going to tell her you're going to have to wait until he's done being the president of the United States, because that office and that position is in control of the world and with the free world, and we will all die, and the economy is going to collapse, and we're all going to be eaten by whatever, because the president, Bill Clinton, the leader, the fearless leader, is going to have to be ready to lead us to charge into battle at a minute's notice, so he doesn't have 2 or 3 weeks to waste about some frivolous, well, he grabbed my behind when I was bringing up some towels to his motel room when he was the governor. They're like, no, you drag your butt down there and you work this out with her. So what he actually did was he flew her up with his attorney to Washington, and they worked out a settlement that way. But see, just because you're thinking that, well, the subpoena rules 100 miles, honestly, if you want to go about the subpoena rules, look, and they'll say, oh, no, you can't. I'm just trying to tell you, Dallas, use the Jennifer Flower case. Bill Clinton said, whoa. I don't care if he's the president of IBM. I don't care if he's the president of Bank of America. I don't care if he's the president of the United States. If I'm going to make a claim, if he's making a claim against me or I make a claim against him, he's going to come and answer this claim. Okay, so I hope that helps a little bit answer that.
Yeah, it does. That's exactly what I expected to hear, because because I believe that there has to be another man, woman, they're making the claim against you to make it valid. Otherwise, they have no standing. So that's why I was asking. And then, I mean, you could go as far as going, well, you delegated the authority, but what personal first-hand knowledge do you have of the actual situation?
Right. I'm going to get Greg back on board. So, Greg, now remember what you were talking to me. You were saying 9 out of 10 people. 9 out of 10 people who are making a claim against you will not be able to validate their debt. So, go ahead, Greg, and explain what that means a little bit. Are you there, Greg from Illinois? Greg from Chicago? Hey, Greg from Chicago. Greg. Hey, Greg. Are you there, Greg? Greg from Chicago. You there, Greg? Did you mute yourself? I had to mute you out because we heard you burping and sneezing and everything else like that. It sounds like a cattle crossing.
Hey, Carl, you there?
Yeah, Greg. I had to mute you out because it sounded like a cattle crossing, and I realized it was you and not the cattle outside. He was sneezing and honking.
Actually, it probably wasn't me at all. The only thing I'm doing is chopping up vegetables here at the kitchen sink.
Something was going on. I had to mute you out because it was hard to keep a train of thought going on because it was derailling. Yeah.
Anyway, I was just talking to Mike B, and he had an issue that was interesting right on his writing about this topic, and so I said, hey, Mike, why don't you jump on the call with us and throw that in there?
But what's his name?
So,
his ID that.
It's Mike B from Virginia. I don't know what it's going to come up under.
Okay.
But,
okay, great.
You know Mike from Privatus, right?
Right. I like Mike. He's a good guy.
So yeah, he's got an issue that's kind of interesting. I think you and I talked a little bit about it earlier, and he could bring up a little bit more about it. It's kind of an interesting kind of like man-to-man claim. So,
okay, well,
but it fits right into what we're talking about.
All right, that's wonderful. We're going along pretty good here, Greg. We've got a good steam going here. 9 out of 10 people we were talking about, or 10 out of debt collectors, or 9 times out of 10 of these creditors who are claiming that it's a debt we were talking about, you said they will fail to validate the claim. Now, why do you believe that?
Personal experience.
Yeah, do it slow. Yeah, do it slow, Greg. Why do you believe that?
I believe it from personal experience.
Okay, well, tell us.
And the numbers of debt validation efforts that I have attempted, following their rules, following statute, you send them a request for certain information, and they send you back a computer-generated cover letter that basically says, we don't know what you're talking about, pay us some money. And that's pretty much how the conversation goes.
So what was the stuff, the information you were basically asking them to send to you?
I was like, please send me proof that this agreement exists, that the amount of money that you're charging, that you want me to pay, is exactly what I'm supposed to pay. Show me what it was that I did or contracted to do or used. If it's a credit card, what did I charge? Show me that all of the fees and everything else that you've thrown onto this thing are actually valid. Show me that you didn't add a bunch of other crap that has nothing to do with our agreement. Show me that this is a clean, it's kind of like if I bought a hammer from you for $10, you charge me $5 interest over 6 months, and then close the account. I figure I ought to pay you $15, maybe $16 for mailing. And if all of a sudden you want $150 for that $10 hammer, I'd like to know where the extra $140 came from.
So let's stop right there. That's great. That's good, Greg. So not only tell them, okay, this is what I'm saying, folks. See, because this is what I would do if I was the credit card company. I'd say it's all in the contract. Read the contract. It's too font. It's 10,000 pages long. I would tell them, no, highlight it. Highlight the terms and the conditions in the contract, because until you do that, I think you're just making this up. I don't think there's any valid explanation within that contract that could possibly legitimize what you're claiming or so please highlight it and send it to me. Instead of you trying to read these 10,000 pages as well, it's in a contract, just read it, that's not my job. No. If they see it's in there, they wrote the thing, make them bring the law forward. Because that's the law. Between you and them, that's the law. So if they're saying there's a contract, and you signed the thing, and you made this private law now between you and them, you have to live and die by this law. You might say they're a bunch of Shylocks, that's fine, but you knew what you were dealing when you danced with the devil, you knew you were going to get burned. So, you still got to make the devil show the terms and the conditions, or the clause. They have to show it in the contract. So go ahead, Greg, what else would you ask these people to produce?
Well, if we're talking about the original creditor, you don't have to worry about third-party authorization. If you're talking about a debt collector, we know that a lot of it, now I want to say we all know this, because, let's assume that there's people on the call that are here for the first time. What a lot of people do know is, presume, thank you for busting me on my favorite bad word. All right, yeah, I know, it is, assume is to make an ass out of you and me, right?
Go ahead.
All right. So anyway, in most cases in contemporary business, when a bill or a debt has been, an alleged debt has been passed from the original entity to a third party, that third party has either paid those people cash, written them a check for that debt on pennies on the dollar, or agreed to a commission at a fraction of the cost. All right? And in addition to that, most of the creditors that are out there have insurance policies, so that if they ever have an uncollectible debt and it goes to the third party, they actually get paid for the debt before it even goes to the third party. So they can write it off. I mean, this is gorgeous how they have this set up. You can get a debt with them. They can then write it off and remove that from their profit, and they can collect the insurance on it and not have to claim that as profit because it's an insurance claim, not a damage. So they get paid twice. And the third-party debt collector pays them something, so they're getting paid like maybe almost 2.5 times. And they're made whole. So they're made whole, and they're coming back and telling you that they're not made whole and you owe them this money. So you have to wonder, well, if you've been made whole, well, what am I supposed to do? If you haven't been harmed or injured, and no man has been harmed or injured, and you guys, in your wisdom, created this banking system and insurance system that makes it impossible for you to lose, why are you bothering me?
Okay.
Why aren't you?
Stop there a second, please. All right, you're doing good. But what you folks might not have just noticed is Greg went from square dancing to tap dancing. What Greg just did is he just shifted jurisdiction. And I don't want to shift jurisdiction yet, Greg. I want to still concentrate on statute. Concentrate on the law of the contract. Don't try to throw a trump card in because you danced with the credit card company. So you bound yourself with the devil. You made a deal with the devil. You are going to get burned. There's no doubt about it. There's somewhere in that contract where you get fried. So let's just work with trying to stay in honor with the person that you decided to dance with. Okay? Go ahead and keep going with that.
All right. So if you don't know anything about what goes around behind the scenes, and you think the only thing that exists is you think this credit card company actually reached into their pocket and gave you money in order to buy that refrigerator, which they didn't, but you believe that because that's what the contract looks like. Okay, the contract looks like, Visa, MasterCard is going to reach into their pocket and pull out $500 for me to buy my new refrigerator. Okay, and so if you're old-fashioned farmer guy from 1800, you're thinking that's exactly what happened because back in 1800, that's the only thing that could happen. All right, there was nothing else. So you believe it. So if you believe that, then you're thinking, well, I should pay this guy back because he put his money out there to buy my refrigerator, and so he really owns my refrigerator, so I pay him off.
Okay. What I'm trying to say here is I really don't want to go down that path because a credit card company did not give you money. A credit card company did not give you paper. A credit card company gave you what?
Credit.
That's right. So I don't want to hear anything about money because money is just a medium of exchange. Now, whether I trade you 300 pounds of cow manure and you give me 600 pounds of the best Chicago bratwurst that you could find, that's money. So I don't want to confuse people with thinking that a credit card company gave them or did not give them money. They gave them something which they believed was worth value to them, or they would have never danced with these people or accepted their conditions or their for value. So all I'm trying to say, Greg, let's make this.
I know you don't want to say money, but for 90% of the common man, they think that represents money.
Okay. All we're trying to say is what things does the credit card company or their representatives or any debt, somebody who gave you something and demands something now, the restitution, what do they need to present to you or to court to keep moving their claim? Now, don't go down on money. Don't do any of this other nonsense. We're just doing a generalization for anybody who owes you a debt, that believes you owe them a debt. What do they need to establish?
Anybody who wants to move anything through a court has got to bring the law and the facts.
Okay. Now, we're not talking about that. When I said to you before, what we were doing was like saying, how do they validate and produce the facts and the evidence to move the court? That's the question. You said 90% of them can't produce, and they can never be able to validate the debt. Now, how would you say they need to bring forth to validate the debt?
They need to bring forth a man or a woman who knows that this is true.
Okay. Now, stop right there a second, folks. This is where this Greg just did his jurisdiction change on me again. Okay? This is common law. Okay? Now, in contract, if you made a deal with Coca-Cola, Coca-Cola does not have to bring any man or woman forward to bring forth, because you reduced your status of a man and you merged it with a fiction. So, for you to get something of value from a two-dimensional world, you reduced your status to that of a two-dimensional entity as well. So they are going to demand from you, this two-dimensional entity is going to say, well, you know, we demand from your person what we agreed as a medium of exchange, money, or what we deemed had value. We are going to give you 10,000 cases of Coca-Cola, and you're going to give us 10,000 widgets or $10,000. So this is how they're going to bring you into court. Now, can you play the old trump card and say, oh, well, this is common law land, and you know what, I'm going to beat these Coca-Cola out of every damn Coca-Cola can they sold to me. They sold me 10 million Coca-Cola cans, so I'm going to beat them out of their money, and I'm going to say, there's nobody with any first-hand knowledge that could say that that signature on that piece of paper between me and Coca-Cola is legitimate. You know what, honestly, technically, yes, you people can do it. Do I think it's disgusting and evil? Yes. Then you're worse than a lawyer to me, because you know how to take advantage, how to take candy out of a baby's mouth. Because, like, say Greg had a company, and he just decided to make his own new cola company in Chicago. And Greg had a whole bunch of stockholders, like his mom and Mike from Privatus, and everybody joining in and giving Greg money to build up this wonderful corporation. So Greg created a corporate entity. I come along, Carl, because I know common law. I'm going to order 10 million cans of Greg Cola. So I get Greg's Coca-Cola coming to me. I tell Greg, prove that's my signature, prove this, prove that, prove this, you're screwed. Is Carl wind up with 10 million cans of free soda? Absolutely. What happened to all those stockholders? What happened to his mom and everybody who invested in that corporation? They trusted me that I would do a certain thing for return for something. So now, what's happening now is it's been going along so smoothly for the corporations to keep doing this to people. All people have to do, what Greg would have to do then, as a good businessman would say, Carl, honestly, this stuff is going to get wacky. You guys are starting to drag us into common law. You guys are starting to do this to us. We're losing exponentially. We're going downhill fast. So now, we're going to have to slow this process down. So, Carl, if you want $10 million of Greg Coca-Cola out of the Greg Coca-Cola Corporation, Carl, we're going to need a $10 million bond. So that way, if your check bounces, or anything happens between the transaction between you and then dragging with common law, we're holding your freaking bond. So you're going to sign this $10 million over to the corporation known as Greg Coca-Cola. Okay? Now, what I'm saying to you folks, this is what's going to happen. It's commerce is just going to slow down, because the corporation is going to say, how do we get somebody to use their debit card or credit card or sign a mortgage without making sure they're bonded? Because everybody just did it on their word. You'd have a credit rating, and your credit rating just established, based upon your acts in the past, your inactions in the past, how good your word was to paying off a debt. So if they just say, look, everybody's learning how to beat us, you know what? Either they're just going to all wrap up, or the banks and everybody's just going to wrap up shop and say, look, like there's only one person out of 100 on this planet that lives in the United States. You know what? We're going to go to China. We're going to go to India. We're going to Africa, where there's 99% of the world lives. We don't need you, United States, anymore. You know what? You guys figure out how to trade rubles or wampum or she-shells with each other anymore. You don't want to deal with us anymore. You don't want to act honorably with us anymore. We're not going to deal with this bond nonsense with you people. You know what? God bless you. We're going to unbolt all your machines and factories, and we'll just ship them to China, and you guys could just work in McDonald's for the rest of your lives, because we're not going to extend credit to you people anymore. How hard is it to get a loan nowadays? It's almost impossible. How hard is it to start a business anymore? Because the banks are scared that they're not going to be able to, you could say, screw over the people anymore. So they're afraid that these people are going to learn how to get out of any kind of credit card debt or any kind of loan or any kind of mortgage, and people will learn how to do it. But then what are we going to have? So this is what I'm just saying to folks, be careful. You guys are going to get what you wish for, but what's going to happen to the next generation? The people who try to establish credit or get homes or try to get businesses going. That's why I say it's so important if you want to play in their jurisdiction, if you want to play in their two-dimensional world, believe me, if the best you could do, like I say to you folks all the time, is say, look, by my word, in good faith, the best I could do, I'm out of a job right now. Greg, the best I could do right now is give you $2 a day for the next 365 days, whatever until I pay the debt off. Believe me, as soon as I get back on my feet, as soon as I get a job, as soon as I win the lottery, believe me, you will be the second person that gets paid off. You know, of course, I'm going to say, you know, praise to Jesus, whatever. But you're going to be the very next person I want to pay off. And there you go. So this is what I try to say to folks. You know, Greg's going to bring you down to a second jurisdiction, common law, and how to wipe out these people and get them off your back. But if so many people do it, like I said, it's going to be a domino effect. And it's going to be a house of cards, and it's going to collapse. So this is just my belief. You know, this is what I really believe I can see happening. So if you want to play in the two-dimensional land or three-dimensional land, or, you know, that's fine. But
well, actually, Carl, if you think about it, though, I'm sorry for jumping in.
No, go on a minute.
But at the same time, you know, two different bad things happen. One, people start to feeling entitled, and two, banks decided to really go berserk on usury. If you really stop and think about the fact that the prime lending rate right now from the Fed to the banks is 0.1%, just about nothing, right? The banks get printed money for free. Then they charge you 18 to 21% interest on borrowing. They are at a point right now where their profit margins are obscene. It is absolute, you know, gun to your head usury. All right? So both, what happened is that instead of everybody being in the middle and being honorable, the people became more and more dishonorable, and the banks became more and more dishonorable, to the point where the chasm between the providers of currency and the users of currency is so wide right now that it's unresolvable. And your prediction of having a new economy and a new form of currency and everything like that, I think that that's inevitable. I think that the game that was set up, I personally think the game that was set up is at an end. Okay, I don't think it can't go very much longer. And if it does, it can only be done at the point of the bayonet. And I think that there will be a new development of currency. I think that in the short term, it's going to go back to what everybody can trust, and that is straight barter. I'm a plumber, or I know how to do plumbing. I'm going to fix your sink, and you're going to give me a bushel of corn. And a lot of that stuff is already going on outside of the large metropolitan areas. If you go into Iowa and Nebraska, you know, Southern Illinois, Indiana, throughout the heartland, I don't know how things are on the coasts because I'm not familiar with the internal economy. That I know my 10, 12 states over here, and a lot of people are doing that now. And it's all hush-hush because nobody wants to talk about it because they all still are afraid of the IRS. And so a lot of people are just doing that, you know, and it's all being done on a handshake and a nod, and, you know, they're trusting their neighbors, and their neighbors are coming through. And that kind of stuff is really happening. And that's how ordinary folks in the heartland are dealing with the problem.
But believe it or not,
basically opting out. They're just opting out.
Believe it or not, it's funny too. The reason why the banks don't want to loan money is because the interest rates are so low, and to them, they're waiting for the interest rates to rise to you know, start loaning money out again.
Well, only on. But Carl, be clear on that. Only on secured loans.
Right.
They are under a lot of scrutiny when it comes to a secured loan with a collateral, but they have no scrutiny when it comes to credit cards, and that's why they push everybody to credit cards.
Well, what I'm saying is
they could do whatever they want.
What I'm saying is, like, you know, venture capitalists, they're sitting on their money and they're just waiting for the interest rates to go up. So people might be, like they're saying, these corporations and these college institutes are sitting on billions of dollars just waiting for the interest rates to go up so they can put the money back into the economy. But at this point, they said, you know what, it's better for us to stick our money under our mattress than to put it in an economy that might go under. So until they actually see that people are borrowing again, because borrowing means growth. Borrowing means there's corporations starting up, and there's a demand for currency. There's a demand to spend again. So like George Bush said to you guys after 9/11, don't let the terrorists win. Go out to those malls and keep buying products and keep buying in Nintendos and keep buying houses. Just keep the money. Just keep the economy going. Don't be afraid to go out of your house. Don't be afraid to go to the shopping mall. Go out there and spend, spend, spend. So as long as there's a demand for the currency, the interest rates will go up. And so the venture capitalists, people who might be millionaires or billionaires will feel a little less hesitant to putting money back into the stock market or putting it into their local communities if they believe there's going to be real growth. But until they believe there's real growth again, they're just going to buy bullion of silver or gold ingots, and they're going to stick it under their mattress and just wait for the economy to collapse. So, like I said, that's why I just try to say, everybody, if everybody just starts to learn to keep their word and play fair and square, I just think this is the way to more go at it than try to figure out who's going to screw the other side first. Are we going to screw the banks, or the banks going to screw us? Who's going to screw who now?
When it comes to a contract, if the terms of the contract include a privacy clause, for example, Karl had mentioned, I'll mention now, we have a colleague who had a contract with a co-colleague that specified that the thing would remain in private, and there was a part of the clause in the contract that said anybody who brought this into a court had to pay $1 million to the other party. Period. It's part of the contract. That all these things, if there was any discrepancy, it had to be handled in the private through a private education process. All right, not public. All right. So this guy goes and gets picked off, sends it to the Attorney General of Illinois, thinking that he was going to bust this guy up, and the Attorney General sends the other party of the contract a copy of the contract that was sent to her, as well as a letter that says, "Dear sir, this guy sent me this stuff and complained about this, this, and this. Would you like to prosecute?" In other words, the Attorney General of Illinois recognized that this guy had breached the terms of the contract, and as we've said many times in this call tonight, the contract is the law. So he broke the law. Okay, and the Attorney General was willing to basically be a star witness against the guy who sent it to the Attorney General. Pretty silly, isn't it? So be very careful on your contracts. If they're not supposed to be brought into the public, don't do it. And if you do have a contract, or you want to make a contract with somebody, consider the aspect of adding that element to your contract to ensure that it stays in the private and it doesn't go into the administrative court system. Put a mutual, I got to pay you $1 million if this goes to a public court. And you know what? Nobody's going to sue you in court. They'll work with you because nobody's going to pay $1 million just to whine. Okay, that's just a little trick in contracts. Okay, and lastly, if someone brings a contract, if a guy brings a contract into court, again, as I said earlier, it is the contract which is the law of the contract.
Greg, there's another thing that I say to folks all the time. If anybody wants a contract written, pay Greg because he's good. He can write good contracts. But let me throw something else. Me and Greg were talking about this the other day because let me see if he's paying attention when I talk to him, which I think he does. So just say that there's a contract and you can't force these other people to respond or react or whatever. What else can you do to a court, Greg, if the other side doesn't want to show up? What can you do?
If the other side doesn't want to show up?
Yep.
You can get a summary judgment.
What do you mean?
In other words, you can still file your claim, you still file your claim and you put in an order for a summary judgment. And, you know, if the other party defaults, it's the same thing as if the mortgage company wants you to go to court and you don't show up. They give a summary judgment and the judge grants it because you didn't appear to dispute the charge.
What I'm saying is, when we were just explaining about if the second party, if you have a two-party contract, like say you have a private contract, a husband and wife, or a doctor-client, a doctor-patient relationship, or an attorney-client relationship, or a priest and what do they call it, parishioners, private information.
I prefer a man and 300 cats.
Okay, and they don't want to disclose the private contract or the private agreement, or they don't want to air their dirty laundry out in public. Nobody on this planet can force somebody to disclose the information of a private contract into the public, regardless of what that contract is about. There's no power on this planet that can open up a trust and intervene into a contract if all parties don't want. If the two parties are a part of this, that's why, like a marriage license, you're allowing the state. You're allowing the state to be the third party intervener on day one. So if it was just a marriage license, it was just a marriage between you, or if it was just, that's what I call it, say when you consent, a consensual, connubial relationship with a woman to procreate and produce offspring. There you go. The government can't get involved. Whatever private contract you have written between her and him, the two people, she can run to court and do whatever she wants. Like Greg just explained to you, the guy says, I don't think this disclosed.
I mean, and that's really important. And, you know, as an anecdotal little piece, my girlfriend in college and I had thought we would get married. We didn't because I wanted kids and she didn't. So we went our separate ways. Years later, she ended up becoming an attorney. And we connected again, you know, through alumni stuff and everything. We started talking. And we actually, before I got married, we're talking about this stuff. And we actually wrote, you know, a cohabitational kind of contract that would allow a man and a woman to live together under a private contract so that they didn't have to become party to the state, or the state didn't become party to the marriage. But at the same time, contractually, it gave the man and woman all the rights that would appear to a married couple under the state law. We actually wrote that, like back in 1992.
You're breaking up, Greg. You're underwater again.
So we wrote this agreement, you know, back in 1990 or 1980 or something like that. I forget when it was, because we thought that was really interesting. Even though she and I never got married, we both agreed that we never wanted to get married. And she became a lawyer, and I became a goofball, right?
Wow.
And
I was saying, Greg, I was hoping that you were going to catch on to what I was saying. How do you kind of try to force the other person to realize that it would probably be beneficial for you to try to settle a matter on a private side before you have to drag it to court? Okay, Greg probably has the thinking cap on right now.
But the way I said that is, if you have the ability to be writing the contract at the beginning,
right,
you put severe penalties into the contract for disclosure.
Okay. Do you see, Greg, that's a lovely answer, but do you see the answer I wanted you to say was a DJ?
Oh, Bill.
Okay.
Okay, you didn't see I was going there, did you?
No, I didn't.
Okay.
Because I was thinking, oh, wait. All right, go ahead.
Right. What I was hoping Greg would stumble into eventually, I was hoping he was going to say that you were going to go for a declaratory judgment. So under the Federal Rules of Civil Procedures, Rule 57, it's easy for me to remember because it's a 57 Chevy. It's Rule 57, and under Title 28, I think it's 2201. And all you're basically doing is saying, look, Judge, you like Greg said to me, he's like, hey, you know what would be fun? He said, why don't we just make controversies between you and me, Carl, and we go to court, and we try to get judges to make rulings to see how this stuff will play out, and nobody's really getting hurt. I said, called barratry, and that's abusing the court system and the resources of the community. No, we can't do that, Greg. But there's something called a DJ, the declaratory judgment, that if you have a controversy that truly exists between you and somebody who really doesn't want to come forward and get involved and thinks they're going to sneak out of whatever they want to do, you're just going to propose this complaint. It's not a claim, it's a complaint, where you're just whining about something to a man in a black robe. And the man in the black robe is going to make saying, well, if this controversy ever appears in this court, and if what you're saying is true and accurate, this is what this court would decide. This ruling is not binding on any party. It's just an opinion of what this court may do if these parties ever appear before us. So then you could hand it to the other side. Say, look, now I'm either going to sue you, and does this pretty well reflect what really happened between us? The complaint I put before this man in the black robe is like, well, yeah, it kind of sounds exactly what happened. Do you see what the man in the black robe ruled? That I would rule in my favor? Like, yeah, so now do you really want me to sue you in court? So you could just have the judge repeat what he just wrote here in this declaratory judgment? And do you want him just to actually put it down as the judgment of the court? That, would you rather do it that way? How do you want to do this? So it's called a declaratory judgment if you're just trying to find an opinion of the court and how they may rule. That's a pretty good way of doing it.
Yeah, I forgot about that. That's why I was going with summary judgment.
But that's what I'm saying. If you're just trying to test out theories, that's how you could basically do it without, because people got arrested years ago for doing that silly stuff on me and Greg, like, oh, let's make a dollar bet that the judge is going to recede my way. And then you just file a claim against each other. When you get caught doing that, you're going to get in big trouble. But this is another way to test it out and just show the other side that you mean business. And if you drag me to court, this is what's going to happen. And now when you talk about like a statutory grand jury, that's basically what they do. They had seat 23. Usually it's 23, not 25. Usually, but because common law is supposed to be 25. But whatever. But what all grand jury comes down with an indictment says, basically telling the guy who did wrong, you got 23 people on the jury here that found you guilty or wrong of doing something. What do you think is going to happen when you get in front of 12? It's going to be a lot easier to convince 12 you did wrong. So if the feds of the state are having a grand jury indictment against you, if I was you, I'd cut a deal with the feds. I'd cut a deal with the state. So anytime anybody gets arrested for a felony, the first thing you do is you demand to be indicted. So like I said, there's some man on the call, I know he wants to talk about drugs and felonies. The first thing you're going to want to do is you want to demand a indictment to come down from the grand jury. And you're going to want to present your case and your side to the grand jury. Now, a lot of people say, well, no, the county prosecutor, state prosecutor won't allow you to do that. Baloney. You can address the grand jury if you want to. And you say, I have the right to present the evidence, all the evidence, not just the prosecutor's evidence, my evidence as well. And if they won't allow you to do it, you could actually hand down an indictment. You could actually hand down a complaint or a claim to the grand jury. And if the feds are coming after you, you could go after the feds and tell the grand jury to investigate the feds and then accept all your evidence. And then they're going to investigate your claim against the feds. So it's interesting because the grand jury is an independent, like tribunal, it's an independent organization altogether. And they get to determine whether or not there's any merit to the claim. So when you get indicted by the grand jury, you're pretty well going to believe that you're going to lose when you get in front of a petite jury of only 12 people. If the grand jury found you guilty, well, the odds are you better make a settlement with somebody quick. Or you better figure out how to file a claim against the other party because you're going down. But that's always a good test to put your feet in the water to see, well, what's going to happen when I go before a real jury? What's the odds of me getting out of this? Not just saying every time you get indicted by a grand jury, like O.J. Simpson did, not because you're not going to win in criminal court. You might not get convicted in criminal court, but you're going to lose in civil court. It's pretty good that the majority of the population, if you get indicted by a grand jury, pretty well feels the same way the grand jury feels. So it's usually a pretty good indication that you better cut a deal. But most times if it's chicken nonsense charges and on a felony level, like this guy who released 12 balloons in Florida and he got hit with 12 felony counts for discharging into the atmosphere helium, he's got 12 felony counts against him. So if I was him, I'd say, you know what, put this before the grand jury and let the grand jury indict me. And the grand jury probably laughs. This is ridiculous. So when it's chicken nonsense charges, then it's a felony. Even if it's misdemeanor, I want to be indicted. You tell them put that in front of the grand jury. Because there's a ridiculous code, a ridiculous carbon dioxide act of whatever, Al Gore nonsense. I ain't putting up with this. I want them to be indicted. I'm not answering to any of these charges. These are ridiculous. So you can try to do it that way if you want to do it. I'm just giving you guys all kinds of different options how you can go with this.
a void judgment?
Just a void judgment. It isn't a judgment. It's a void judgment. It's like saying an elephant is a tennis shoe. No, it's not. It's two completely different things. So a void judgment has nothing to do with the judgment is void. It's two completely different things. A void judgment. Greg, what was I telling you before that I was saying that one exists and one doesn't exist? Do you remember what I was telling you before about a void contract or something about a contract?
Well, it's a matter of, we talked about this 2 or 3 calls back about, you know, the modifying word and the primary word. Okay? And a void judgment is saying that it's a void judgment. All right? Judgment is void. Implies that, okay, imagine this. The judgment is. Okay? Let's get rid of the word void. The first part of your sentence is the judgment is. That is a statement that says that it exists. And then the last word is how it exists as void. Okay? Void judgment is saying that it's void. It doesn't exist. But you put the word is in there, it gives it life.
Oh.
All right?
So you don't say it's a void judgment because that's saying it is a void judgment. So how do you word it?
Just say a void judgment.
A void judgment.
Because if you say the judgment is void, if you subtract the word void, you just said the judgment is. You just recognized it.
So you're basically saying there is no judgment because that judgment couldn't possibly exist because it couldn't have existed based upon the way it was allegedly created. Because an attorney brought it to life. An attorney can't do that.
Right. So you have to avoid any word of acknowledgement of existence, which the verb is provides.
Okay, well, I thought that that Karl said to say it's a void judgment, which is it is a void judgment. So that's not the right one sentence claim. So is that correct, or did I hear that wrong?
Right. It is a void judgment altogether.
Okay. Right. It is a void judgment. Okay, I thought that's what I heard.
Not the judgment is void.
I gotcha. Okay, the void has to describe the judgment.
Right. Well, well, kind of. It judgment does not exist. So the judgment doesn't even exist. How do you describe a judgment that doesn't even exist? It's a void judgment. It's saying what you think is.
If you want to be cute, you can say it is a void judgment ab initio.
Okay.
Beginning.
Don't go Latin. Don't go Latin on them, man, because they can respond.
They just use plain English.
Right.
It's a void judgment from the beginning.
Yeah.
From the beginning. Okay.
Well, say from that date, from the date that it was, the date that it was created, the date that it was issued, April 1st, whatever. There's been a void judgment, controlling this case, so that a void judgment is attempting to control this case. So there's a void judgment interfering with my rights. So there's a void judgment interfering with my property.
Can you order a jury of your peers?
Me and Greg talked about that quite at length, and it's kind of dangerous to have a jury of peers. You know why?
Why?
Because those people, your peers, mean the people who actually know you. And so, well, honestly, I don't think I could find 12 people that actually know me. What the jury of peer concept was all the people that knew you were like in a certain status, like in England, you had a hierarchy, you had a pyramid. So you didn't want a guy, a commoner, like a shoe cobbler, judging a lord or a vassal or a king or a knight. You wanted something in your own status, in your own little, hierarchy, your own little, what do they call them in India? Your own little class system. Your own class. Your own caste. Your own class. Your caste system. You don't want, right? Everybody was in a caste. Everybody was cast in a certain mold. So only those people are allowed to judge you, because you better believe if you were a sir or a knight or a lord, you certainly didn't want all the shoe cobblers of the kingdom to make a ruling on you because he hated you. So that's what the peer system, that's the peerage. That's what the peer system meant. So to actually try to find 12 people just like you, it's kind of a beautiful, lovely thing, because you could really run around like a freight train. You could basically win every single thing, because if you had a crazy cult that believed in eating your firstborn child, and somebody tried to get you in trouble for eating your firstborn child, well, you could just bring this crazy religious Arapaho or whatever religion craziness into court and say, this is the custom of our people. Now, appear just means, am I doing anything out of the normal? This is how you've known me for 50 years. Am I doing anything wrong? And all your peers will say, no, this is exactly what he's supposed to be doing. He's not done anything wrong. Everything is up to snuff. He's operating in total honor, because this is how we roll. So see, that's what I'm saying. So when the craziest examples I could possibly could even think of is like, if the federal government says that the people can't have anything more than a 22 caliber pistol or a 38 caliber pistol with a barrel 2 inches long, the Eskimos in Alaska, they're all going to die, because these polar bears, when you shoot them with a 38, are going to laugh. They're going to like, I got hit with a mosquito. So even though the Eskimos, yes, are they U.S. citizens? Yes, technically they are. So, but they need to carry around a bazooka. When they go down to school, they need to carry a bazooka to blow that polar bear off the sidewalk to get their kids in class. Now, you can't just walk around with a bazooka in New York City and say, well, just in case a polar bear pops up, this little 38 ain't going to get it. I'm going to have to carry a 50 cal. So we got to blast this polar bear off our path. So yes, could an Eskimo literally get in trouble for carrying around a 50 cal in the school zone? Yes. But then when they try to press a federal charge, he's going to get all the Eskimos, the peers, around this federal judge who was shipped in from New York City, who never even seen a 50 cal in his life. Like, oh my God, that's a bullet? He's like, yeah, that's a bullet. That's what we need to shoot a polar bear to get him out of our way. Well, that's against federal codes and regulations. You're going to go jail in a school zone. You can't carry that stuff in a school zone. And federal law that Barack Obama just dictated this week just says anybody comes near the school zone with a 22 spends the rest of their life in jail. So that's when you get a jury of peers, because the customs, practices, policies, and beliefs of the people that are indigenous to that district demands that the law gets ignored back from Washington, and we have to live like this for our own survival, because it's necessary and proper for our survival. So, and that's how you bypass a federal law. That's more of a jury of your peer kind of thing. So yes, can you run over federal laws and state laws like a freight train? Yes. Can it be almost like a lynch mob kind of thing? Yes. So jury of peers is a wonderful thing, and then it's a dangerous thing, because all these people who know you say, no, what you're doing isn't normal behavior, man. You're crazy. So if you actually have 12 decent, honest people who are your peers, but you could have 12 dishonest people as your peers. Maybe you roll with a whole bunch of dishonest people. So jury of peers is kind of an old-fashioned thing for English common law, basically to protect the caste system. That's basically what it was for. It's not really meant for us. We just want basically 12 independent people who don't know us. Just pick 12 people out of random from Taco Bell. Go to the first Taco Bell, pick the first 12 people, throw them in that box, and that's basically supposed to be society. And that's how we're supposed to roll. We don't want 12 people from the country club. We don't want 12 people from the homeless shelter. We just want to basically 12 people at McDonald's. Pick the first 12 people and say, you know what, that's society. So that is the kind of jury I kind of like in this country, just 12 random strangers. Just pick the first 12 people that walk past this courthouse and I'm good to go.
You have mentioned that the judge won't take notice of the Trinzi versus Pagliaro case if you enter the court as a defendant.
Mm-hmm.
Okay. Just a hypothetical. If you enter the court as a defendant and you make objection to the lawyer speaking, but the judge continues to rule in his favor, can you still go back from that point or forward from that point and claim void judgment?
It really problem, like I said, this is one of the very first things I talked about way back in August when I first started doing these things. If you don't establish the rules of the court on day one, you have no right to object to anything. So all these other people, these gurus yell, well, if you don't object, you don't set up yourself for anything to an appeal. Well, you know what? The judge was just basing his rulings and his objections and his sustaining your objections or overruling them based upon the rules that were before him. So all that's going to happen on your appeal is going to say, did the judge not act under the rules of the court that were before him? And they're going to say, no, he was in 100% compliance with the rules that the moving party said, we're going to play baseball running from third base, second base, first base. And you're coming in now saying, no, judge, we've always done this for the whole entire creation of mankind. We've always ran first base, second base, third base. And the judge would be like, you know what? Overruled. The rules that are before this court this time is what the moving party established. If you didn't like the rules that he was moving this court under, why didn't you file your own claim? And say, those aren't the rules, judge. These are the rules we're supposed to be following. This is the way the court's supposed to be moving. Well, then file your claim. And we'll determine whose rules prevail. We'll say, okay, what's the rules of the contract in that document between the two people? And then the judge is going to put on his judge hat, his arbitrator hat, and he's going to determine what is expressly or implied within that contract. Then he's going to take into consideration who wrote the contract, who's liable, who signed it. Is there any kind of a fraud in factum or fraud in inducement? Is there any kind of within this contract? Then the judge is going to put on his thinking cap and try to figure out just what's going on. Who's trying to screw who? And then if you don't like to interpret the contract, that's when you call in a jury. And you tell the jury, say, well, I want a jury. You know, I don't trust you, Judge. I think you're in collusion with this guy who wrote this contract. And the judge will say, fine. You want a jury to interpret it? Have the jury interpret it, because the jury is supposed to interpret the facts. And the facts are, this is the contract. Is this a contract? Yes or no? I want the jury to determine, is this or is this not a conscionable contract? Yes or no? And then, but you'll say, well, wait a second, the judge interprets the law. No, the jury could do both. And the contract is the law, and the facts are, does this or does this contract not exist, or does this or does this judgment not exist? You can let the jury determine that. The jury gets to determine both if you choose, but it's up to you. And like Greg tried to say before, all the statutory jury is useless, da-da-da-da. And I said, well, you can rely on Blackstone's commentary. It's, I think it's volume 3, section 372. Or it's volume 4, 372, which says the jury at its own peril to determine both the facts and the law for it. And then no judge could overrule it. So, yes, can you go back to the common law where the jury determines? And I explained to everybody how William Penn, Pennsylvania, how he got saved because the jury said, we're not England anymore. We're going to do it our way here in the United States of America. Well, before it was the United States of America. It wasn't even Pennsylvania yet. You know, that's how it became William Penn. That's how far back that case goes. But that, to me, is when this country really got rolling, when the people said we had enough and we're going to make the decisions on our own. We don't care what they're doing 2, 3, 4, 5,000 miles away. We're going to, it's like an Eskimo is going to do. We don't care what Washington, D.C. is doing. If I walk into this schoolyard and there's a polar bear coming across this parking lot and I got a 22 in my pocket, me and my kids are dead. What am I going to do? Sue Barack Obama? This is ridiculous. I'm going to pull out my bazooka out of my backpack and I'm going to blast a hole through that polar bear. Sue me.
Simultaneously, as they're filing a complaint or claim against you, you need to enter your own claim into the court.
Yeah.
So that when you meet when you meet in court, there's 2 claims before the court.
There's 2 claims, 2 sets of rules, and God bless you, because there's only one claim, and the other side is bringing a complaint.
Right, and the complaint's going to be from the lawyer.
If the complaint's going to go underneath the claim, it has no.
I got you. I got you. Perfect. Crystal clear.
Yeah, but like I said, you guys got to be careful when you merge yourselves with a machine in a 2-dimensional world. Yes, can you use a claim to trump these guys? Absolutely. But I try to say to people, do you understand what's going to happen when the banking institutes realize that they're operating in the United States of America and we have these rules, and they're going to be basically written out on a rail. They're not going to come back. Now, do you folks have a new currency system for us to operate under? I just wanted to get on the record that he had an attorney, or has an attorney. The attorney couldn't
be bothered to show up. He paid $2,000, and we're going to require the court to acknowledge that fact, that the reason why Wells Fargo was granted the order was because his attorney basically threw him under the bus and said, you know what, we'll just let Wells Fargo do whatever they want to do. We're not even going to put up a fight. So what I figured the easiest thing for me and him to do right now is to sue the attorney, but sue him as a man. Don't say, don't do malpractice, don't do anything. I'm just going to make a simple lawsuit where it says, I think the man's name is David Wright. I think that's his name, is the attorney. And I'll say, my friend's name is Jimmy Vest. We're just going to make a simple lawsuit in court here, and I'll post it online. It's just going to say, I, man, Jimmy Vest, claim wrong by the acts of David Wright. Next sentence would be David Wright. I tended David Wright $2,000 to perform a service. And number 3 would be by his failure to perform that service, I've accrued a financial loss. And then I said to him, we're just going to make a claim for the amount that the mortgage due. And we're not going to put down the fact that he's an attorney. We're not going to put down the fact of malpractice, because as soon as a court clerk sees an attorney's name on there or malpractice, she's going to try to do everything in her power to try to slow that process down. So if you just say one man did another man wrong, that's it. Oh, and I said to him, we're definitely going to do a trial by jury. Because I said if you do a jury with a man in a black robe, he's going to basically cover for the lawyer when he realizes who this David Wright is, who gets before him. What's going to happen is the judge is going to say to my buddy, he's going to say, well, you know, $2,000 was cheap. You know, most people charge $5,000 to do bankruptcy. You know what? As a matter of fact, I think you owe Mr. Wright another $3,000. Next case. So I said, no, I said, don't go in front of a man in a black robe on this one. This one we go in front of a jury. And we show the jury that that man, David, is just like any other man. You give him $2,000, he better at least show up for the court hearing, and he better at least fake it that he tried to win. And when you don't win, he just says, oh, well, you know, we had a good try. Well, you know, good sport, good volley. We lost this one. That's okay. We'll get him on appeal. At least fake it that you care. But he realized that my buddy came up with the $2,000, so he probably figured, he comes up with $2,000, we'll file an appeal and maybe make another quick $2-3 grand on the guy. So I said to my friend, no, we're just going to go after him as a man. We're going to ask for a trial by jury. You don't have to attach anything. You could attach the exhibit of the receipt that you gave the man $2,000 if you want it. But honestly, you don't have to do anything. You don't have to do citations. You don't have to do the junior code. You don't have to do, just say one man said that he'd perform a function. Like say a man said he'd come over here and fix my pond, fix my creek, fix a dam, and he doesn't do it. And it floods. And I'm going to just say I accrued a loss. I don't have to say he was a lawyer. I don't have to say anything. I don't have to say he's a brick mason. I just say he was a man. I gave him a certain amount of money. He failed to perform a function in which he agreed to perform. And now I've accrued a loss. And that is it.
What about the house?
Oh, he's still in the house. I mean, they haven't moved on to foreclosure yet. And it was funny. I got to talk to the Wells Fargo attorney. I said, I'm going to see you down in Rockbridge County. I said, I'm going to ask for the original note. Because it's funny, when we got up there, the judge said to him, well, why haven't you paid in 3 years? It was so funny. And he said, well, you know, he fell into hard times. And I said to the judge, I said, he wants to pay today. And, you know, if we have the money, if we have it all up front, does Wells Fargo have the original note that they have right now that we can just swap the money for the note? So then the lady said, that'll be it today, fellas. It's like, I just asking, just throwing it out there. If I have the cash in my back pocket, I'm going to say a rich friend of his, and we just want to toss you the cash. Can we just take the note and, you know, destroy the note, and can they take their money and leave us alone? And she said, that'll be it for today. You know, we just have the 2 motions. We don't have another motion. And what was funny, I was in the courthouse, and I walked out. And when I walked out, some lady, like dressed all in black, came up to me, real dressed nice lady. She tapped me on the shoulder when I was in the court clerk's office getting a copy of his case file to try to see. They had a copy of the note, but not the original note, and all the rounding numbers and FICA numbers were redacted. So, and the FHA numbers were redacted on it. And I say, why they were redacted? So I called up the attorney's office today. Hey, that's right, they didn't call me back. I called up Wells Fargo to say, hey, where's the routing number, so I could actually see where this note is at this time and where has it traveled, you know, through the commercial process. You know, once you got it, did you securitize it? Did you monetize it? Did you, you know, what did you do with the note? So they redacted all the routing numbers, so I couldn't see if Wells Fargo actually has possession of it, or had they made a claim on it through an insurance company, or through the IRS or the Treasury Department. Have they, claimed the loss? I wanted to find out. But everything was redacted, so that was interesting. I never seen a redacted one like that. But I guess they're doing it nowadays, so people like me can't figure out where it is. And
amazing, they're so sneaky and conniving.
Oh, we'll
they don't
find
even care.
Oh, we'll get it though. But it's funny. Some lady tapped me on the shoulders at the court clerk's office, and she said, "What was your name again?" And I said, "Karl Lentz." She said, "I heard of you." She said, "I seen you on YouTube." I said, "Can I help you, ma'am?" And she says, "I'm doing a pro se case here." I said, "Let me see your claim. When I'll take a look at it when I'm outside in the lobby." So it's funny. She went back in the courtroom. So I went back in the courtroom. I tapped her on the shoulder, and I called her, to come back out to me. It was so funny, man. That made those attorneys so nervous, because I started talking. I said, let me read your paperwork here real quick, ma'am. I said, "Ma'am, where's your claim for equity?" And she's like, "Well," I said, "Where's your equitable claim, for the property?" And she said, "What are you talking about?" And I said, she was doing stuff I guess she learned on YouTube or something. And I said, "See what the bank wrote right here? That you have no equitable interest in the property beyond $138,000 on which is due." I said, "Ma'am, you have no idea. Your equitable claim could be worth $200,000, $300,000, $400,000. I said, "Did you mow the lawn? Did you take the tree off the roof when it fell? Did you fix the leaks in the roof? Did you fix the broken windows? Did you make sure the mice stayed out of the house? Did you make sure that property that they're claiming is worth $136,000 over the last, for the last 20, 30 years you lived there? Did you maintain it so now that it's still worth $130,000, or did you let it just fall to irreparable repair and just let it get mold and mildew and mice and raccoons living in it?" She said, "No, I did good upkeep." I said, "Good. Then you're a good caregiver, you're a good housekeeper, you're a good groundskeeper." She said, "Yeah." I said, "Make the claim. Make the equitable claim." And she's like, "Really?" I said, "Yeah, just call me if you can't figure it out." I said, "Man, this is so simple and scary. Just make the claim for the equitable value that you put into the land, the sweat, the toil, the labor, that you kept it up. Good. You kept up the bank's house for 30 years? Great, lovely. Now they could pay you for being the groundskeeper, being the housekeeper." Just like the women were doing back in the 70s when they again divorced from their husbands, and all these rich husbands who were presidents, CEOs of big companies were saying, "Oh, well, she was just a bimbo wife. I married her. She was a bimbo at 18. She's a bimbo at 50. And, she never had a lick of work done in her life. She never did nothing." And then the women were claiming equitable interest in the home and raising the children. And the women were walking out with $1 million in sweat equity. Mm-hmm. So I said to the lady, "Don't do what the women did in the 1970s. I said it was hysterical. What they were doing. And they even made a movie. I don't remember if it was called The Wives Club or something. It was a ridiculous movie. I think Diane Keaton was in it and Goldie Hawn. And it was flipped around. The man was making the equitable claim and interest that he was married to Goldie Hawn, but she made all the money, but he gave up his career to manage hers. So he was getting tons of money. So it's funny. And people forget all about how to do that. But it was nice that somebody recognized me, and a court clerk saw the lady come up to me in a clerk's office and said, "Who are you again?" And I said, "The court clerk lady," because I explained to her that she said, when she asked me if I was an attorney, I said, "No, I'm not an attorney. If I was, I could only present the person to the court. But since I'm a man, I could make a present of the court another man. I could present another man to the court. But if I was an attorney, I can't present a man to the court, but I could present a person to the court because I'm acting in the capacity of a person as well." And she's like, "What are you talking about?" I said, "Well, a person is technically a man, but he owes a duty and obligation to a society like a legal society, and I owe no duty or obligation to a legal society. So I'm just saying I'm a man, he's a man, and we're coming here to see if anybody's got a claim that he owes a debt." I said, "That's simple." I said, "Nothing amazing, nothing complicated." So the lady's just looking at me. She's like, "What the hell? That don't make sense somehow." She's like, "I never heard anybody say it that simple." It was funny, the poor clerk lady, but she really liked me. So she gave me a copy of the case file, and we found a copy of the note. But I said to her, "Isn't it true that the original note must follow the case? It can't be hidden someplace?" And she's like, "What do you mean?" I said, "Well, say we're arguing about a pogo stick or a tractor or a pony. Wouldn't the sheriff's department have to hold a pony in the stable somewhere so when the court makes a ruling on the pony, the winner gets the pony? Because if the loser has the pony, he might just out of spite just put a bullet in the pony his head and say, oh, look, some hunter shot the pony when I was in court today. What a shame. You know, I said, aren't you supposed to actually put the item that's in dispute in the care and the custody of the court, the sheriff's department? And I said, this is just a copy. Where's the original note? So she's like, I don't know. You're going to have to ask Wells Fargo. I said, yeah, I'll do that. So we called up Wells Fargo, and obviously, when I asked the first guy, he sent me to a second guy who obviously put me to his voicemail. The second guy, he obviously did not going to answer that simple question.
Yeah, nobody wants to talk to you.
Oh, it's fun. I said, look, I got the cash. I got the money in my back pocket. You know, it's like, say you got a big drug deal. You know, they got 10 kilos of cocaine. You're not going to give the guy 10 kilos and say, hey, come back with the $3 million you owe me sometime soon, please. No, you're going to say, look, here's the money here, and we'll drop it at the same time. We'll grab it, and we'll both run. So where's the note? I'll drop the money on a table, but I want that note. Before you grab the money and run, I want to have one hand on the note. You have one hand on the money, and we'll let our hands go at the same time. I want that note. So nobody else could claim the IOU, the note, in the future. I want to make sure this is the note. And I got the original note. So it's so funny, man.
So now what?
I'm just going to go after the lawyer first. The lawyer is going to be a lot more fun because the lawyer, you know, is in collusion with the lawyer from Wells Fargo, and you know he's in collusion with the trustee that was assigned by the United States Bankruptcy Court. You know they're all in collusion, just laughing their behinds off. I mean, our buddy's proud to be a redneck, and he's proud to not have a, you know, college education. He's proud, you know, that he dips tobacco. He's proud of that fact. You know, he could take care of his family. You know, he's one of those, I got a shotgun and a tractor, and I don't need the rest of the world. So he's a good guy. But like I said, they think this is funny, that they make a quick $2-3 grand off the guy, and they run. So because he couldn't pay his light bill, so he had his lights got shut off because he had to come up with the $2 grand. So he was borrowing it from everybody. And this guy carries my debit card in his back pocket for years. So he could have used my debit card to pay his bills when I was over in England, but he didn't. And so his lights got cut off, and he had to borrow money. So it's so funny, when his lights got turned back on, he had to come up with $1,700 for a deposit and for the past due bill, and they made him pay 2 bills in advance. Mm-hmm. So that $2 grand that he paid the lawyer, he could have saved and paid his light bill on time and not fallen behind. So he's just been having a real tough 60 days. But he takes care of my place when I go over to like England or whatever. He takes care of this place, so I got to help him out now, and it's a lot of fun. So now we're going to just go after the lawyer for taking the money and not doing any work. Thank God the lawyer didn't do anything, because this is a lot more fun to go after, because you know they're in collusion.
Yeah.
You know they're all in on it. So you.
Yeah, they probably made a phone call. You know, we're talking to each other over the phone, saying, "Yeah, I got his money. You go ahead and sell the house or whatever."
Yeah, do whatever you want to do. Exactly. So it's fun. So we finally got one with his pants down. And he's going to call up it's so funny. The opposing lawyer for Wells Fargo got on the phone right in open court, man. He ran out of the door, and we surmised he was calling up the attorney who was supposed to show up, because when we got out to my buddy's pickup truck, there was like a dozen phone calls from his attorney, but we couldn't bring the phone into court. But his attorney was trying to contact him, trying to explain why he wasn't in court. And he just kept calling all day. And I said, don't you dare pick up that phone and talk to that guy. He was going to try to cut a deal with you, like saying, well, you know, I said, no, we're going to file a suit against this guy. And after we get the suit filed, then we'll answer the phone for the man, then we'll try to negotiate a settlement. But don't try to negotiate a settlement until we have something in the court.
Aren't you worried that they're going to arrest you for, you know, practicing law without a license or something?
I don't practice. How do I practice law? What do you mean by practicing?
That's what they call it. You know, that's what they would say.
Somebody asked me that today. Not practice law. What was I get that onto that poor man about? I think something about taxes. He's income. He said to me, income. He says, well, I said, did you make any income last year? He said, well, no, but I made income the year before. I said, The way I define income, it's 16 feet tall, it's orange with black spots, and it eats tall trees and leaves off of tall trees in Africa. Usually you guys refer to it as a giraffe, but I call it income. So if you believe that I'm practicing law, that's a lovely belief. Do I believe I'm practicing law? No. So see, you can't be held liable for your beliefs. So if I believe there's a God, can you hold me liable if I'm wrong? No. See, so if somebody says you believe that you're practicing law, practicing law. Now, how do you find practice? You mean practice like am I trying to do it? Am I attempting to do it? Am I guessing how to do it? What's practice mean? Like, am I practicing to play a baseball game, or I'm with the New York Yankees and I'm actually playing the game? Are you trying to say I'm practicing to maybe one day be a New York Yankee? Or are you saying I'm playing baseball, so I am a New York Yankee? What are you talking about? Practicing. And it's their definitions. Why could I possibly care less what they want to define? There's no law on planet Earth that one man can't aid and assist his fellow human being. It's called being a good Samaritan. So if you're saying that an attorney in a legal society is saying it's illegal to be a good Samaritan, oh, that's pretty funny. Yeah, I guess they would pretty much outlaw or try to make it illegal to be a good Samaritan because there's no money in being a good Samaritan. How much money can they make if everybody just goes around helping their fellow man for, because they want to?
You don't want to make you get a license to be a
to get practically to permit me to help my fellow man is the government. So let me see. Man created the government. No, let's say that for laughs. Man created the government. So man created the government, so the government could tell a man if he could help another man. Oh, that's interesting. So I'm going to be bound as a man by a government not created by me, that I'm not under any obligation or oath or duty to abide or serve or submit myself to. I'm not bound to them. So you're saying if the government of Mexico is upset that I'm practicing law, or England is upset, or Canada's upset, or the United States is upset, somehow you're saying I'm bound because I'm in the United States or I'm in Canada? How am I in the United States? I just walk upon the land. I'm not in the land. I walk upon the land. So I'm not in anything. So you say, oh, ain't you in the United States? No, wouldn't that hurt? Wouldn't that be kind of confining and binding? I guess I'd be in the ground when I'm dead, but no, I'm not in the land. I walk upon the land in a place that you folks refer to as the United States. But am I in the United States? That's ridiculous. Of course I'm not in the United States. Are you in the United States?
Does the hospital administrator hold any liability, or does the agent?
Because the woman said to you, are you threatening me? Are you trying to tell me that if I don't do this, you won't let me take my property out that door? That's all she had to say.
That's right.
And she said, you do know what you just did was extortion. That if I don't do something because you tell me to do or you order me to do it, are you telling me that you're going to hurt me? You're going to cause me harm? Is that what you're saying? Well, if you want me to sign that piece of paper, ma'am, I'll be glad to sign that piece of paper. But you know what? You're going to have to come up with $1 billion up front first, and then I'll sign it. You want to order me? Order me. But I demand fair and just compensation to carry out your orders. You want me to perform a function? Fine. You're getting paid to be here and talk to me? Fine. I want to get paid to answer you.
I don't know. I think it's an uphill battle, really, honestly, because, there's no way to really, unless, like I said, not unless this private administrative process is basically the way to go, where I just write her a letter and say, do you dispute, that, or
he just told you what to say.
That's what you would have said. That's what she would have said in the instance that the agent approached her.
Okay, now all she has to do is go to who's ever holding the child and say, I wish for my property to be restored. I wish for the immediate restoration of my property. That's it. Who's got it? Grandma?
Yeah, Grandma's got it now. And as a matter of fact, Grandma, he had to hire the male friend of this scenario here of mine. Basically, he had to hire a private investigator just to find out where the baby was being located, because at the time when CPS approached her at the hospital the day the baby was supposed to leave, I guess pursuant or respective to the contract that they signed, the baby was supposed to be going to the grandma's address. But in fact,
The grandma had not went from the hospital to there for whatever reason. She went to her boyfriend's house and kept the baby there at another location that was not on record. So the private investigator comes back with this report, like 2 pages, and says that he interviewed, he sat at the lady's house, trying to locate her for a couple of days and was unsuccessful. So he interviewed a couple of neighbors, and the neighbors said that she hadn't been home for several weeks, and that, they would be, that necessarily she hadn't been home in a few weeks or whatnot, and they didn't know where she was. Well,
okay. Before you're going too deep into this.
Yes, that's right.
Very simple. What state did it happen in?
Texas, of course.
Okay. No, not of course. Mine was Alabama. It happens everywhere. It's no big deal. What I'm saying is, who is liable if the baby drowns or the legs get broken? Is the state of Texas liable? Is the county liable? Or is grandma liable?
Yeah, like grandma. I mean,
is grandma considered a foster care provider?
I wouldn't.
He's not. And he's telling you to ask those questions.
Right.
I see. I'm asking
you. Right. If the baby accidentally drowns or gets strangled by his own diaper, whatever. Okay, who is the mother going to sue for the damage to her property? Who is she going to sue? Grandma, or is grandma considered a foster care provider, or is DFAC or CPS or DHR or DSS? They still have the capacity to place the child?
That'll put the spirit of God into them.
Yeah.
I'm sorry, I really heard what she said.
I just said that would put the fear of God into them.
Yeah.
Are you going to be liable? Are you taking full liability for this, child then?
Yeah, that'll put the fear of Lentz in them.
Well, I tell you what, no matter what, I think they signed a new lawyer to the case.
Forget about lawyers, man. It ain't common sense unless it's Lentz sense.
All right, well, thank you, man. I appreciate the information, and I really don't know.
Just go find out, man, who is bears liability if the child gets injured, harmed. Who is bearing the liability? This is her property. And if this girl or the woman, whoever who bared this child, doesn't have the understanding of what the word property is, she will never get her property, the restoration, it'll never occur. If she keeps saying child or baby or infant or kid or offspring or prodigy, if she uses any other word other than property, the government's going to not recognize it as hers.
Okay.
So she has to define it exclusively as it's her property. It's exclusive to her. Nobody else with the society can make a claim for it. And all she has to do is wish for its immediate return. That's all she has to do. Nothing else.
So she writes that directly to the grandma? Because, I mean, there's other players.
Right, and grandma's going to tell her to go F off, right?
I believe so.
Good. Then now you just take that F off and you take it to your local mom and pop little district, what you guys would call a small claims court. To me, if it's a penny, it's worth making a claim for. I'm going to make a claim, and you guys want to call a small claims, call it anything you want. It's just a claims court. Just go down to your local court and just file a claim that she has my property and I require its immediate restoration. And that's it. And the court clerk will say, oh, okay, fine, and she'll stamp it. And like I said, that when I did with the folks in Canada, I said, see Exhibit A. I'm going to put the child's name down. I said, see Exhibit A, and I attached a photo of the baby. To the 4 kids, it was see Exhibit A, B, C, and D. So the court clerk can't give you any boo. They just say, see Exhibit A. So after the court clerk stamps it in and files it and says, okay, we'll have the grandma summons. Where's Exhibit A? It's like, I forgot Exhibit A. You know what? I'll bring it down tomorrow, and I'll make sure the other side gets a copy of it. Because then when she sees Exhibit A as a baby, then the court clerk's going to be like, oh, I thought you meant a yo-yo, a pogo stick, or a bowling ball.
And then they
I didn't know you meant baby. It was like, don't worry about it. It's my property. Don't worry about it. And I make the immediate claim that I want the restoration to occur immediately. And let grandma come forth and try to prove that that's her property.
Yeah, very good.
And then they say, well, you got to take this to family court. It's like, no, where does it say I have to take a claim for property in family court?
Okay, but Here's the thing, Carl. Know this.
That's a child. It's like you might define it as a child. I define it as property. Now, who's making a claim, court clerk lady? Are you making a claim, or am I making a claim?
Well, of course, Grandma's petition actually, morphed into a case number, a cause number, like family court. And so whenever
that's grandma's case.
Exactly, because I heard from a call once before from you. I mean, if they make a claim, then you make a claim, you bring your own claim. But here's the thing, when he goes into court or when he went to the county recorder, the clerk's office, he basically went down there to go and ask them, how much does it cost to make a claim? And they were like, I think they know and recognize this guy because he's been back and forth down there about him. And I don't know, I hear some feedback, but
yeah, a lot of feedback.
Basically, they recognized him, and when he went to ask how much would it cost for him to file his claim, they were trying to, divert the man to file all of his paperwork into their claim, into Grandma's claim.
Okay.
And by the way, Grandma's claim was only a petition.
Sir, hang on. Yes. If anybody's having a hard time with the court clerks, the simplest thing to do is put a lousy stamp on it and mail the damn thing with a check and be done.
Be done with it, huh?
Be done. No discussion at the counter, no nothing. They have to accept it. They stamp it. They file it. It's done.
And that's even in the case of a new case.
That's simple, right? I couldn't drive down to Alabama. I filed the case. I just put a stamp on it, put the money order in it, and done.
Okay.
If I stood at the window, you don't think they would have gave me a hard time to try to file my case? Because the individual in charge of Alabama's Department of Social Services was the chief federal district court judge in the federal district court in which I was filing my claim. You don't think the court clerks would have been trying to defend the chief judge of that district federal court by not accepting my claim? Of course they're told not to take any of my paperwork. So you just put a lousy stamp on it and mail it. If somebody orders you, you do fair and just compensation. And like the man over in England, he's been doing great over there with the government over there because people are calling him up like crazy. And he's going into courts and he's going into government meetings with these people. And they said, are you ordering this man to do X, Y, and Z? And they were like, yes. It's like, well, on this piece of paper, it says he must do this, he must do this, he must do that. And they're like, so why don't you just change that word from must to order? And they said, well, it means the same thing. It's like, no, it doesn't mean the same thing. You mean like when you go to McDonald's, the lady at the counter says, oh, sir, can I take you a must? No, the lady would say, can I take your order? So must doesn't make any sense in that sentence. So just put the word ordering down there, and this man will be glad to carry out your public servant's orders, and I'll make sure that he carries out your orders. See, he's not saying why, because the public servants know. They can't order you. Some cops will just start freaking out. It's like, no, I'm not ordering you. Then what do we have to talk about today, sir? Well, I want your driver's license. It's like, okay, just order me. Well, I'm not going to order you. Well, then what do you want to do, sir? Well, I want it. Okay, just order me. Just say, I order you to give me your driver's license. Just order me, and I'll carry out your orders. What's the problem? Most cops just say, yes, it is an order, because they don't know. But I talked to a young state trooper the other day, and I said to him, I was driving my sister's van, and he stopped me, and he said, her tags are expired. I said, oh, yeah, December's her birthday. They expire on her birthday. It's January. Oh, that's right. I said, I shall get them registered. And he says, oh, okay, I shall be right back. So he went to his car, and he came back with a ticket. I said, oh, that's lovely. I said, but you were clear. You clearly heard me say, I shall register. He says, yes, I heard you say that. I said, you do know what the word shall means, right? And he says, yes, they trained us at the academy. That shall means something in the future, that you haven't really done anything wrong today, but they still told us to just write out tickets anyway. I said, do you realize what you just said to me? I said, do you realize that what you just said is systemic? It's within an organization to be doing something illegal and unlawful. You're telling me you were trained that you know what the word shall means, that I'm not doing anything wrong because the future hasn't occurred yet, but you still are trying to find me and penalize me for something that I have yet to do? I said, have a lovely day, sir. And I said, I'll be so glad to see you in court on April 2nd, and you explain yourself to the court what you just did. I said, stay safe out there, kid, and drive safe, and, God bless you. And I left. I just laughed because he told me that the academy teaches the state patrol officers what the word shall means, that they don't have any jurisdiction or control or capacity to order a man to do anything, and they know shall means something in the future, that at some time in the future, maybe the government will have control over man. Maybe we could order man to get a car registered. But we can't order a man to get a driver's license. We can't order a man to get a registration. We can't order a man to get an inspection sticker. But man is tricked. We'll trick them by using the word shall. And they'll think shall means must. But we, as government, know we can't order a man to do a freaking thing. So, see, they're teaching these troopers they can't order a man to do anything. So that's the whole thing that you got to try to get in your head.
Okay. And so then I took the ticket back and I returned it, and the court clerk told me she was going to throw it in the trash. Then I filed that notice to cease and desist against the officer, against the court clerk, the city attorney, because at first they told me the city attorney would be prosecuting it. And failure to stop.
Okay.
And so then still found out it was on the docket, so showed up in court, and the judge let me read a statement where I basically listened to your stuff and had written all of the things down to say.
What did you say? What did you say?
I said, well, ma'am, I was traveling the other day and this officer stopped me, and as far as I know, for no reason. I harmed no one and damaged no property. If I did, I'd like to find out who and settle with them. Now this officer is bringing this complaint against I, and I don't answer complaints. I returned the complaint with a letter in good faith to Pam, the court clerk at the window, and told her I was not willing to contract with them. I followed up with a cease and desist notice along with my fee schedule, which I sent certified mail to the officer, the clerk, and the city prosecutor, who I was told would be prosecuting the case, since I know that you can't prosecute it. And today I find that this matter has not been taken care of, and I know you don't want to violate your oath of office. I know you can dismiss or discharge this matter, and I'm waiting for your answer. I am a woman, so act accordingly.
Ma'am, you just used my stuff, Billy Thornton stuff, Dean Clifford stuff, Winston Shroud stuff, Freeman of Montana stuff. You used everybody's theories in one letter. I just say, who's the man who's going to come forth and make the claim? I'm here to compensate any man I've done wrong. That's all I say. But you used Billy. I mean, you used everybody. I mean, you just threw the whole kitchen sink with all the pots and pans and spoons and everything at this poor lady judge, and she's like, "What is this? What?" This is like every free man speech, dialogue, rhetoric I've ever heard in my life. It was good. It was funny, but no, my thing is one sentence, two sentences. I'm here to settle a debt. Who's making a claim? I owe a debt. Who's claiming I did wrong?
Well, she, because this was arraignment court, and she was just pushing it on, and you were either supposed to plead guilty or not guilty, or you were going on the trial, and so so she kept. Did you listen?
Did you listen to my very first on this talk show thing I got? I think it's 127469. I said Karl destroys Gordon. Because Gordon was trying to get jurisdiction on me. Gordon was trying to arraign me. And all I said to Gordon is, may I have leave of court for pen and paper? He says, what happened if they just drag you in irons and chains? I said, can I have a piece of paper and pen? So you had a paper and pen. All you had to do is present to the court. It's like, I have this notice to present to the court. And hand a copy of the notice to the court. I am here to settle a debt. Who is the man who's going to come forth to claim that I've done wrong and not settle the debt? That's all I'm here to do today. I'm here to settle any debt that any man claims is due and true. That's it. You make something really simple like that, and you pass the notice to everybody in the court. And the judge says, all I want to hear is guilty, not guilty, no contest. It's like, okay, did you not get my notice? Yes. Okay, that's all I have. I've answered the court. I've put a proper answer before this court. Do as you wish. And that's it. That's how you handle an arraignment.
Okay.
Let them bear the liability of guilty, not guilty, and no contest.
Well, she looked at me and she asked me again what I was gonna plead, and I told her that I had given my statement and I'd given her a chance, and I had a claim ready to file, and I believe that I had the right to free travel, and the Supreme Court believed I had the right to free.
See, this is your problem. This is what I'm telling everybody's problem is that they got a tongue attached to their throat. You're supposed to do everything in writing. If that, ma'am, this is not just you, ma'am, everybody who's listening to this thing. When you get asked a question in court, you ask for leave of court, and the judge will say, "Why? I want to answer the court properly. I'm going to require of this court to give me leave of court so I could give a proper answer." And he'll say, "How long will that take?" "About 2-3 minutes." And then you write it down, and then you hand it to them. You don't get into a conversation with these people verbally. You will lose. There is no way in the world you're going to hold your own in court. You do it all in writing. And you hold them all liable, because if the judge wants to enter guilty, not guilty, no contest on you, what do you say? "Can I have leave of court, Your Honor?" "What? I would like to answer the court whether you wish to enter the leave on my behalf." "Good. Can I have leave of court for a second so I can properly answer the court?" "Yes." "Here, let me write this down real quick." And you say you will bear all liability. Whoever enters a plea on my behalf will bear liability, and that's it. The judge knows what you're doing by just saying, if you enter anything on my behalf. If you order anything on my behalf, like you order 10,000 pancakes, you're going to be liable for that order. If you're going to order me to reappear, if you're going to order me to appear in 20 days to answer this, you're going to be a liability. I did that once to my sister back in 2007, 2008. The judge was like shit in a pickle. He was looking around the courtrooms like, "Who wrote this? Who wrote this?" Because in a civil matter, they can't compel you to fight. They can't compel you to put up your dukes and fight, or they can't say, when you go to court, it's supposed to be like it's a battle. Instead of people shooting each other at dawn, pistols at dawn, they wanted to handle it civilized. With that Alexander Hamilton, Burr, they killed each other. They said, "That's enough. We're going to have to settle our squabbles amongst man in a civilized manner in a courtroom. So we're going to promote this civil courts." So like I said, it's a very simple rule in Virginia that I know of that I used. It's a Virginia Supreme Court ruling. What is it? 2? I'll try to get it down in a couple of minutes. But it's a very simple. It's 2. I'm trying to remember if it's 2FB. But it says something very simple, that if anybody orders the case to move forward and both parties aren't ready to move forward, the person who orders the case to move forward is going to be liable. So I'm trying to remember 2. I'll find it in a couple of minutes. I'll Google it real quick on my computer, what it is, the Virginia Supreme Court. But nobody can compel you to fight. Nobody can compel you to do anything. They can't order you to answer. They can't order you to open up your mouth. They can't order, if somebody wants to if somebody wants to enter in something on your behalf, you just tell them that, you put in writing that they're going to bear liability.
So I'm supposed to show up March 4th, and there's a judge, and the police officer is the one who's prosecuting this claim against me. So I do not speak. I just hand them written.
Everything, you got to do everything in writing. You have to stop talking. Because every time you start talking, they get jurisdiction. What if they're talking Chinese to you? They're talking legalese to you. They're talking Cantonese. They're talking Vietnamese. They're talking legalese.
Well, what happens to how you said where you go into the court and you ask if anyone has a claim against?
You put it in paper. I put it on paper. I put it on paper. I put it on paper. Go listen to my very first talk show with Gordon Hall. Gordon Hall was going bananas because I said, "Gordon, I don't have a tongue attached to my throat. I would never be stupid enough to open my mouth and utter anything in open court. Gordon, I've been doing this a long time. And even I'm not stupid enough to open up my mouth. And all you people who have no experience whatsoever are opening up your mouths. And I'm not crazy enough to open up my mouth. What makes you people to think that you should open up your mouth and speak legalese, Cantonese, Vietnamese? They speak in a completely different language.
So when is the time for you to open your mouth? Because I've heard you say you need to speak it.
Only when a man is speaking to you. You have to know if you're speaking man to man. Oh yeah, in the Supreme Court, the Virginia Supreme Court rule it's VSR 7, like 8, it was 5, 6, 7, 7B, like Bravo 2, 7B2, and that's the one that you could basically base it off of, the 7B2. 7B2 basically just says that you can't be compelled to fight or defend yourself or do anything until you're ready, until you're damn good and ready. If it's a civil matter, you move when you're ready to move. That's why people always say civil trials are horrible, or when civil lawsuits are horrible, because it could go on forever. Like especially with attorneys, they could just bounce it back and forth, back and forth, back and forth forever. It's civil. You can't force somebody to fight until they're ready to fight. You can't force somebody to stand their ground and say, okay, in civilized, you still have a chance to prepare and get ready, It lasts forever. That's the rule in Virginia. So Virginia Supreme Court Rule 7B2. Although it's FB2, it's 7B2. But I haven't done that. Looked for that silly rule in years. But like I said, that's just something that you guys could refer back to and say, oh, I see what you're saying. So there's probably something in Texas or California and Oregon, basically the same thing in civil proceedings, that you can't force me to move forward with my, my defense, my claim, my case, until I'm ready. They can't force you to fight in a civil matter. It's not civilized. So, like I said, I say as little as possible when I go into court. I just say, did you not understand the notice? Did you not read the notice? What part of the notice did you not understand? I'm just here to settle a debt. That's the only way you could force me into court that I've done wrong. Who is coming forth to make the claim that I have done wrong? It's that simple. Who's here to say I broke the law?
Okay. Okay.
If the cop says, well, this is the law. No, that's a code. It's a code. It's not the law. There is a public law. It's enrolled somewhere on parchment, somewhere in the state capitol, in some sort of congressional library or legislative library. The public law is an enrolled document somewhere at the state capitol. What you're quoting is a codification of the law. You're getting a little snippet. You're taking out of context what the law truly reads. Now, are you going to bring the law into the court and unroll the public law and read the public law into the record? Or is this going to be a lawless court and you're just going to say that this is a code? But if you try to open your mouth and you try to utter what I just said, you're going to look like a moron. You see what I'm saying? So you try to put it as simple as you can on paper.
I know. So you just take paper in there and then I just answer them with paper and hand it over?
Yeah, that's the best way to do it.
Okay.
You say, I require leave of court. And me and Bali did it. It was funny. When Bali did it, I thought everybody would laugh when he says, I need leave of court. And the judge says, why? He says, I need to wee-wee. In the United States, we think that's wee-wee. What are you, 3 years old? But no, nobody in the court laughed. Everybody's like, oh, I guess that's the way they say, I got to go to the bathroom. So we would go to the bathroom. I'd go to the bathroom with him, and I'd write something down on a piece of paper for him.
Okay. So what do I do when they dismiss or not dismiss this, but say that they're going to put a bench warrant if I don't pay?
Why don't you make a claim that somebody's filing a false complaint into the court and saying that I have done no wrong? I have done no wrong. I have broken no law. I am just a woman going from point A to point B, and I have done no wrong. This man is bringing a false claim into the court that I have done wrong. I have done no wrong. I've injured nobody.
We did do that claim.
Oh, you did make a claim.
Well, I haven't. We didn't file it. I didn't know at what point I was supposed to take that into them.
Because I'm sure your claim is more than 3 or 4 sentences, isn't it?
Yes, if that's page long. We sent you a copy in your email.
Yeah, it should be right. It should be 3 or 4 sentences, and you're done. Say say this man has claimed that I have done wrong. This man said that I failed to stop. By mail, it's that simple. What did he say what is his claim that you've done? By my non-failure to stop, I still have caused no harm, no wrong, no injury. This man is making a false claim that I owe a debt. So you just got to pull yourself away from being a driver. You just got to say, I'm a man or I'm a woman going from point A to point B. Okay, let's just put it this way. Say you like that movie, Omega Man, and you're like Will Smith made the remake, and you're the last man on planet Earth, last woman on planet Earth. Are you going to stop for every freaking stop sign? No. Why? Because you realize you're not going to harm anybody, hurt anybody. So why bother? It's advisory. It's all advisory. It's the same thing. Like say you saw a bus, hitting 2 or 3 cars behind you because the driver fell asleep. And what are you going to stay at the stop sign and say, oh, I better not go through a stop sign because I'll get a ticket? No, you're going to blow through that stop sign and get out of the way of the bus. They're all advisory. All these codes are for the benefit of man. They're here to advise us how we should act. how we shall act, how we should do something in the future. It's advisory. Because whatever you say, well, I stayed at that stop sign and that bus plowed right into me, and it broke both my legs. So I'm going to sue the state legislators because they intimidated me. They made me so scared to go through that stop sign. The cops made me so scared that I go through a stop sign that the bus broke both my legs. And they'll say, well, why don't you just get the hell out of its way? And I say, well, there's a stop sign there. They say, all of these codes are advisory. They're just there for your benefit. You got to use, your better sense of your own judgment to act or not act in a certain manner. If you believed it was in your best interest and nobody's going to be harmed, then, it's just advisory. They just put it there to help people because they take all the stop signs away. Everybody's going to be freaking out every time they come to a crossing. So they're lovely advisements. It's nice that somebody actually spent the money to put stop signs up, but it's all advisory. There's no law that says you have to stop. It's advisory.
Right.
Yeah.
So I thought
good advice, but you chose not to take the advice. So you chose not to take my advice. Okay. Was anybody hurt? No. Did you hurt anybody? No. Then what's the point?
Exactly.
And if you read the code, if you read the code, ma'am, I can almost guarantee you, if you read the code, it says all drivers shall stop. Okay?
Right.
Sometime in the future, you shall stop. So how could they give you a ticket for something that you ain't done yet? Go look at the code. Look at the code. I guarantee you Oregon code. And that's what somebody called me up the other day from some state. He said, Atlanta. I wish the man from Atlanta was calling up, a pizza delivery guy. He said to me, oh, my God, Carl, he was a second mark from Atlanta. There's two marks from Atlanta who doing this silly stuff with pot and stopping their cars and not stopping with tickets or whatever. Then one man from Atlanta read it. He said, oh, my God, Carl, every single code for traffic says shall. I said, right, sometime in the future, you shall stop. He didn't say you had to stop today. He didn't say you had to stop right now. It says in the future you shall stop. Yeah, when the government sometime has control over you. But at this time, well, unfortunately for the government, they don't. Unfortunately for man, we have control over our own actions or inactions. And we can't hold the government liable. Because you can say, look, you said right here in your code book that I shall stop. And since I stopped, I broke my legs. No, ma'am. Sometime in the future, you shall stop. That's what shall means. It doesn't mean must. It says shall. Read the damn thing. And they'll say, oh, that's bullshit. We thought it meant shall means today. No, shall is future tense. And that's what I tell people. Go Wikipedia. It takes you 2 seconds to hit your keyboard. Shall, Wikipedia, future tense. Not present, not past. Something that will occur in the future. The government officials are incredibly intelligent by writing these codes because they know using these silly little words like shall makes you people believe that it means today. Oh, all drivers shall stop. Let's say must stop. It's like will and shall. Will, something in the future. When somebody dies, they'll read their will and say what I'd like to do when I carry on from this planet Earth. When I'm no longer here, this is what I will you to do. It's future, not present. So like I said to people, that's a simple way to get out of a lot of that nonsense. Is just say, doesn't your statute say I shall stop? Yeah, what does that mean? Sometime in the future? Is the future here? No. I can tell people all the time, mess with your mom like that. So your mom says, go mow the lawn. I said, okay, Mom, I'll go mow tomorrow. Sunny day, next day, pops up, boom. Mom says, you're going to mow the lawn. I said, I told you yesterday. Well, I told you. Tomorrow I'll mow it. And she'll say, oh, don't play that silly tomorrow never comes. Well, that's what the government does to you guys. It says shall. Well, shall never comes. It's that simple. Then they know what they're doing. They're just messing with you. Just like I mess with my mom. So, yeah, tomorrow I'll wash your car. And then next day, the sun comes up and Mom says, you going to wash my car today? Today? No, I thought we agreed on tomorrow.
All right.
That's what the government is doing to you. It's like, oh, I thought I must stop. No, you shall stop. I was telling you, it's just a game. They're playing word games, you people.
Okay. Thank you, Carl.
All right. He can call me if he wants to. I like that guy, man. I haven't talked a fake name since like April or May. He just dropped off planet Earth.
Okay, we're going to move on.
All right.
Here. All right, Walking Truth. Let me see. There you go. You've been unmuted. Do you have a question for Carl?
Hi, Andrew. Can you hear me all right?
Yeah.
Yeah, this is JB in Tampa. How you doing, Carl?
All right.
Thanks for I think one of my questions was just answered with the lovely conversation you just had with this lady, because I was confused when we should talk as well, because it sounds like you're advising a lot of feedback in court. But basically, if I go listen to the Gordon Hall one, which I haven't listened to many of them, but I haven't listened to that one. Basically, every time an answer is required, I just take a quick leave of court, write the answer down, hand it in, and if they don't respond accordingly, then I can say something as simple as, did you receive my notice? Did you read my notice? Did you understand my notice? But that would be it.
That's it. That's perfect, man. That's simple.
Okay.
They love it, man. The whole world is two-dimensional paper world. They love it, man. Just communicate them at the level that they understand. See, the judge or guy in a black robe is just like the interpreter between the two-dimensional and the third dimension. So he's the interpreter between black and white and three-dimensional. So keep it on their level. Never, ever cross. Let them drag your third dimension into their second dimension. They're running parallel tracks, man. It's like parallel rails. Don't ever cross over because they'll run you over. That's what I did in England. It was a lot of fun. For 5 hours, we were running parallel. I mean, the other side was trying to compel me to answer something in legalese. Just make it call. Just say something in legalese. Just cross over our side. Just cross into our dominion, our world, into our realm. Just say it, Carl. Just cross over. Just make one precedent, one citation, one ruling, one statute. Please just do it, so we will run you over. We will hold you in our jurisdiction, and we will slaughter you. And I just ran parallel in the common law side. And I was trying to tempt them to come over. And every time they tried to come over, I just smashed them. They were like, it's like, boom, boom, boom. And the poor judge was laughing his behind off. You know,
let me ask you a question right there. Let me stop you right there and ask you a question. When you say you tried to get them to come over, how did you draw them back to the common side? Did you do it via a written?
No, I was just when we made our case to the Crown, when we made our case to the judge, what I was saying, I'd say speaking in common law. And it was funny, the barrister would try to say, well, what you did was wrong with, this man, da-da-da. I said, you mean an officer? Or you mean a man? It's like, well, he's an officer. Well, is this France? It's like, what? Is this a common law land? Yes. Does a man stand in court? Yes. where does an officer stand in a common law court, in a common land? It was so funny watching the poor guy saying, look, this isn't France. This is a Napoleonic Code. This is a man. This is a law of man. This is a land that abides by the common law. So is there a man who's going to make a claim today that any one of these three people have done wrong? Well, they did this. Look, sir, I already agreed that everything they did was illegal. I already agreed that they're guilty of everything that they've been charged with. Fine. Lovely. But is this France? No. And they have done nothing wrong in this common law land. They have not done anything wrong in England, have they? In France, yeah. But is this not a common law land? Yes. Do they not have to do wrong? Yes. Did they do something unlawful? He says, well, they did. I said, that's illegal, what they did. And they're guilty of that as charged. Whoop-de-do. Big deal.
Okay, so this is the part that I think confuses part of your audience and your followers is you did have this tete-a-tete back and forth with them in that vein. But normally, if you were trying to answer something, you would only do it by paper. But
I never talked directly to the barrister. We always talked directly to the judge, who was the interpreter between the second dimension and the third dimension, between statute and legalese and law and man. We talked directly to the judge. That's what the judge will tell you. Don't look over at the other side. Don't talk to the other side. Talk to me. I'm the interpreter. I'm the judge. I'm the referee here.
Okay, so let me ask you this, and you just told the other lady she can talk when she's talking directly to the man, but now I'm supposed to talk to the barrister or the judge.
No, when only a man takes the stand. A barrister can't take the stand. So when you're addressing the court, you're addressing either the judge, you're addressing the man who's taken the witness stand. You're talking to a man. You could talk to a man. If the man is saying, if the man took this, say I owed you a debt, or you owed me a debt, and you took the stand against me, I'm going to talk directly to you. Sir, do I know you? Do you know me? How do you claim I owe the debt? I will talk to you. But the other side, like a barrister or a state prosecutor, is like, if he says I owe a debt, I say, oh, is that true? Good, take the stand. And I will talk to you once you're on the stand. Well, he said, I can't take the stand. Then there's nothing for me to say. I only talk to a man who could come forth and make a claim I owe the debt. Do you know if I owe the debt? Do I owe it to you? Do you know if it's true? No, I don't know anything. then what the fuck are you talking? Why are you saying anything in this courtroom?
So you say that much to him to get him to take the stand, but when he doesn't, then basically the conversation is over. Why are we here?
Right. The judge will say, then you know the law. Like my sister did that when I said that to people. My sister got divorced. She wanted $20,000 for a retaining fee. I told my mom and dad, don't give her a dime. My sister, she loves me to death. We do anything for each other. I said, you're not getting a freaking dime from us. You can handle this on your own. Your husband's got 3 lawyers. Yes. His lawyers, I guarantee you, advise him not to say anything, to just sit there because he's guilty of infidelity. Yes. Good. All you need to do is, as soon as you hear anybody other than your husband open his mouth and open court, because she was the one moving the claim of for the divorce, if anybody opens up their mouth on the other side, you immediately object and say, does any of this person who's speaking now at this time have any firsthand knowledge of any of the anything that has transpired between the relationship between me and that man over the last 20 years? Yes or no? If they do, let them be sworn in now under oath of affirmation, take the stand so we could use it and so we could have it placed upon the record. So as soon as the poor attorney lady tried to speak, my sister said, I object. And the judge said to my sister, wait a second, you had your turn. You said what you had to say. Now it's their turn. No, it's his turn. I'm making a claim against him. If he wants to answer the claim, let him speak now or forever hold a peace. If he doesn't wish to speak now, oh, well, I order the court to award me what I wish. So then, like I said, the attorney for the other side tried to say, but, Your Honor, we're here to represent him. And then the judge said, well, you know the rules. Do you have any firsthand knowledge of any of the events that transpired between these 2 people over the last 20-something plus years? No. She said, then, lawyer lady, you need to sit down. And then she said, but, Your Honor, and then she said, now you need to sit down and shut up. You know the rules. And my sister said, the next thing happened was the 3 attorneys said to her husband, you better take the stand because the judge is about to award her everything. You better say something in your defense because it's over. We can't do anything for you. She just knocked us out. Now you better come forth and you better say something. So he did take the stand, and my sister just knocked him out anyway because he wasn't prepared. He had nothing to defend himself with. So he came in with 3, because he was a Gambino. They had big money. They knew all the judges. They had all the attorneys. They had everything. And I said to my sister, you're not going to beat them with an attorney. You're wasting your time. You're going to have to knock the attorneys out of the game. So just take them out. Just say this, and it'll be all over. And she did, and it was all over. She loved it. She had a good time.
Okay.
I wish I could have been there.
Oh, yeah. I would have loved it. It was a judge lady, too.
Well, let me lay just a little bit of groundwork here. I've been defending my own foreclosure for 6 years. Primarily, I had the most success when I studied Bill Thornton and used his writs of error for about 2 years. And somewhere along the line, they kind of got me off track. I didn't know how to really close the deal, and we've been off doing legalese, for lack of a better term. But it all started when in 2008, I actually won with a simple challenge of jurisdiction. My case was dismissed with prejudice by a judge, but the judge was retiring the next month. And so he retired. My case was dismissed. Estoppel was in place, but they kept filing into the case. And this has been going on for an additional 5 years, and I've strung it out. Now, just before I found out about you, like a month before, I was at my wit's end. We were ready to go to trial after 6 years. They finally got it to where we were going to go to trial. And I didn't know what to do, so I filed for bankruptcy. And we've come out the other end while I've been listening and studying to you. But I'm in bankruptcy court with an adversarial proceeding, and I'm bringing a claim against them under the auspices of the bankruptcy court. And the claim is basically for a violation of my due process, and for a breach of a common law trust, which I set up with the plaintiffs.
Yeah. Well, like I said, I love common law trusts. I mean, that's how I got the folks out of England. Out of one of the crimes or offenses they were charged with was putting forged commercial paperwork into the public. And I said, well, they audited out of their trust. And I had to explain to the judge 3 times in open court what a common law trust was compared to a public trust. And the poor barrister was going crazy, using hours of citations, codes, statutes of what you have to do when you create a trust. I said, that's a trust in the public. I concur. You got to go to the county recorders. You got to disclose the beneficiaries. You got the trustee, the grantor, I said, but I said to the judge, that's lovely. I'm not arguing anything. He's the best barrister I've ever seen in my life. I said, but what I'm telling you is, if you got a trust in common law, you don't have to disclose any of the contents to anybody. And it was funny how I explained it to the judge, and I did it 3 times. And then when it came up with the ruling, he said, okay, fine, because he said they were guilty, the forgery, forged instruments in the public, da, da, da. So, but he said, fine, this is a common law land. Okay. So he's like, they didn't do anything wrong. And okay, so the charges, of entering a forged commercial paper into the public through a trust, he said, fine, that's discharged as well. So it's just funny because, like I said, you've gone through bankruptcy, so you're in the United States Federal District Court, you're saying, correct?
I'm in the United States, the bankruptcy section of the district court. Yes, the adversarial proceeding is filed under the umbrella of the bankruptcy court, not really USDC.
Yeah, what I'm trying to say is I try to get people away from these any kind of statutory courts, code, codified courts. All you're moving under some sort of Title 26, 16. You're moving under some sort of crazy code.
Correct.
And this is what happened to the poor Dean Clifford guy. When he got arrested, he was an expert with the codes. He and his crew knew every code on planet Earth that pertained to Canada and Canadian Constitution, all this other stuff. The problem is that they said on his when he was talking from jail, was they modified all amended the codes. So when he was ready to place all of his work before the court, before the Crown, all of it was utter garbage because they amended all the codes. So it's a very dangerous game you're playing by relying upon their codes, because they could change their codes at will, and there's absolutely nothing you could do to deal with the interpretation or amendment or the modification of their codes. And all I teach people is how to talk like a man when you go to court, how to stay on a common law, how to stand on a common law side. We won't have a common law for maybe 40, 50 years. Hopefully, it'll be as long as I'm alive. We'll have a common law system in this country. But eventually it's all going to be codified. I know it's going to be all sort of one world order, new world order. Of course it's going to be, because the kids aren't learning what I'm teaching. So they're just, you folks just do it. A police officer waves a badge, so all of you guys just say, oh, it's the law. No, it's not. It's not the law. It's all advisory. Do what you wish. You're a man. You only got so many spins around the sun. Don't hurt nobody, and rely upon a common law for your defense that, hey, I didn't hurt nobody. That's nice that a whole bunch of women decided to sit around and say everything I do is illegal. Thank you that I got to wear a bubble suit from the time I'm born to the time I die. Thank you for being a nanny state. But I think I got this. I don't think I need your help, and then certainly not. I don't require anything of you.
Okay, let me ask you this question, Carl. Let me try to just take this a step further. I realize that this is not in the vein of what you're teaching exactly, but I'm already in the BK, and I'm trying to use the AP proceeding to my advantage while I'm there. I do have a foreclosure that's been stayed back in the regular state, county court. So I filed the paperwork with a common law court of equity, tried to set the jurisdiction myself in common law. They're still putting me, of course, in all the paperwork. I didn't do this. They're putting me as pro se online. And I've read your case filing.
Oh, yeah. You don't have a choice. When you're in the United States District Court, you are pro se. When you're at the United States District Court, you're a man.
Yeah, but I filed it into the bankruptcy court of the United States, not the
You just said it. You just said you filed it into, not at.
Well, I didn't. I don't want to play semantics with you. On my heading, my paper heading, it says bankruptcy court in small letters of the United States.
Okay, so that's not going to help you. That's not going to help you. That's not going to help you. If you went to go to a federal court and you wanted to claim that you a man can't be bankrupt. So that's what people don't understand. As long as a man is alive, even if he's dead, you could harvest his organs. A man is always worth something. So you can't say that a man is void of any value. I mean, that's ridiculous. You're not bankrupt. So, when you say bankruptcy, you should know what the word means when you just say, I have value and I have worth. Just at this time, the other side doesn't, believe that what I claim has value, it believes has value. It's like I have a pocket full of Canadian, English, and American money in my United States money in my wallet right now because I've been over there and I got their money. Now, I can't obviously pay somebody with Canadian money because it's 70 cents on a dollar, and English money is 17 cents for every 10 cents. It's 1 to 7 to 1. So some people will say this money has no value, that money has no value, that money has no value. And money is just a medium of exchange in which two parties agree has worth. So this poor man, when he went to bankruptcy court the other day, the lady said, do you have any money? And he says, no. I said, oh, of course you have money. Of course you have a medium of exchange that's worth, that has value. I said, you fix my cars for me, I do your legal work for you. Or you take care of my cattle for me, and I'll take care of your dog. You know, what part of money don't you understand? This lady's just asking you, do you have money? And you said no. You say, yes, I have a lot of money. It's like, oh, good. It's like, yeah, just at this time, this man doesn't believe that my money that I wish to offer to him has any value. Like some man in Indiana paid me like 800 bushels of corn. Now, obviously, I don't have a truck to hold 800 bushels, so I found a broker. The broker gave me cash. I took the green. The broker took the corn and gave it off to a farmer somewhere. Who knows? But that's what I'm saying. Well, you guys got to start understanding what money means and bankrupt means and value.
This is a question concerning a speeding ticket. I sent a letter to the court objecting to the charge, and I got a nice letter back saying the court accepts your not guilty plea, and they scheduled a pretrial conference like 5 weeks from now. They said, sincerely yours, and that's nice. And then about 2 days later, I got an offer from the office of the DA from the county to dismiss the ticket fine in points if I participate in a traffic education program for a $200 fee. It sounds like I want. It sounds like I want to do a conditional acceptance, or I'm concerned if I ignore that, they might come back and say, hey, you know, we tried to settle with you.
Well, the big thing is whenever you're dealing with a traffic ticket, to me, the number one concern is to allow the other side, to make the other side aware, however you have to drill it into them as nicely and sweetly as you can. I am a man. There is no law that requires a man to obtain a license of any form to take an apparatus and go from point A to point B. There is no law that requires a man to get a license to move from point A to point B.
Excellent. Is the best way to do that via a notice or just a letter?
Yep, letter's fine, notice is fine. First I do it as a letter. Say, can you show me where the law states that a man needs permission or a license to go from point A to point B? See, I got so tired of people saying travel, drive. I got so tired of these legalese words that I said, hey, how about we just make this simple? Do I need a license to go from point A to point B? Simple. It's like,
and wait for their answer.
And wait for their answer. Do I need a license to go from point A to point B? Well, if you're driving a car. I didn't say I was driving a car. I said I was going from point A to point B. Nobody said anything about transport. Nobody said about drive. Nobody said traveling. Do you believe I was driving? If they say, well, the cop believes you're driving. You mean Bob, who's a man, who's sometimes a cop, he believes I was driving? Well, driving to me is like hitting a golf ball with a mashie or a wood or a 5-iron or a putter. That's what I believe drive means. Or drive means I have great goals and ambitions in life. I have a great drive. Now, if he believes I was driving, okay, but what do you mean by driving? You know, because if it's ambiguous, you know, you can't hold me liable for it. I did that in court one time. It's hysterical. I used the word long. The thing was long. I said, okay, there's 3 definitions in Webster's alone. I said, I long for a lost dog, my lost home puppy, my lost homeland. Long as distance, as in, you know, travel distance, or long as a measure of time. Now, in this statutory code in which you bring forth into this court, what do you believe the word long means? And the assistant chief of police gave me the thumbs up from the witness stand. At least I saw him give me the thumbs up, because guess, buddy, what you think the word long means, because I could take your statute and wrap it into what do you think it means? And you think I'm not, and how? And like I said again, Well, it's the reason why you want to act always in the capacity of a man, because you know, say, look, I know when I break the law as a man, I cause harm, injury, damage, or some sort of a loss. Now, when I operate as a driver of a motorized vehicle, I do not know the law, because your law is over 83 feet 6 inches thick. I don't know the law. So I wish to rather 99.99% of my life to just be a man traveling from point A to point B in any manner I wish, in a rocket sled, in a wave back machine, in a teleportation apparatus. You know, I want to just operate as a man, because it's easy for me to abide by the law of man. It's not easy for me to abide by your silly codes, because they're 10,000 feet thick. And like I said, one of the easiest ways to get out of any kind of traffic thing is like, wait a second, under 16.1-183, it says, I shall drive under 55, or I shall have a license, or I shall have a registration. Doesn't that mean sometime in the future I shall drive under 55? But the
interesting about Yep. That word shall, when you were talking about it earlier, I looked it up in an old Webster's, and it said the preterite is should, which gives another insight that it implies.
Implied.
Right.
It's not expressed. It's not good law. If that's what I say to people all the time. You guys got to really study the word expressed and implied. Are you implying, or is it expressed? If it's expressed, is my name in that statute? Do you have a photo of me in that statute? Like, see bad drivers, fast drivers, speeding drivers, see my photo being there? Like, there's no doubt about it. You know, expressed means it's absolutely, there's no doubt about it. You're talking about Karl Lentz. Are you saying, or it's implied that a driver, okay, at times I am a driver, guess what? 24 hours a day, 7 days a week, I'm a man. 13 minutes a day, I'm a driver. So am I a driver, or am I a man? And I think I'm a man. Awesome. I think I'd caution on the side of error, and I'd go in front of the jury and say, I think beyond a shadow of a doubt, right now you're looking at a man, not a driver. Would you say I'm a driver, or would you say I'm a man? No, you're definitely a man. But you could be a driver. That's right, I could be, but I'm always a man. That's right. So I'm standing here as a man. I'm not standing as a driver. Yeah, see, I just love playing with their words.
And do you think it seems to me it would be premature if I filed a claim at this point, because I don't feel like I've been harmed yet. But would it be legitimate for me to file a claim based on
no, like I said, you just bounce their own words off their own heads, and they'll say he's a player.
I had a case that I was going through, and it got to a point where, basically, long story short, I ended up taking a plea deal right before going to trial, and I was supposed to go do 30 days in jail. I didn't do that. What I did is do a notice to the people of the state of California and any interested parties, and basically I used your format. I said at one point in time, you know, I, a man, believe that I had somehow done wrong. I had become more aware as I realized that the plaintiff never appeared in this case, and no man testified in open court under oath or affirmation that I injured, harmed another man. There's no record of this case in existence. It's also in the file. No man ever spoken into an open forum. And then I said, furthermore, do you believe I am you? And Zhang, who sometimes acts as a deputy clerk, believes I am you because they issued warrants. So I said, if any man wants to come forward in order me to live up to any agreements, I'm happy to entertain any and all claims. It is my wish that any order or warrant against my person be discharged, dismissed, and or cleared, and that any probation be revoked / terminated at this time of awareness. I require a prompt reply, as I believe you wish to move your claim against my person in an open court. Any man who executes an unlawful order and burdens me with that order will be held liable. See attached fee schedule. Then I verified it and signed it. Sent that in. Now,
okay, the first five lines are okay. Get rid of the next two, and the next 7 were fine.
Okay, what part wasn't good?
Where you started to play with the you crap.
Okay.
Other than that, that was fine, because that's a separate train of thought. You're running a good line, and then all of a sudden you went off rails a little bit. Then you came back on the rails. You went off a little bit.
Okay.
But other than that, it was fine. You 5, 2, 7. You did fine. I mean, it's a little wordy, but it's fine, man. You got it, man. It's like, are you sure you're from Southern California? Because almost everybody's from Southern California, like total potheads, man. You were concise. So it was pretty damn good.
Well, thank you. I mean, I've been studying and learning for a little bit now and trying to implement and see what's been working. Now, what I can say about this is because I had police contact about 2 weeks ago out here in L.A., I was pulled over in my car. I had transferred the title out of my name into a friend's name, basically, and that had been about 3-4 months ago. For whatever reason, the DMV hasn't done that, and they ran the VIN number on the car, started asking me about this, the person, blah, blah, blah. I just remained silent, and they basically ended up looking up my name, and they said, you fit this description. And again, I just remained silent. And they found that these multiple warrants in these different counties in California, do not cite and release, mandatory appearance required, and they cite released me. They did tow my car, however, and I'm in the process of trying to get that back right now, but they didn't arrest me, the man, for these warrants. So I feel like something was going on there. I have a girl I grew up with who is a police officer now, and I called her and asked her, is there any notes in there or anything? Because I don't know why this is happening. She thinks it's just because it was non-extraditable warrant.
Okay, it might have been because what it was a misdemeanor, not felonies?
This is all misdemeanor stuff, yeah.
Yeah, like I said, that's what they would say. It was basically non-extraditable. See, because when I got busted for moonshine, it was considered a federal felony. So they said that anywhere within the state of North Carolina, I could be brought back in because it was originally classified as a felony. It was a misdemeanor, which the judge reduced it to. He says, any place you travel in the United States, you'll not be extradited for misdemeanor. But in North Carolina, you could be. But felonies, you will be. You know what I'm saying? You definitely will be. So if this is all misdemeanor, they just say, it's not extraditable. So that makes sense.
Okay, now what about...
she's probably telling you the truth, yeah. I'm sure she's telling you straight up, yeah, if it's a misdemeanor, they're not going to waste their time. You know how much cost it waste, the transport from point A to point B?
Yeah, no, I think you're right, too. My only question is now is, what do I do about this? The car's getting taken all the time, and, what if they do end up, taking me eventually? I mean, I have this itemized statement, and I have this letter that I just read you that I've sent in via mail, and it's into the court record now. So I mean, they have this itemized statement, and they haven't responded to my letter. So, your thoughts?
So what you could do is that you say that you want them to expunge the record. Are you telling them that you want them to expunge the record because the record was made in error? Is that what you're asking them to do, to clear the record, to get rid of it, to make it go away?
Well, what another thing I've done too, I was going to ask you about, is I've resigned as the agent for the agency. That's another thing you probably are. Some of you don't agree with. I know.
I don't play that. I don't play that. Yeah. I don't play that game. Yeah. Before you say that, who's the one who promotes that?
That guy Ken W.
I don't know who he is. Sorry about that. But yeah, I've heard of that kind of nonsense, but I don't play that nonsense. I'm just a man. All I know is I'm a man. Is there another man who's made a claim I've done wrong? That's all I want to know. Anything else, I don't even acknowledge exists. Because, like I said, anything else that exists is still 24 hours, 7 days a week, a man. And I'm going to hold him liable if he moves a claim and anything other than the fact that he could prove by firsthand knowledge and he witnessed me doing him wrong. Other than that, so I don't care what badge he's wearing. I don't care what color he's under.
So what if they just start arresting us and they're taking us to jail? Because going to court is fine.
This ain't Germany. This ain't Germany yet. You mean if they start arresting you?
Yeah, exactly.
Okay, not us.
well, people that are doing these sort of things that end up having warrants out, that are dealing with the name and the birth certificate and all this jazz that we know is surrounding this.
Yeah, they do grab all you people who do that crazy stuff. And like I said, they don't go after people like me because I make them laugh their behinds off. They think it's really funny what I write. See, because like I said, that's all you have to do is just make them laugh. They say, you get the trick. You see the sleight of hand. You see the misdirection. You see the 10, 20 little simple words we use to control and manipulate you people, and you're throwing it right back at us. And so you like one of us. You see the joke. You get the joke. See, but when you put all this patriot nonsense in there, they go, "Oh man, here we go. This guy's a."
Well, I don't play that. I don't ever pull that kind of stuff. I'm just trying to see what's been working. I'm just throwing everything against the wall. You
did fine, right? Like I said, you did fine up until you started playing that U game. And I mean, I do the U game, but in a separate manner. I don't put it in the same context that the way that you did it. You know, you've mixed like two different things, and you know, you put like you're making cookies, and you put cement in it. And it's like, no, you're doing good, man. You're making a nice batch of cookies. Then why'd you throw a little cement in it? That doesn't make any sense. You don't want to do that. When you pull the U game, you do that in a separate letter. You do that in a separate notice. Like you see, like I said, when people said my case was dismissed in Alabama, and I said, oh, you think it's dismissed? What do you think that means? You think it's over? Yeah, good. You want me to see you put me about another 10, 20, 30 documents into that case? It's my case. I'll let you know when it's over. It's dismissed. Fine. They dismiss it. You can't dismiss my case. It's my case. I'll keep doing. But what I'm trying to say is you give them notice of this, and then you give them notice of that. If you want to say that you were interpreting me as a you were believing I was a person and a man. But at all times, I just stood in the capacity in court as a man, not as a person, which would make you a you. You'd make it the man and the person. And a man is a person who owes a duty and an obligation to a society in which he's held a title or has been ascribed a certain role. Now, you're a man, and you could be a person, but at all times you're a man. You know what a person means, correct?
Yes, correct. That's a legal fiction.
No. A person is a man who holds an obligation or duty to a society in which he ascribed. So if you're saying that I will be a licensed driver, you write your name on a document, you are now a person within that society, within that driving license authority or agency. You bound yourself into the second dimension. You are now a person, but a person is a man. Okay?
Okay, so my problem though is like they'll pull me over. I've tried to discharge the license. I don't have the license, but they're identifying me with this person, so they're taking my property.
Right, they're identifying you as the person on that driver's license. So when they do that, they're just going to do it. You just know it. It's just going to be a natural instinct for them to say, you're the person, this is the car, we're taking the car. You're just going to make the claim for your property, the restoration of your property.
So how do I do it?
Just say you have my property, and I claim a vested interest in that car. Like I said to a cop one time on the witness stand, that white Camaro you pulled over, did you help me build that car? No. Did you put any money into that car? No. Did you loan me that car? No. Do you have any vested interest in that car? He's like, no. So do you think you could tell me what color I could paint it? No. Do you think you could tell me what kind of engine I could put in it? No. Do you think you could tell me how fast I could drive it? No. There you go. Is there anybody who's going to come to this courtroom today that could tell me how fast I can or cannot drive my property, my car? Is there anybody who's going to come to this courtroom today that could tell me how fast I can or cannot drive?
So if they hand you this notice of stored vehicle, then the one to go to address it would be the tow yard, or would it be?
It'd be the man who thought that he had the cojones to touch my property.
Yeah, so that's
who's the man who called up that tow? Who's the man who calls the tow truck to touch my car? Like if some man calls up a tow truck company right now and hooks up one of my cars from my property and drives it off, what do you think? I'm going to sue the tow truck driver? No, I'm going to sue the guy who called up the tow truck driver to touch my property.
So that would be the officer then.
I don't know who touched it. If you're saying there was a man named Joe Officer, yes, sue Joe Officer. That's a funny name. You mean Bob? You mean a man named Bob, who for 8 hours one day decided to be an officer? You're suing the man. You're suing.
I don't have. Yeah, but there's no name on here. You're suing the tow company and that it was impounded. That's it.
Okay, and who called up the tow company?
I don't know. How am I supposed to?
Why don't you call the tow company? Say, hey, who called you? Who told you to come and take my car?
And they're going to say,
what do you think they're going to tell you? We have no effing idea? Or do you think they're going to give you kind of an idea who told you to come and do it?
They're going to say LAPD.
Good. So you're going to sue Mr. or Mrs. LAPD. An idea who told you to come do it. They're going to say LAPD. Good. So you're going to sue Mr. or Mrs.
I thought it had to be a man.
That's right. because they're telling you LAPD. You're presuming LAPD is not a man or a woman. See, you would say that somebody like me, like Carl, you're being silly. No, because you said that the tow truck company said LAPD called them. LAPD needs vocal cords to operate a telephone, needs fingers to push the dial, okay? So what's going to happen is when you sue LAPD, okay, when you put it LAPD, say, hey, where's the LAPD attorney for the LAPD? The LAPD say, LAPD did not call. You say, oh, LAPD did not call? Then who called? You see what I'm saying? You're going to have to try to find the man or the woman who actually did the phone call. If they just
usually
said
the person
LAPD
that made the citation, did you get a ticket?
Yeah, I got a ticket.
Okay, at the time you got the ticket, that officer who wrote that ticket is most likely the one that called the tow truck. So you got his name right there.
Right. Oh, like I said,
I have his badge number and his last name. I mean, officer.
Okay. Again, what I'm trying to say, sir, if you got any kind of a name, again, you're just presuming it's a first name, it's a last name. I'm telling you, it doesn't matter. You just sue. If the tow truck company says LAPD called, okay, you're just going to make a suit and say, okay, LAPD. You're going to call up LAPD. You're going to look in the phone book and say, oh, there's LAPD. Hey, LAPD, you got a legal department. Yeah, I got a legal department. Okay. And then you send a notice to the legal department for LAPD. You say, LAPD made a phone call to Tom's tow truck company. He towed my car. Tom's tow truck company called my car. I want LAPD to compensate me for towing my car. You know LAPD is going to have a legal department.
Yeah.
Let them worry about who called up Tom's towing. Why should you worry?
Okay. All right. Well, that's something I haven't tried yet, so
that's what
I'll definitely do that.
Right. I
haven't tried to get all of these legal departments yet, so that's something I haven't.
Yeah. You know, and I know every single cop. You know, and I know every single government agency, a government entity has a legal department. You say, okay, LA was the Los Angeles Police Department legal department, just like I did. Like, say I had a problem with my internet today. I said, where's your legal department? And they said, it's in Germantown, Maryland. I said, oh, great, lovely. I said, you got their phone number? They said, yeah, and they gave me their phone number for the legal department. What do you think, I want to talk to a customer service kid? I'm not going to waste my time talking to a customer service kid. I want to talk to the legal department. Why would you want to talk to anybody in LAPD other than the legal department? You know they have a legal department. You know they're the ones that are going to answer any claim. You know if Officer Bob...
That's a good point. That's something that we don't really talk about. I like that.
If you sue Officer Bob, he's going to automatically turn it right over to his legal department. He said, the legal department, what do I do with this? And the legal department will advise him, right? Yeah, that's why they got risk management, and that's why risk management sets up legal defenses and pays cops and government agencies and government agents their legal fees.
Okay, I got you. Okay,
yeah.
Okay.
Just go right to the legal department. Oh, you're right. So like I said, that's the safe. If you don't know the officer's name, it's like, look, I don't know the officer's name, but LAPD, yeah, great. You know what? LAPD's got a fucking legal department. I'm going to send it right over to the legal department. I'm not even going to waste my time. And they'll decipher. They'll figure out who touched that man's car.
Okay, cool.
Yeah, because we got a hell of a funny guy in Mark in Atlanta. He finally sent off the letter. It took him a long time. He got pot taken from him, from a cop, a man who was wearing a, uniform as a cop out of his car. So Mark finally put the letter to the chief of police down there in the Atlanta area where he lives, to the cop, whatever the cop's name is, Ivan or something like it's a Polish name or something like that, and to the legal department that he wants his property. He wants the immediate restoration of his property. So it's funny because this is a great case because the most he could get for the crime of having that much pot was like $50 fine and 1 hour in jail. So what a hell of a case to make the claim for getting your pot back, because he's not looking at 20 years in jail. He's not looking at a $20,000 fine if he claims that's his pot. The most he could get if he claims it's his pot is like a $50 fine and 1 hour in jail.
Yeah.
If he claims as it. So what a case, because if he gets his property restored, the restoration of his property, one little joint, if he gets his one little joint back, what's the difference of them not giving him back 1 joint or 1 kilo or 1 megaton of pot? Like 1 piece of pot is the same as 1 million pieces of pot. So if he could win his case and show that 1 joint has to be turned back over because that's his property, billions of joints got to be turned back if a man makes a claim for billions of joints to be turned back to him. And he could use Mark's case. He's like, what's the difference? One joint, 2 joints, 100 joints? It's that man's property. Why'd you give the man back that 1 joint? Well, it was his property. We had to give it back. There you go. I said, yeah, Mark, get your joint back in pot, man, and fucking fire it up in open court.
That's awesome. I love that. So, just real quick, Karl, so when do you pull the U game then? Because you were saying I didn't do it correctly in the paperwork. I didn't execute it the right way. When do you use that correctly?
Like I said, the U game is the only time I use U game is when they're originally sending me some documents that say, I see that in this letter that you sent to me, IRS, you refer to me as you. Do you mean thee, thou, or thy? Do you mean me in a singular sense or me in a plural? Do you believe that there's jointed between I, a man, and I and my person? And do you believe I'm bound by some sort of contract or rules or terms of obligations in which I subscribed? You see what I'm saying? In that kind of a context, when someone's saying that I believe you owe me money, who, me and my person, or just me, the man? Who do you believe owes the money? The man who's going to testify in open court, or the person? Which one do you believe owes you the debt? Who's going to testify in open court, or the person?
Okay.
Which one do you believe owes you the debt?
And that's what you asked too. Do you believe I owe a debt? Do you believe it is true? And do you believe it is due or posted?
Well, the reason why I asked the you to them is I'm getting joined between them as a man and them in their official capacity under color of law, because you can't sue them under color of law. You can't sue the prosecuting attorney. You can't sue a judge. You can't sue a court clerk. But you can sue Susie, who acts as a court clerk. You can sue Bob, who acts as a judge. You can sue Joe, who acts as a cop. But you can't sue cop, Joe, judge, or clerk. But when you say, do you believe I owe a debt? So when I was saying that to the state prosecutor, do you believe I owe a debt? Is state prosecutor Bob and the state prosecutor uniform that you're wearing, the costume that you're wearing at this time, not only does the state prosecutor believe it, but Bob, do you also believe it as well? So Bob's going to have to take the witness stand. That's why the judge laughed. Because Bob's going to have to come out of that costume and take the stand and perform.
Okay, so let me give you an example. Here's a scenario. So let's say I'm in this county, even though they're just misdemeanor warrants. I get pulled over for whatever reason. They identify me with this person. They take me in on the warrants, and then I go before the judge. That would be the time to pull the U game then, most likely, right?
No, because like I said, the big thing is you want to find out who issued the warrants. Because
that kind of stuff is hard to find out. They just put like initials, like M. Zhang, you know. So you have like kind of a last name, you kind of an initial for a first name, but you know, it's hard to pinpoint.
The magistrate. Okay, somebody had to issue the warrant, right? And then the magistrate just stamps it to be executed, and then the sheriff's department issues it to hands it off to the deputies to go carry out the warrant. So
I'm looking at one of them right now.
But the magistrate there should be some sort of like a seal from the magistrate.
There's a seal from the Superior Court of California from the county.
Okay, but who was then I guess like I said, because when that lady got arrested the other day, she thinks she's on Angela's call right now. I don't know if she's still on it or not. Let me see if she's on there, Lady Fairfax. If she's on there still, and she'll tell you exactly what happened when I told her to go down there and find who issued the warrant. She hung up. Yeah, she was just on the computer. But I told her to go down there and find out who issued the warrant on her. And she said the officer issued the warrant, and the magistrate granted him the warrant to have it go executed. So then the officer who was investigating the domestic violence he issued the warrant, and he wished for the magistrate to have it delivered upon the sheriff's department, so the sheriff's department could go out there and execute the warrant. So obviously, she was like, well, who issued this warrant? The magistrate? I'm going to go sue the magistrate for issuing this warrant. It's like, no, the magistrate didn't issue the warrant. The magistrate just granted the issuer the warrant to be recognized as true. And then she's just going to pass it off to the sheriff's department, like 8 o'clock in the morning. The deputies all line up at the courthouse to get warrants that they have to go issue that day, that the warrants have to go execute that day. Sorry for that. Execute, it's different. So you can't hold the deputy liable who's just executing the warrant. You don't hold the magistrate liable for stamping the warrant. You hold the issuer of the warrant liable. Like I said, I could issue a warrant for your arrest to have you be brought into a court on the 22nd day after you failed to answer my civil claim against you. You have one more chance, because I don't want a default judgment, and I certainly don't want a summary judgment against you. I want a judgment that reads that you had the opportunity to answer, you were there, you were competent, you had the ability to say something, and you chose to stand mute, and you had the chance to defend yourself, put up your dukes and fight, and you chose not to, and I'm going to win. Because if you get a default judgment or a judgment, a summary judgment, they could always be overturned. They could always be considered void judgments because nobody ever spoke in open court. No, I didn't press the record, and you didn't come to court to explain why you didn't appear. You could have been in a coma. You could have been on the other side of the world. You could have been marooned on a desert island. There's many reasons why you didn't appear in court that day. So if I could issue a warrant for you to be dragged into court, I'm going to issue the warrant for you to be dragged into court. Now,
well, this is even better, Carl, because this is better because they're saying that, no, you were supposed to go do jail time. You're supposed to go sit in jail for 30 days. That's what the court is trying to say. So that's what the violation is. Oh, you didn't comply with the court order.
That's because you believed you did wrong and you confessed. You convicted yourself, right?
Basically.
Okay, a conviction. Okay. When you believe in Jesus is going to come back, you have a conviction, right?
Okay.
You have a belief. See, a conviction means you have a belief. So whenever you hear people whenever you hear judges or lawyers making jokes, they say 99% of the people in jail convicted themselves.
Yeah,
that's right. They had a belief that they'd done wrong. They didn't know how to say, wait a second, where's the man that I've done wrong? They believed that some violation of a code was wrong. No, it's an infraction of a code. It's not a wrong. A wrong is wanton, deliberate intent to hurt or harm or injure another man. Smoking pot in your car on the side of the road is not wrong. You believe it's wrong because when you see a cop, you put the joint out, you roll the windows down, you try to get it all the air out, because you think you're doing something wrong.
Mm-hmm.
Right. So by your actions, you're showing that you believe you've done something wrong. Because the whole world or the whole society has been led to believe that smoking a joint is wrong. To me, I say, how is it wrong? If you're causing anybody injury, harm, or loss, then it's wrong. But why don't you people just parade right down Main Street smoking? What the hell is you people's problem? Why are you people hiding it? And it's like, oh, here comes a cop, put that out, put that out.
It's such a gigantic paradigm shift to make the leap from citizen, entity, whatever person to the man.
Yeah.
A lot of people.
Yeah.
And it's amazing, isn't it? I find it really interesting that we're so enveloped in the program that they've programmed us with. It takes a long time to get to that point where you step out of that.
The higher your grade point averages was in school, the more A pluses and gold stars you got, the harder it's going to be to understand what I'm doing. because they indoctrinated you guys. I have so much easier time dealing with, like, say, a housewife that really didn't give a damn about school, or a guy who left school when he was in second or third grade, than I have with people who actually have a high school or college education. It's almost impossible for me to get through to these people because they are so absorbed. They are right. You can't show them the simplicity and the beauty of such simplicity. Like, do you not see me, Tarzan, you, Jane do wrong, Jane no do wrong to Tarzan. So Jane give back to Tarzan. That's it. And the church is like, holy crap, this guy figured it out. How did he figure it out? Well, he made a claim. He's not complaining. He stated the facts. Jane did wrong. Jane give back. It's simple. And you guys are like, oh, Hale versus Hinkle law. The United States Constitution, there's a third article of Confederation, and the Pilgrims have this a charter, the Compact Act. I said, oh, geez, you guys got to stop. This is all just misdirection and confusion. This is not acting like a man saying, I make a claim, somebody done me wrong, I want compensation, I owe what, this is what's due to me. Or somebody saying, who's making a claim that I owe them, who's making a claim that I owe what they claim is due? Where is it? Where is this man? Where is this woman? I'm not dropping down to your level. You're going to come up to my level. I'm in the image of God. You're going to come and talk as a man. I'm not going to talk to my servants. You're a public servant. I'm the public. I'm not going to drop down and talk to you. You just do your effing job and leave me alone.
Yay. They've been... Go ahead, I'm sorry.
No, go ahead, Angela. Go ahead. Say what you going to say.
No, it's all right. Go ahead.
No, go ahead. Because I was going to say you got like 53 seconds and we hit the 2-hour mark. Yay.
Why are you tired? Do you want to get off the phone?
No, you can just ask me whatever the question was you want to ask me.
Well, I was going to ask you, I think I mentioned it to you briefly on the phone about my friend who, he's on a fixed income, and now they've reassessed him because this living situation changed, and so they're deducting $200 a month from his Social Security, or maybe it's his supplemental security income. Mm-hmm. And he had a right to appeal that decision and ask for a reassessment, which he filled out the paperwork and sent it in. And that was 3 months ago, and they're supposed to get back to him, I think, within 19 days. But they haven't. They've just ignored him. And there's an article online about how terrible the Social Security. They're not giving people their right to due process. In other words, they're asking for. Go ahead.
You know why? Because people are sitting around like him and complaining, right? If he's sitting around with other people and making claims in his local mom and pop district court, just saying
he's kind of a disabled person.
Okay, is there a reason why he can't just make 2 or 3 simple sentences like? They have a duty and an obligation in which they ascribe to this lady named Susie. Susie has been in dereliction of duty in which she's failing to perform a service or function in which society is paying her, to perform. Why can't he just make simple claim like that and saying she's refusing to do her job?
Well, he can't.
And by her failure to perform in a duty in which she's acquiring, public funds to do her job, is causing him harm. It's causing him a financial loss. Why can't he just, there you go, it's at the 2-minute mark, 2-hour mark, yay, just download whatever I just said, and there you go, there's your perfect claim.
Hey, wait, I want to ask you.
Claim. And when she gets dragged before the court, she's going to say why she believes that she can collect a salary, she could collect an income, she could collect money from the public and not perform a job in which she said that she would perform.
Well, they usually do the appeals. Someone else does the appeal that's not familiar with the case.
I didn't say appeal. I didn't say appeal within their system. I said take you to your local mom and pop county court. Mm-hmm. Like you guys would call small claims, but my one penny claim is a huge claim. I don't define my claim. They might say my claim is, it's so tiny, it's so insignificant. We're going to call it small. No, my claim is a claim. It means the world to me. If it was worth me getting off my behind and going down to the courthouse and filing something, that is tremendous effort. That took me a lot. That took me 50 years to know what I'm doing. That's a huge claim. That claim is amazing for me to be able to put pen to paper. It took me 12 years of school. I had to learn how to drive, get insurance for my car. That's a massive claim. So don't anybody fucking diminish my claim by saying, oh, it's only a penny. Look, it's a penny to you. It might mean the world to me. Don't you tell me how much this penny is worth. What happened if the Dalai Lama swallowed it, he pooped it out, I went up to the Himalayas, and I got it. You know, that penny could be worth $1 million. Don't tell me how much my penny's worth. All I'm saying is I'm making a claim. It's mine, and back off. And so he's saying that this is what he's due as compensation, and some lady has the capacity to make it happen, and for some reason she's derelicting her duty, and for some reason she doesn't feel like performing that function in which society is paying her to do her job, to make the claim against her, and let her answer in court. Say, I don't have to give you due process, sir. I don't have to process your claim because I don't feel like it, because I'm the United States, Social Security, I'm the United States citizen, I'm the United States, and I can go tell you, go F yourself, and what are you going to do about it? Let her say that in open court in front of a trial by jury. Let her say it. Let her give the reason why this man has been being done wrong.
What if he doesn't have the name of the person?
Oh, he doesn't know who's supposed to. Okay, then he's just slack and lazy.
No, he just. I'm just saying, what if? What if somebody can't dial a phone? What happens if he doesn't know who's the one that did it? It's just a computer deal or something. You've got 1 million people sitting in a room.
He doesn't know he can't call up and say who's been assigned my case. He can't do that, and they'll say nobody. It's like,
okay, no. What if he has done that several times and they never get back to him?
Okay, he says who's been assigned my case. So he wrote them a letter, and he says, yeah, my name is Bob Johnson, and
when he calls the number, he doesn't get he has to leave a message.
What the hell is wrong with you people that for some reason you forgot how to pick up a pen and paper and use ink? When I say to everybody all the time, the only way to properly answer the court is in writing. Have I ever said to you people, use your tongue that God gave you? No. Did I ever say flap your tongue? No. Did I ever say pick up the phone and make a call? No. You guys can listen over 100 shows that I've done, and I've always said paper and pen, paper and pen, paper and pen. Is there some reason why he can't put it in paper and pen and write to them?
He has. He sent them
And then what did he do? He sent them a letter, correct?
Yeah.
Okay, and then after he sent them the letter, he gave them what, 3 days, 10 days, 20 days to answer the letter?
Yeah.
Okay, and then he went out and got a process server, okay? And the process server made delivery of the letter?
No. I don't think he went that far. He didn't go that far.
Oh, because the benefits aren't worth it? It's not worth making the claim?
I guess
why don't you just get a process? Why do you because he's too young. He's a young kid and he doesn't know how to operate within the public?
No. He's an older gentleman. He can't get around that easily. He can't get back and forth. He's like in a locker situation.
Ma'am, I had a process server deliver upon the court and the people I was suing in Alabama. I had them sue over a telephone.
Oh, yeah?
What did that have to do with me going down to Alabama to call up a process server? It's like processserversareus.com. It's like they're all over the United States.
I didn't know you can have someone served over the phone.
You call up a process server, and the processserver.com company will give you like 4 or 5, 20 people, 100 people in your neighborhood. They'll be more than glad that for $50 to go serve your letter on a party that's not answering. Because as soon as they're not answering, the process server says, hey, look, I handed that person that letter. And he's going to write a statement to you and say that I made a delivery to this man or this woman on this day at this time. So that now you got proof that this person is deliberately ignoring you. That this person has been assigned this job to answer, and they're not doing their job. So now that's just proof when you go into court. It's like, look, I did